शुक्रवार fresh matter.
Your Lordship, one matter for the end of the list. I am a director of the primary society, Your Lordship, Milk Producers Society. I am also a director of the secondary on delegation, Your Lordship. I have been disqualified yesterday, Your Lordship, without giving any opportunity, without raising the dispute, unnecessarily for 2008-19 allegations. I have been disqualified, Your Lordship. I have not been given permission to file objections. I have not given, even the dispute has not at all raised, Your Lordship. Only based on the complaint, Your Lordship. Therefore, Your Lordship, tomorrow there is a board meeting of the secondary society, Your Lordship.
Tomorrow.
The proceedings initiated by the respondent under section 29C of the Karnataka Cooperative Societies Act for disqualification and for appointment of administrator. Now, there is no positive direction to comply. Without there being a positive direction, question of compliance does not arise. Whereas the respondent, third respondent has been dismissed from service or misappropriation of funds after conducting inquiry and he found guilty and he has been dismissed. He moved the assistant deputy registrar of cooperative societies under 29C, subclass 8 for disqualification of director because there is an interim order of stay. Before granting interim order of stay, the dismissal order has been passed. Hence, question considering the stay order or reinstating him does not arise. He made a letter to the bank stating that order has been stayed, I have to be reinstated.
You are challenging the notice.
Notice and the proceedings before the assistant registrar. Because it is not revision, it does not revise.
How can you challenge a notice?
But there is no appeal, there is no revision. This is prima facie, this is a, without there being an order for compliance, question of disqualification does not arise. The order may kindly be looked into, my lord. interim order may kind be looked into.
ಏನ್ entry ಮಾಡೋದು?
Interim stay of the dismissal order.
Sir, what has that got to do with issuance of a notice under section 29C?
29C does not attract Malal Baruda illa avarige now unnecessary without jurisdiction, the 29C proceeding has been initiated. ಅಲ್ಲಿ ಇದೇನಾಗ್ತದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಯಾರಾದ್ರೂ lordship may kindly look into the order passed by the honorable
Learned AGA, fix notice for response number 1 and 2. Issue notice to response number 3 to 16.
no, they are only up to respondent number. They are the directors, no notice may be dispensed with. That's not one.
Party ಮಾಡ್ಬೇಕು ಮಾಯ್ತಾ?
Mela.
Why have you made them parties then?
Because in the proceeding, they are the party, there is official raise objection, they are only formal parties. They are up to 1, 2, 3.
You will have to file a memo.
Please dispense, I'll made it, already made here, but anyway, I'll file a memo.
Issue notice to respond number 3. Learned counsel for petitioner has filed a memo dated 12/6/2024. Seeking dispensation of notice to response number 4 to 16.
Please, ma'am.
So learned counsel submits that the dispute was raised by respondent number 3. And respondent number 3 is the contesting party.
Please, ma'am.
The rest of the respondents are all directors of the first petitioner
Bank.
Cooperative Bank, and they are formal parties and no relief is sought against them. We'll stop. Next para, at the risk of the petitioners, notice to response number 4 to 16 is dispensed with.
Please.
Release this matter
My lord, here, one thing, my lord.
on 19th of June. Yes,
19th of,
June,
well, 19th, before the tribunal, there is a 19th, the same matter.
yes,
Well, here, the interim,
20th of June.
18th already.
It's 18th.
Please.
Yes.
My lords, appearing on behalf of the plaintiff. The thing is, the plaintiffs are seeking mandamus,
Plaintiffs are.
petitioners, man.
Ah.
The petitioners are seeking mandamus directing the BBMP to implement the order dated 15/11/2023 under issued under section 248(3) of BBMP Act 2020. My lords, respondent number 5 and
Again, the 5th respondent.
yes, against 6th respondent and 5th respondent. 6th respondent is an educational institute
Ah.
and 5th respondent is a private party who runs the 6th respondent. My lord.
Implementation of which order?
Annexure J, my lord. Order passed by BBMP 248 under section 248(3). They have constructed illegally without obtaining requisite plans and all the necessities required by BBMP.
A. Pawan Kumar.
My lords, in this matter, I am appearing for respondent BBMP, my lords.
Learned counsel, Srimati Sumangala
Gachin matter. Yes, my lords.
undertakes to appear for response number
1 to 4.
1 to 4, my
1
lords.
to 3.
1 to 3, my lords. 1, 2, and 3, my lords.
Deputy Commissioner, Deputy Inspector General of Police, BBMP.
Yes,
ಅವ್ರನ್ನೇನು ಪಾರ್ಟಿ ಮಾಡಿದೀರಾ?
my lords, formal party and all.
ಏನ್ ಫಾರ್ಮಲ್ ಪಾರ್ಟಿ?
Because
How is they concerned with this? They are concerned only with public property. Issue notice to response number 5 and 6. At the oral request of learned counsel for petitioners, respondent number 4 is permitted to be deleted. You please carry out the amendment.
please, my lord.
Learned counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned counsel for the respondent BBM. Next para. since the petitioner is seeking implementation and execution of the order at Annexure J dated 15/11/2023 passed under section 248(3) of the BBMP Act number 2020, learned counsel for the respondent BBMP is directed to secure instructions and make submissions.
Obliged, my lords.
So, release this matter on 26th of June.
Obliged, my lords.
Obliged, my lord.
Mainly pass over 3 and 4.
Hmm?
Pass over minutes. 3 and pass.
Learned counsel Shri Pawan Kumar, who is present in the court, takes notice for both the respondents. Learned counsel for petitioners is directed to serve 2 sets of copies of the petition along with annexures and the learned counsel for the respondent BBMP. Please stop. Next paragraph. The learned counsel for the respondent BBMP is directed to secure instructions in respect of the impugned order
Make sure
at Annexure A dated 23/5/2024.
A1.
A and A1.
Smart.
Full stop. Release this matter
Stay.
on 19th of June.
Stay. Regarding stay.
Yen stay.
Stay of annexure.
You were asking for issuance of Khata.
Please.
Yen stay.
Notice is issued that
Notice. Sir, they have given an endorsement that it is
Please.
not possible to register the Khata. What interim order can be granted? Yes. 3 and 4 same order.
a similar set of facts, my lord, sir.
Ade,
Second matter,
same order.
please.
Yes.
Petitioner has challenged the order passed by the Karnataka Appellate Tribunal, not the plan was sanctioned in 2017. We have constructed the building, but the 2021, during the COVID period, they appears to have visited the building and passed some order and kept it there. In 2021, my lord, they sent a letter to one of the tenants. Tenants informed us, we requested them to issue the certified copy of the orders. Without inspecting the place and also conducting the survey, they have passed the order. That we have challenged before the Karnataka Appellate Tribunal. The Appellate Tribunal is looking into the photograph, has come to the conclusion, basement, you have portion of the basement and the ground floor portion, you have converted into a commercial complex. Therefore, it has to be demolished. That is the view taken by the KAT. But no opportunity has been given to us. But ultimately, suppose, if we have
Opportunity, sir.
Allah, now, suppose, we have converted into a commercial in the sense shop, some medical store and other things they have given. Ultimately, they have to ask us to remove it.
Yes.
Therefore, my respectful submission is let the authority inspect again, once again, and take the decision according to law. Provide opportunity to
But
us.
you have utilized the basement floor.
Basement, no, ground floor, my lord,
Let us see the order.
the ground floor and the basement.
Let's say kindly see the
Portion
page
of the
number-
ground floor and basement.
Let's say kindly see the page number 58.
Last may kindly come to, that is one nimisha, sir. ನಾನು ಹೇಳ್ತೇನೆ, ಆಮೇಲೆ ಹೇಳ್ತೇನೆ.
Page number 58.
Last may kindly come to page number 50, 59, 57,
Yes,
58, you last may can see it.
yes.
When last pair, ಅದು ಬಲಭಾಗ ಎಡಭಾಗ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. Inspection ಗೆ they have not issued any notice to us. Because that time during the COVID time, they have dissolved, it was not, nobody was in occupation. And they said they have inspected. So then this is the, please see this, the 12/2/2019, they have inspected, they say. Then when this notice, when you peruse the sanction plan, it is clearly stated that the sanction is for basement, ground floor and third upper, 3 upper floor for residential hostel. And used for commercial use in a port of the ground floor only. Basement floor and part of the ground floor where car parking shown area is reserved for parking purpose only and shall not convert for any other purpose.
Hmm.
Photos produced by the appellant show that the basement floor has been rented out for commercial purpose.
Yes.
Whereas in the sanction plan, they have clearly mentioned the basement floor is reserved for parking purpose only
Hmm.
and shall not be converted for any other purpose.
Hmm.
Consult for the
What have
respondent
you
to the
stated?
photographs, all
What
this.
is stated in your petition?
Pardon me,
You have constructed basement, ground plus 5 upper floors.
why are upper floors? Why upper floors? Here shows the appellant has constructed, what happened was, 2 floors are not the actual floors as such. It is a duplex they have constructed, all these things are there.
Sir, there
Let them
are
inf-
restrictions on height. You cannot do all this.
But
We cannot help you, sir.
but
If
no-
you have blatantly violated the sanction plan and
But
put
let-
up construction,
my
this is
request
how you are
is,
going to suffer.
only
cannot-
thing is, please, your lordship may kindly consider this.
No, no.
Not the setback area, they have not, whatever they have not, without informing us, they have taken this decision.
Sir, even now you are not saying anything in your writ petition as to whether you have put up 5 floors or not.
5 floor ಕೊಟ್ಟಿದ್ದಾರೆ.
And you are not, then
ಇದಾರೆ ಹೌದು, but
then naturally it has to
ಅಲ್ಲ,
be demolished.
only request is, your
ನೀವೇ demolish ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ, one request,
ನೀವೇ demolition ಮಾಡಂಗಿದ್ರೆ I will give some time.
ಅಲ್ಲ,
You go and demolish.
ಅಲ್ಲ, only
yourself.
one request ಹೇಳ್ತೀನಿ.
Yes.
ಈಗ ಸೆಟ್ ಬ್ಯಾಕ್ ಏರಿಯಾ ವೆರಿಫೈ ಮಾಡಿ, ಆಮೇಲೆ ಬೇಸ್ಮೆಂಟ್ ಯಾವ್ದಾವ್ದು ರೆಗ್ಯುಲರೈಸ್ ಮಾಡೋದು ಮಾಡಿ, ದೆನ್ ವಾಟ್ ಎವರ್ ರಿಕ್ವೈರ್ಡ್ ಮಾಡಿ.
Basement regularize ಮಾಡಕ್ ಬರೋದಿಲ್ಲ sir.
ಅಲ್ಲ, ಬೇಸ್ಮೆಂಟ್ ಅಲ್ಲ, ಫಸ್ಟ್ ಗ್ರೌಂಡ್ ಫ್ಲೋರ್.
You have to remove the shops that are put in
ಅಲ್ಲ,
the
ಬೇಸ್ಮೆಂಟ್
basement
ಕರೆಕ್ಟ್,
floor.
ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಮಾಡಿ, ವಿಲ್ ಸಿಂಪ್ಲಿ ಆಸ್ಕ್ ದೆಮ್ ಟು, have already discussed.
Actually, you do that and
Let
you
them-
come before the court and say this, we are
Let-
planning to do this, you give some
let-
time.
Let them not demolish, they have already appointed an officer to go and demolish the property.
They will do it.
ಮಾಡ್ಬೇಡಿ ದಯವಿಟ್ಟು, ಏನೋ ಮಾಡಿದ
That's
ಮಿಸ್ಟೇಕ್
why I said
ಮಾಡಿದ್ದಾರೆ.
you are not saying anything even in the petition.
ಅಲ್ಲಲ್ಲ, ಮಾಡಿದ ಹೇಳಿದ್ದಾರೆ ವಿದೌಟ್ ಅಪರ್ಚುನಿಟಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ petition ಅಲ್ಲಿ.
We will give you 15 days time. You want to do it yourself, you do it. We will list the matter after 15 days. ಬರ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ಒಂದು ರಿಕ್ವೆಸ್ಟ್, ಲೆಟ್ ದೆಮ್ let there be a fresh
Sir, ಏನು
visiting.
ಪ್ರಯೋಜನ ಇಲ್ಲ.
ಅಲ್ಲ, ಅದು ಏನೇನಿದೆ
Why
ರೆಗ್ಯುಲರೈಸ್.
why would they give some information which is not factually correct? ಅವ್ರಿಗೇನಿದೆ?
ಅಲ್ಲ, 2019 ನಲ್ಲಿ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಸಿ,
ಏನೇ ಇರ್ಬೋದು.
Nobody-
You are
no-
saying
ಅಲ್ಲ,
it was
notice
done in not in your presence.
ಹೌದು, ನಾವ್ ಇರ್ಲೇ ಇಲ್ಲ.
If it is in your presence, will it change?
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಮೆಜರ್ಮೆಂಟ್ ಎಲ್ಲ ತಪ್ಪು ಬರ್ದಿದ್ದಾರೆ. ಅವ್ರಿಗೆ ಹೇಗ್ ಬೇಕಂಗ್ ಬರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ. ಮೆಜರ್ಮೆಂಟ್, ಸೆಟ್ ಬ್ಯಾಕ್ ಏರಿಯಾ, ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್ ದೇ ಹ್ಯಾವ್ ಲೆಫ್ಟ್ ಇಟ್. 2017 18 ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿದ್ವಿ, 2021 ಅಲ್ಲಿ.
What you want?
ಅದಕ್ಕೆ ಲಾಶ್ಮಿ ಕೈಂಡ್ಲಿ ಫಾರ್ ದ ಟೈಮಿಂಗ್ ಲಾಶ್ಮಿ ಕೈಂಡ್ಲಿ ಸ್ಟೇಟ್
No, sir, no.
and let
no
them
question
inspect.
of state.
Lasmi kindly direct them
No
to go
question
and
of state.
have an inspection
Two
in our
floors-
presence.
2 additional floors has to be demolished without any question. What do you say about it?
ಅಲ್ಲ, construction
And basement portion, if you have rented it for shops, that has to be removed.
ಅದು ಮೆಡಿಕಲ್ ಸ್ಟೋರಿಗೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Yes, yes, it has to be removed.
ಅಲ್ಲ, ಮಾಡಿದ್ದ ನಾವು, ಐ ಆಮ್ ನಾಟ್ ಸೇಯಿಂಗ್ ದಟ್ ವಾಟ್ ದೇ ಹ್ಯಾವ್ ಡನ್ ಇಸ್ ಕರೆಕ್ಟ್ ಅಂತ
ಅದನ್ನ
ಹೇಳ್ತಾ
ಮಾಡಿ
ಇಲ್ಲ.
ಮಿಕ್ಕಿದ್ದು ಇದಕ್ಕೆ portion we will ask for a joint inspection and a fresh report regarding the setbacks.
ಒಂದು ರಿಕ್ವೆಸ್ಟ್,
Yes.
let them inspect it. In the meanwhile, Lasmi kindly
No,
fix that
no,
date. I will ask also my lord the party
Post
to.
days, sir, 15 days time will be given. You remove the offending
ಅಲ್ಲ, ಮೇಲ್ಗಡೆ
additional floors.
ಹಾಸ್ಟೆಲ್ ನಡೀತಾರೆ, ಮಕ್ಕಳು ಎಲ್ಲ ಸ್ಟೂಡೆಂಟ್ಸ್ ಇದ್ದಾರೆ.
Cannot be done.
We require some, I will, please, let them not demolish immediately. Lasmi kindly have it next week. We will find out.
Or you think a hostel without permission?
ತಗೊಂಡಿದ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಟ್ಯಾಕ್ಸ್ ಕಟ್ಟಿದೀವಿ, ಎಲ್ಲ ಮಾಡಿದೀವಿ.
Sanction plan was given for what?
ಹಾಸ್ಟೆಲ್ಗೆ
ತೋರ್ಸಿ.
ಕೊಡು, ಮತ್ತೆ ಹಾಕ್ಲಿಲ್ಲ ಹಾಸ್ಟೆಲ್ ನಿಂತಿದ್ಯಾ?
Where is the sanction plan?
My lordship did not produce that, my lordship.
And it is recorded that it's for residential purpose.
ಅಲ್ಲ, ಇದೆ ತಂದಿದ್ದೀಯ, ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಇದೆ, ಒಂದು ನಿಮಿಷ. ಇದೆ ರೆಸಿಡೆನ್ಸ್ ಹಾಸ್ಟೆಲ್ ಅಂತಿದೆ.
ಕೊಡಿ.
ಫಸ್ಟ್ ನಲ್ಲಿ ನೋಟ್ ಅಂತ First note. ಅದೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ, but only thing is in that extra construction is not, I am also not saying that it is a right hand side, first note ನಲ್ಲಿ first.
ಏನ್ ಮಾಡ್ತಾರೆ ಈಗ?
ಒಂದ್ ಸ್ವಲ್ಪ ಟೈಮ್ 10 days I'll also ask them to party.
I'll give you 15 days time.
ಅಲ್ಲ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತ ಶಿಫ್ಟ್ ಮಾಡೋದ ಏನು ವಿಚಾರ ಮಾಡ್ತೀವಿ ಲಾಸ್ಟ್ ಕಡ್ಲಿ.
ಇದನ್ನೆಲ್ಲ ಮಾಡಕ್ ಆಗಲ್ಲ ಸರ್.
ಒಂದು ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿ ವೆರಿಫೈ ಮಾಡಿ ಒಂದು ಇದು ಮಾಡಿ ನೀವೇ ಎಕ್ಸ್ಟ್ರಾ ಥಿಂಗ್ ಹ್ಯಾಸ್ ಟು ಬಿ ರಿಮೂವ್ಡ್. ಐ ಅಗ್ರಿ.
ಇದ್ರ ಬಗ್ಗೆ ಏನು ಇನ್ಸ್ಪೆಕ್ಷನ್ ಬೇಕಿಲ್ಲ. You admit that 2 additional force have been put up contrary to the plan, they have to go.
ಡೂಪ್ಲೆಕ್ಸ್ ಅಂತ ಏನೋ ನಮಗೆ ಕನ್ಸಲ್ಟ್ ಮಾಡಿದಾರೆ ಅಂತ, ಅದಕ್ಕೆ ದಟ್ ಇಸ್ ದ ರೀಸನ್ ವೈ
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. Height of the building also is shown in the plan.
Height 3 meter extra ಇದೆ.
ಮತ್ತೆ
2.5 meter 3 meters extra ಇದೆ. That I will ask them to how it has to be regularized and they will find out. And
ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಸರ್.
ಅಲ್ಲ ತೆಗೆದುಬಿಟ್ಟು ಬಾಕಿದ್ ಹೇಗೆ ಅಟ್ಲೀಸ್ಟ್ ನಾರ್ಮಿಗೆ ಹೇಗೆ ಮಾಡ್ಬೇಕು ಅಂತ ಒಂದು ವಿಚಾರ. ಅವರು they have already taken a decision.
Council Shri
Mattegowda
KV
my lordship.
KV Wakalat file ಮಾಡಿದೀರಾ?
Undertake to file my today.
Takes to appear for respondents number
1 to 3 my lordship.
1 to 3. Issue notice to respond number 4. Learned counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned counsel for the respondent BBMP. Full stop. Next para. Learned senior counsel Shri G. Krishnamurthy, appearing on behalf of the petitioner, submits that the information regarding the deviation in the setback area and regarding the construction of additional floors
and utilization
has been given by the respondents without conducting a joint inspection. Full stop. Moreover, it is submitted that the plan has been sanctioned for construction of
residential
hostel and utilization of the ground, a portion of the ground floor for commercial purpose. Full stop. Learned senior counsel submits that the entire building on the upper floors are utilized for the purpose of hostel and many students are residing in the building. Full stop. Learned senior counsel therefore submits that a direction may be given for a joint inspection and a report regarding the measurement of the buildings of the building. Full stop. Next para. For contra, learned counsel for the respondent BBMP submits that it is clear from the impugned order itself that the petitioner was given a sanction and building license to put up basement plus ground floor plus 3 upper floors, while he has put up 5 upper floors. Full stop. As regards the basement floor, it is submitted that the basement floor can be utilized only for the purpose of parking, and the petitioner has formed shops and has leased out the same to other persons. Full stop. Next para. Having regard to these factual information available on record, comma, this court is of the considered opinion that the petitioner is required to remove the 2 additional floors put up and remove the shops put up in the basement floor. Full stop.
On report,
That
then we'll
purpose,
let the report be submitted, madam. Thereafter, your lordship may.
ಏನ್
Your
report?
lordship only pass an next week, I mean, that.
Again report, ಹೇಳಿ. I can get it today itself. This is that, this is
15,
not
20
going to help,
No, I will ask,
not going to help.
that the person managing.
You should fairly admit,
ಅದಕ್ಕೆ ಹೇಳಿದ್ದಾನು.
no, you should fairly admit.
I already.
See, you will have to remove the shops.
ಅಲ್ಲ,
It has to
ಅದು
be
ಹೇಳಿ
used
ಆಗಿದೆ. ನಾನು
for parking area only.
ನಿನ್ನೆನೆ ಹೇಳಿದ್ದೇನೆ ಅವ್ರಿಗೆ, you have to remove it,
Hmm.
you have to regularize it. ಅಂತ ಅವ್ರು ಯಾರು ಅವ್ರ ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್ ಇಸ್ ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಬರ್ತಾರಂತೆ ನಾಡಿದ್ದು ಮಂಗಳೂರು. ಅದಕ್ಕೆ you will ask me kindly give some short accommodation so that I will ask them what best we can do it.
Having regard to the submissions made by the learned senior
ಕೋರ್ಟ್
counsel
ಆರ್ಡರ್ ಬಿಟ್ಟು ಸ್ವಲ್ಪ
that students are residing in the hostel and the lessees have to be requested to make alternative arrangements, comma, 4 weeks time is granted to do the needful. Full stop. Next para. Release this matter on 12th of July 2024. Full stop. An affidavit shall be filed by the petitioner regarding the compliance of the directions issued by this court. Yes. Till the next
in
date
the
of
meanwhile,
hearing,
let them not precipitate.
the respondents are directed not to precipitate the matter any further. Yes.
For petitioner, kindly pass out.
Regarding tax. 25 crores.
ಖಾತಾ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ
Yes, sir.
ಏನ್ ಖಾತಾ ಮಾಡ್ಬೇಕ್ರಿ ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ? Annexure D.
Annexure B is the purchase, sale deed.
Learned AGA takes notice for respondent number 1. Learned counsel Sri Pawan Kumar, who is present in the court, takes notice for respondents number 2 and 3. Learned counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned counsel for the respondent BBMP and the learned AGA. Full stop. Next para. Learned counsel for the respondent BBMP is directed to secure instructions and make submissions, comma, since the Union of India is before this court seeking directions to the BBMP to register the Khata in its name, comma, on the ground that the Central Public Works Department has purchased 18 acres of land from the previous owner, HMT.
HMT Limited.
Full stop. Release this matter on 19th of June.
Petitioner counsel,
Yes.
the elections, the proceedings of the elections had reached the stage of delegate forms were received. The date for election was to be announced along with the defaulters list. That is, 60 days program was required to be started. At that stage, my lord, as your lordships may recollect, first a notification was issued saying in view of the parliamentary election we are postponing, etc. They withdrew that. Again issued a notification at annexure L 13/3/24. That again, that was also withdrawn. Annexure N was issued, page 39. On 21/3/2024, page 40, kindly see the conditions, my lord. ಮಾರ್ಚ್ ಮಾಹೆ ಸೋ ಅಂಡ್ ಸೋ ಆಡಳಿತಾವಧಿ ಮುಗಿಯುವಲ್ಲಿರುವ ಸಹಕಾರ ಸಂಘಗಳಿಗೆ ವಿನಾಯಿತಿ ನೀಡಿ ಸಹಕಾರ ಸಂಘಗಳ ಆಡಳಿತ ಮಂಡಳಿಯನ್ನು ಚುನಾವಣೆಗಳನ್ನು 6/6/24 ಮುಂದೂಡಿ ಹಾಲಿ ಇರುವ ಆಡಳಿತ ಮಂಡಳಿ ಪದಾಧಿಕಾರಿಗಳ ಅವಧಿಯನ್ನು ಮುಂದುವರಿಸಿದೆ. ಅಧಿಕಾರಾವಧಿ ಮುಂದುವರಿಸಿದ ಅವಧಿಯಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿಗಳು ಯಾವುದೇ ಪ್ರಮುಖ ನಿರ್ಣಯವನ್ನು ತೆಗೆದುಕೊಳ್ಳತಕ್ಕದ್ದಲ್ಲ ಹಾಗೂ ದೈನಂದಿನ ಕಾರ್ಯಚಟುವಟಿಕೆಗಳಿಗೆ ಸೀಮಿತಗೊಳಿಸಿದೆ. ಈಗಾಗಲೇ ಚುನಾವಣಾ ವೇಳಾಪಟ್ಟಿ ಪ್ರಕಟಿಸಿದ್ದಲ್ಲಿ ಅಂತ ಸಹಕಾರ ಸಂಘಗಳ ಚುನಾವಣೆ ಪ್ರಕ್ರಿಯೆಯು ಯಥಾಸ್ಥಿತಿಯಲ್ಲಿ ನಿಂತು ಹೋಗತಕ್ಕದ್ದು ಮತ್ತು 6/6/24 ನಂತರ ನಿಂತು ಹೋದ ಹಂತದಿಂದಲೇ ಚುನಾವಣಾ ಪ್ರಕ್ರಿಯೆ ಮುಂದುವರಿಸತಕ್ಕದ್ದು. ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡೋದಿಲ್ಲ ಅಂತೇಳಿ ಇದನ್ನ ಕೊಟ್ಟು we filed a writ petition pointing out our term expires on 28/7. It is not before 6th June. Therefore, there is some ambiguity in this notification because though delegate form is received and there was no actual election, they were required to publish that 60 days notice, which is to be done by the election officer. Therefore, we filed a writ petition pointing out this difficulty and ambiguity in the, kindly see page 42. Our writ petition nalli at page 46, this honorable court was pleased to pass an order saying, now that the voting in Karnataka will be over on 7/5, though code of conduct remains, 7/5 voting ಆಗೋದಿದ್ದಕ್ಕಾಗಿ ಈ ಪ್ರಿಪರೇಟರಿ ವರ್ಕ್ ಅನ್ನ 7/5 ನಂತರ ಇಮಿಡಿಯೇಟ್ಲಿ ಶುರು ಮಾಡೋದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡ್ರಿ, ಅದರ್ವೈಸ್ ಅನ್ನೆಸರ್ಲಿ ಕಾಂಪ್ಲಿಕೇಶನ್ಸ್ ವುಡ್ ಅರೈಸ್ ಅಂತೇಳಿ court sent a request pointing out this. It appears the election authority immediately forwarded it to the government saying this is what the court has observed, and this publication of draft voter list etc. can be made. Whether we can ask the election officer to proceed with that work. For that, government issued a endorsement
Your Lordship may kindly see annexure P, page 50. ಸ್ಪಷ್ಟೀಕರಣ ಕೇಳಿದಿರಿ ಅಂತ ಹೇಳಿ 51 ನಲ್ಲಿ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ನಿಯಮಾವಳಿಗಳ ನಿಯಮ 16D2A ಅನರ್ಹ ಪಟ್ಟಿ ತಯಾರಿಸಲು ಅನರ್ಹ ಸದಸ್ಯರಿಗೆ ನೋಟಿಸ್ ನೀಡುವ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಹಾಗೂ D5 ಕರಡು ಪಟ್ಟಿ ಸಲ್ಲಿಸಲು D3 ಕರಡು ಪಟ್ಟಿ ಪ್ರಕಟಿಸಲು ಪ್ರಸ್ತುತ ಕ್ರಮವಿಡಬಹುದೇ ಎಂಬ ಅಂಶಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಚುನಾವಣಾ ನೀತಿ ಸಂಹಿತೆ 6/6/24 ಜಾರಿಯಲ್ಲಿದ್ದು 6/6/24 ನಂತರ ಯಾವ ಹಂತದಲ್ಲಿ ಚುನಾವಣೆ ಪ್ರಕ್ರಿಯೆ ನಿಂತಿತ್ತೋ ಆ ಹಂತದಿಂದ ನಿಯಮ 13D ಪ್ರಕ್ರಿಯೆಯನ್ನು ಮುಂದುವರಿಸಬಹುದು. ಈ ಹಂತದಲ್ಲಿ ಪ್ರಕ್ರಿಯೆಗಳನ್ನು ನಡೆಸಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಸೊ ಗವರ್ಮೆಂಟ್ ಸೆಡ್ ಇಟ್ ಹ್ಯಾಸ್ ಅಂಡರ್ಸ್ಟುಡ್ ಇಟ್ಸ್ ನೋಟಿಫಿಕೇಶನ್ ಆಸ್ ಈವನ್ stopping and postponing the 13D proceedings also midway. Then it said it can be done only after 6/6/24. Immediately on 6/6/24, 5/6/24, annexure Q is issued. Page 52. This is again under section 121, they quote. Then kindly see conditions, my lord. ಒಂದನೇದು ರಿಟರ್ನಿಂಗ್ ಅಧಿಕಾರಿಯಿಂದ ಚುನಾವಣಾ ವೇಳಾಪಟ್ಟಿ ಪ್ರಕಟವಾದಂತಹ ಪ್ರಕರಣಗಳಲ್ಲಿ ಚುನಾವಣೆ ಪ್ರಕ್ರಿಯೆ ಪ್ರಾರಂಭವಾಗಿ 21/3/24 ಯಾವ ಹಂತದಲ್ಲಿ ನಿಂತು ಹೋಗಿದೆಯೋ ಆ ಹಂತದಿಂದ ಚುನಾವಣೆ ಪ್ರಕ್ರಿಯೆ ಪ್ರಾರಂಭಿಸತಕ್ಕದ್ದು. ಹಿಯರ್ ದೇ ಆಡೆಡ್ ಎ ಕಂಡೀಷನ್. It will apply only in respect of such of the societies where returning officer has published the calendar as required under Rule 14. ಉಳಿದವಕ್ಕೆ ಇದು ಮಾಡಲಿಲ್ಲ. ದೆನ್ 6/6/24 ಇದ್ದಂತೆ ಆಡಳಿತ ಮಂಡಳಿಗ ಪದಾವಧಿಯು ಮುಕ್ತಾಯಗೊಳ್ಳುವ ಚುನಾವಣೆಗೆ ಬಾಕಿ ಇರುವ ಸಹಕಾರ ಸಂಘಗಳು ಮಾಧ್ಯಮಿಕ ಇವರ ಆಡಳಿತ ಮಂಡಳಿ ಹಾಗೂ ಪದಾಧಿಕಾರಿಗಳ ಅವಧಿಯನ್ನು ಚುನಾವಣೆ ನಡೆದು ಹೊಸ ಆಡಳಿತ ಮಂಡಳಿ ರಚನೆಯಾಗುವವರೆಗೆ ಮುಂದುವರಿಸತಕ್ಕದ್ದು. ಅನ್ಕಂಡೀಷನಲಿ ಹಳೆ ಕಮಿಟಿನ ಮುಂದುವರಿಸಿದ್ರು. ಮೂರನೇದು ರಿಟರ್ನಿಂಗ್ ಅಧಿಕಾರಿಯಿಂದ ಚುನಾವಣಾ ವೇಳಾಪಟ್ಟಿ ಪ್ರಕಟವಾಗದೇ ಇರುವ ಎಲ್ಲಾ ಪ್ರಕರಣಗಳಲ್ಲಿ ಇನ್ ವಿಚ್ ದಿ ಪೆಟಿಷನರ್ ಸೊಸೈಟಿ ವುಡ್ ಕಮ್. ಕರಡು ಅನರ್ಹ ಮತದಾರ ಪಟ್ಟಿ ಪ್ರಕಟಿಸಲು 23-24 ಸಾಲಿನ ಸಹಕಾರ ವರ್ಷವನ್ನು ಒಳಗೊಂಡಂತೆ ಪ್ರಕರಣ 20(2)A ಸೋದಲ್ಲಿಯ ಅವಕಾಶಗಳ ಷರತ್ತನ್ನು ಪೂರೈಸಿರುವ ಕುರಿತು ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ನಿಯಮಾವಳಿ 13(2)2A ಅವಕಾಶಗಳಂತೆ ಆಕ್ಷೇಪಣೆಯನ್ನು ಸಲ್ಲಿಸಲು ಹೊಸದಾಗಿ ಅವಕಾಶ ನೀಡಿ ನೋಟಿಸ್ ಕೊಡತಕ್ಕದ್ದು. 13D2A ಹೊಸದಾಗಿ ಮಾಡಬೇಕು. ಅದಕ್ಕೆ 23-24 ವರ್ಷವನ್ನು ಸೇರಿಸ್ಕೊಳ್ಬೇಕು. 23-24 ವರ್ಷದ್ದು indirectly what has been done is the general body would be held on or before 25th of September after June. So 25th September ವರೆಗೆ ವೇಟ್ ಮಾಡಿ ಜನರಲ್ ಬಾಡಿ ಮಾಡಿ ಈ ಜನರಲ್ ಬಾಡಿಯಲ್ಲಿ ಹಾಜರಾಗ್ತಾರೆ ಆಗೋದಿಲ್ಲ ಅನ್ನೋದನ್ನ ಲೆಕ್ಕಕ್ಕೆ ತಗೊಂಡು 195 days ನೋಟಿಸ್ ಅನ್ನ ಹೊಸದಾಗಿ ಕೊಡಬೇಕು. ಮುಂದೆ ಅದರಲ್ಲಿ ಕಂಡೀಷನ್ 5 ತಾವು ನೋಡ್ಬೇಕು. 4 ಇದಾಗುತ್ತೆ, ಬಟ್ ದಟ್ ಈಸ್ ಫಾರ್ ಕ್ರೆಡಿಟ್ ಸೊಸೈಟೀಸ್. 5 ನೋಡ್ಬೇಕು.
This is a general order.
ಜನರಲ್ ಆರ್ಡರ್ ಯಾವ ರೀತಿ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ, ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ನಿಯಮ ಸ್ವಯಂಸತ್ತೆ ಮತದಾರ ಪಟ್ಟಿ ತಯಾರಿಸುವ ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿ ಮುಕ್ತಾಯಗೊಂಡಲ್ಲಿ ಅಂತಹ ಸಹಕಾರ ಸಂಘಗಳು ಆಡಳಿತ ಅವಧಿಯು ರಚನೆ ಮುಂದುವರಿಯತಕ್ಕದ್ದು. ಆದ್ರೆ ಅದನ್ನ ಹೊಸ ವರ್ಷಕ್ಕೆ ಸೇರಿಸ್ಕೊಳ್ಬೇಕು. ನಾವು your lordship may kindly see, we will not enter into the controversy whether elections can be postponed under section 121, because there are some decision which say election proceedings cannot be postponed under 121. Some contra are also there. I am not going into that. For exercising 121 power on 21/3/24 or 13/3/24 on the earlier date, they had a reason. They stated specifically that there are more than 18,000 cooperative societies to which election is to be held. Now that the government officials have been designated with several work pertaining to parliamentary election, it will be very difficult to conduct the election in a proper manner. Therefore, we are postponing it. We will continue from the stage from where it is done. ಆವಾಗ ಚುನಾವಣಾಧಿಕಾರಿಯಿಂದ ನಾಮಿನೇಷನ್ ಪ್ರಕಟವಾಗಲಿ ಅನ್ನೋ ಕಂಡೀಷನ್ ಅನ್ನ ಹೇಳಿರ್ಲಿ. ಎರಡನೇ, ನಾವು ಕೋರ್ಟ್ನವರು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಡೈರೆಕ್ಟ್ ಮಾಡಿ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೇಳಿದಾಗ ಸಹಿತ ಇಲ್ಲ ಇಟ್ ಇನ್ಕ್ಲೂಡ್ಸ್ ಎವ್ರಿಥಿಂಗ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ 13D, ಅದು ಎಲ್ಲಿಗೆ ನಿಂತಿದೆ ಮುಂದುವರಿಸಬಹುದು ಆಮೇಲೆ. ಈಗ ಇನ್ ಎಫೆಕ್ಟ್ ವಾಟ್ ದೇ ಹ್ಯಾವ್ ಡನ್ ಈಸ್ ದ ಇಲೆಕ್ಷನ್ಸ್ ಫಾರ್ 22-23 which were due for 22-23 onwards are postponed by 1 year. 25/9 ಜನರಲ್ ಬಾಡಿ ಮಾಡೋದಕ್ಕೆ ಟೈಮ್. 25/9 ಜನರಲ್ ಬಾಡಿ ಮಾಡಿದ ನಂತರ 13D2A ನೋಟಿಸು 195 ಡೇಸ್ ಅಂದ್ರೆ 6 ತಿಂಗಳು 15 ದಿವಸ. ಅಕ್ಟೋಬರ್, ನವೆಂಬರ್, ಡಿಸೆಂಬರ್, ಜನವರಿ, ಫೆಬ್ರವರಿ, ಮಾರ್ಚ್, ಏಪ್ರಿಲ್ 6 ತಿಂಗಳು ಮಾರ್ಚ್ ವರೆಗೆ ಟೈಮ್ ಆಗುತ್ತೆ, ಮುಂದಿನ ವರ್ಷದ ಮಾರ್ಚ್ ವರೆಗೆ. ಆಮೇಲೆ ಇದನ್ನ ಏನು ಇಲೆಕ್ಷನ್ ಇದು. ಸೊ ಅರ್ಲಿಯಸ್ಟ್ ದಿ ಇಲೆಕ್ಷನ್ ಕ್ಯಾನ್ ಬಿ ಹೆಲ್ಡ್ ಈಸ್ April 2025. It is not something which such a power, exercise of such a power, assuming for a moment 121 gives such a power, this is most arbitrary and it has no reason or rhyme.
What is the prayer?
I have sought for stay of conditions 3 to 5 and have also sought for continuing the election subject to result of the petition. ಯಾವ ಸ್ಟೇಜ್ ನಲ್ಲಿ ಇದಿತ್ತು ಮೊದಲಿನ ನೋಟಿಫಿಕೇಶನ್ ಪ್ರಕಾರ ಆ ಸ್ಟೇಜ್ ಇಂದ ಮುಂದುವರಿಸ್ರಿ.
Lord, may I request, my lord, the condition imposed in the impugned order, that is, doesn't affect the petitioner, and it doesn't say that the election will be held in March 2024 and 25. I will take instruction. The matter may be taken tomorrow, my lord. I will make appropriate submission. Yes.
Learned AGA takes notice for response number
2.
1 and 2 and 4.
Lord, 4 ಅವರು ನಾವು ತೊಗೊಳೋದಿಲ್ಲ.
Federation ಗೆ regional commissioner,
Federation,
Bangalore division.
he will be in a federation, he will appearing for federation. ಅವ್ರು ಫೆಡರೇಷನ್ ಆಗ್ಬಿಡ್ತಾರೆ.
ಅಲ್ಲ, ರೀಜನಲ್ ಕಮಿಷನರು, he is the election officer. All these are apex societies, therefore regional commissioner is the election officer.
Learned Council Sri TL Kiran Kumar requested to take notice for response number 3. Learned Council for the petitioners is directed to serve 2 sets of copies of the writ petition along with annexures on the learned AGA as well as learned Council Sri TL Kiran Kumar. Full stop. Next para. Learned Senior Counsel Sri Jaykumar S. Patil, appearing on behalf of the petitioners, submits that the petitioner society was earlier before this court in WP number 11962 of 2024. Seeking a direction to the respondents to continue with the election process from the stage where it was interfered with, so that the elections can be held immediately after 6/6/2024, having regard to the code of conduct issued for the parliamentary elections. Full stop. By order dated 25/4/2024, this court
What is it? Page 14.
had directed the state election authority and the government to take appropriate stand. 49 ಅಲ್ಲಿ.
Page 48 ನಲ್ಲಿ last but one ಪ್ಯಾರಾದಲ್ಲಿ last sentence. It would be
Regarding
appropriate.
the request made on behalf of the petitioners that
Preparatory steps
the
leading.
preparatory steps for continuation of the election process, whether can be proceeded from 7/5/2024, since the polling in the
State of Karnataka.
state of Karnataka would conclude. And having regard to the preparations for the elections already having commenced, whether the petitioner society and the returning officer can be permitted to
Election
continue.
officer.
Election officer may be permitted to continue with the election process from the stage when it was interrupted. Full stop. However, the additional chief secretary, Department of Cooperation made a communication dated 23/5/2024 to the
Election
State
authority.
Cooperative Election Authority, stating that it would not be permissible to grant permission to continue with the process from 7/5/2024 as sought by the petitioners. Full stop. However, it was also clarified that immediately after 6/6/2024, the petitioner and petitioner society and the election authority will be permitted to continue the election process in respect of the petitioner cooperative society from the stage when from where it was interrupted, including the provisions contained in section 13D, 13 capital D.
Section ಅಲ್ಲ, rule.
Rule 13 capital D bracket 5. Bracket
ಮೊದಲೇ 13D,
bracket
2A,
2A
2A, 5 and 3.
13D bracket 5 or 13D bracket 3. Full stop. However, by virtue of the impugned government order dated 5/6/2024, the petitioner society and the election officer will not be permitted to continue the process as was agreed earlier in terms of the communication dated 23/5/2024. Full stop. Learned Senior Counsel submits that on a plain reading of the impugned order, which are general directions applicable to the entire state, the process will have to recommence not from the stage when it was interrupted, but
After the general body for the current year
but
23-24.
it requires the publication of the list of eligible and ineligible voters, taking into consideration the year 2023-24. comma, which would mean that the election cannot be held for the next 6 months. Full stop. Next para. At this juncture, learned AGA seeks for a short accommodation to secure instructions insofar as the third petitioner cooperative bank is concerned, comma, having regard to the
Consumers Federation Bank.
third petitioner federation is concerned. Full stop. Release this matter on 18th of June. Obliged. Yes.
ಅದು ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ನಲ್ಲೇ ಕರಿಬೇಕು ಬಿ ಗ್ರೂಪ್ ನಲ್ಲಿ ಪೋಸ್ಟ್
For preliminary hearing.
Please. Response number 2 and 3 has issued, my lordship, 248, 1 and 2 notice has so far, my lordship, which is, my lordship, without jurisdiction. My lordship, 248, section 248 of BBMP Act stipulates the zonal commissioner has to issue the notice. My lordship, it is a quasi judicial power and it has to be exercised by the zonal commissioner. And one,
So you want to stand on technicalities. You are not saying anything
lordship,
regarding
yes,
your
in fact, my lordship,
construction.
my lordship, in fact,
Huh?
in fact, my lordship, they have not conducted joint inspection.
Ah.
My lordship, kindly see the, my lordship, the sale date.
Have you
Lordship-
stated in your petition
My lordship,
that you are put up construction only in accordance with the sanction plan?
my lordship, there is, my lordship, according to the provisional order.
Have you made a statement in the petition that you have put up construction only in accordance with the sanction plan?
My lordship,
Huh?
but there is a violation, my lordship, but they consider, my
Who is violating? Not them.
lordship, they consider it is,
Not making a statement that I have not violated, I have put up the construction only in accordance with the sanction plan. This court will presume
my
there
lordship,
is nothing wrong in the action taken by the BBMP.
but my lordship, they have not conducted joint inspection. Plus, my
You
lordship,
want a joint inspection to be conducted.
please, my lordship.
That is all.
My lordship, no, my
We
lord.
will order.
Further, my lordship, they consider that it is 2 floors, it is additional 2 floors. But my lordship, the top floor is, my lordship, the tank room and the lift room.
Let us consider. Workal. Learned counsel Sri Pawan Kumar, who is present at the court, takes notice for all the respondents. Learned counsel for petitioner is directed to serve 2 sets of copies of the writ petition
Please.
along with annexures on the learned counsel for the respondent. Please, we'll stop. Next para. Since it is contended on behalf of the petitioner that the information collected by the respondents was not in the presence of the petitioner, please, and that the petitioner has not violated any conditions imposed in the sanction plan.
That is additional
Comma.
1 floor.
If you admit, then the end of the matter.
But my lordship, as 247 has my lordship, he can apply for a modification of plan under 247. If it is, if
Sir,
it,
modification only 5%. ಅದ್ ಮಾಡಿದ್ರೆ ನೀವು ಈ ಕೋರ್ಟ್ ಮುಂದೆ ಇರ್ತಾನೆ ಇರಲಿಲ್ಲ. The ಯಾರು ಅಸಿಸ್ಟೆಂಟ್ ಡೈರೆಕ್ಟರ್ ಆಫ್
2 and 3, my lordship.
ಅಸಿಸ್ಟೆಂಟ್ ಡೈರೆಕ್ಟರ್ ಆಫ್ ಟೌನ್ ಪ್ಲಾನಿಂಗ್.
Town planning, yes.
ಅಸಿಸ್ಟೆಂಟ್ ಡೈರೆಕ್ಟರ್.
If plan is there, assistant director of town planning.
The impugned notices are issued by whom?
Assistant director of city planning and assistant engineer of city planning.
Director, town planning, will not say.
Town planning.
Town plan-
I,
Respond number 2, assistant director town planning
Town plan.
is directed to conduct a spot inspection in the presence of the petitioner on 18th of June at 11 AM. Full stop. The petitioner is also directed to be present at the spot on the particular date without waiting for further notice. Full stop. Next para. Release this matter on 25th of June 2024 to enable the second respondent to file a report before this court. Full stop. Next para. Needless to observe that till the next date of hearing, no precipitative action shall be taken by the respondents. Full stop. The petitioner is also directed not to proceed with the construction till the next date of hearing.
Careful.
For the petitioner, my lords. Petition, my lords, seeking mandamus. I have given the representation to the chief officer of town municipal, my lords, seeking mutation of Khata as per the registered sale deed. Registered sale deed, my lords, is in annexure A, which is in page number 10, my lords. And representation is in annexure B, my lords, page
11.
yes, my lords.
ಏನ್ ಪೇ ಮಾಡ್ತಾರೆ ಇಷ್ಟು ವರ್ಷ?
ಕೊಟ್ಟಿತ್ತು ಅವ್ರು ಆಗ್ಲಿಂದನೂ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಯಾವ್ದು ಜಾಗ ಇದು?
ವಿಜಯಪುರ, my lords.
Huh?
ಬೆಂಗಳೂರು ರೂರಲ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್, ವಿಜಯಪುರ.
Town municipality.
Yes, my lords.
Learned AGA takes notice for respondent number 1. Issue notice to respondent number 2. The petitioner is also permitted to take out hand summons
Yes, please.
to respondent number 2. Release this matter on 20th of June.
In preliminary hearing. My lords, preliminary. My lords, please, preliminary hearing. ಇಲ್ಲಾಂದ್ರೆ B group ಅಲ್ಲಿ ಬರುತ್ತೆ ಸ್ವಾಮಿ, ರೀಚ್ ಆಗಲ್ಲ. Please, my lords, only mandamus.
Let us see. Yes.
During to the petitioners, my lords, my learned friend informed me that they would like to take an adjournment
Huh?
in the matter.
So the council on record, SH Prashant sir has some inconvenience today. So kindly a date may be fixed next week.
My lords, we would also like to file
Inspection
written,
report
the
has been
physical
filed.
inspection report has been served on us since the last date of hearing. We would
Ah.
like to file written objections as well, my lords, to the report. Hence, if a date may be granted for the same.
A week's time is granted at the request of learned counsel for petitioner to file objections to the inspection report filed by the respondent BBMP. Full stop. Release this matter on 24th of June.
Kindly. My lords, interim order granted on second
Interim order
February,
granted earlier,
kindly be
extended till
continued.
next date.
Great.
In this matter appearing for proposed respondent.
Lord, this is a case where, my lord, the petitioner is a telecom infrastructure provider. Lord, petitioner was granted license from BBMP for erection of mobile tower. In furtherance to which, my lord, petitioner has erected the mobile tower. But in furtherance to,
When did you erect it?
Lord, it was January 2024.
ಈಗ recent.
ಹೌದು.
ಹಾ,
The license was issued on 12/1/2024.
ಹಾ,
Subsequently, my lord, the tower has been erected. Now it seems, my lord, the present impleading applicant but said to have submitted a representation to BBMP saying that the mobile tower, because of this EMF, it is electromagnetic frequency radiation, it may cause health hazards to the general public. Based on that, my lord, without any proper inquiry or anything, now annexure A, page 16 is issued by the BBMP. Unilaterally, my lord, withdrawing the license. But what I would submit is,
notice has been ordered.
notice was ordered, my lord, the interim order was also granted.
Hmm.
Now the tower is functioning, my lord. But if at all the,
Let them file objections. We will consider.
yes,
Lordship, one submission on behalf of the proposed respondents. Lordship, though they have submitted that 12/1/2024, they obtained, they have obtained license. Lordship, kindly see my impleading application, page number 8, my lordship. Lordship, even before, my lordship, grant of permission, on 10/11/2023, my lordship, before that itself, they have started construction. My lordship, I have filed complaint to ADTP.
For objection.
Lordship, it is, my lordship, it is illegal.
What is illegal?
The construction of the tower itself is illegal. And I produced photograph.
They have got the sanction at least later.
Lordship, that is there, Lordship, but Lordship, in terms of the regulation, they have to comply, Lordship, the Lordship, kindly see page number 51, Lordship. 51 of their petition. Lordship, assessment of inconvenience that public is likely to be put in consequence of establishment or maintenance of telecommunication infrastructure tower or overground cable infrastructure and measures to mitigate such inconvenience indicated by the permission holder. That has to be done, Lordship.
Yeah, no, Angandre.
Lordship,
Then nowhere in the city of Bangalore you put a telecom tower.
but Lordship, they have not complied with the provision.
Special law.
Lordship,
Anything special about you? There are any number of towers in
please,
Bangalore.
I
city,
understand,
sir.
Lord. Yes, Lord. In fact, but
How can you make use of this sentence and say, no, they have not heard me? Who are you?
Lordship, the localites, Lordship.
So what? When the guidelines itself permit erection of telecom towers,
They have to comply with this, Lordship.
then what is it? What is it that you are going to say?
Lordship, it is Lordship, that is to the life of Lordship, the petition.
Sir, which would mean, please, no telecom tower can be erected anywhere in Bangalore city.
I'm Lordship, further.
Not Bangalore city, anywhere in the state and anywhere in the country.
Please, but Lordship, in fact, there is
You want to make use of mobile phones, but you don't want the telecom tower to be erected in the neighborhood. How is it
in
possible?
fact, there is Lordship, school and Lordship, government, this one, hospital
No.
nearby. Even Lordship, the Supreme Court has Lordship stopped construction near the school, Lordship.
2 weeks time is granted to the respondents to file statement of objection. Full stop. Similarly, the petitioner is also permitted to file objections to IA number 1 of
I
2020.
already filed.
Yes.
Khata has been issued, my lords, is the instructions. Our Khata kelkond bandidare swami. In 3/5/24 itself, the Khata has been issued.
The petitioner is before this court with a prayer to issue a writ of mandamus to consider online Khata transfer in favor of the petitioner in terms of his application dated, its application dated 2/11/2023 at annexure A. Next para, learned counsel for the respondent BBMP submits on instructions that
On
the Khata has been issued on
3/5, 3rd May.
3/5/2024. Full stop. Next para, placing the submission of the learned counsel for the respondent BBMP, the writ petition stands disposed of as the prayer made in the writ petition has become infructuous. Full stop. Needless to observe that liberty is also reserved to the petitioner to move the court in case of the respondents not issuing the Khata certificate as has been submitted by the learned counsel for the respondent BBM. Yes.
For petition, my lord. Petition is an education institution which has filed application for the allotment of civic community site, my lords. Yesterday, my lords, if my lord.
Mysore.
Civic community
Mysore.
sites, Mysore, my lords.
Why so many writ petitions are being filed? What is this?
My lord, the process actually initiated in the year 2021. Even after lapse of 3 years, my lords, the process is not completed. Publication was publication was given in the year 2021, my lords.
Yesterday, matter had come up for preliminary hearing. Preliminary hearing.
Preliminary hearing, fresh matter, my lords.
Yav the writ petition number?
Writ petition number, my lords. 10839 of 2024.
108.
39 of 2024. This was serial number 13, my lords, yesterday also.
Serial number 13, serial number 13, same order. Yes.
My lords, one humble submission. Thereafter, my lords, on serial number 14, my lords.
WP number 10839 of 2024.
In my matter, my lords, notice was ordered. In next matter, my lords, notice was already ordered. So the respondent counsel appeared in the matter and he did he makes submissions and my lords disposed of the matter.
Serial number 13 yesterday.
Yes, my lords.
Where notice was issued.
Please, my
So
lords.
same order. Yes.
One humble submission, my lords. The respondent counsel for respondent number 2 to 4, my lords, BS Prasanna, my lords, BR Prasanna. He may kindly be taken notice, my lords.
Same.
Vivek was ordered to take notice, my lords. I was told, my lords, my instruction is Vivek has given NOC in those matters. That's why BR Prasanna is appearing in the matter. And
BR Prasanna. Learned counsel BR Prasanna.
18th, my lords.
And Nenne matter ಅಷ್ಟೇನಾ?
14th ಒಳಗೆ ಡಿಸ್ಪೋಸ್ ಆಗ್ಬಿಡ್ತು. ಯಾಕೆಂದ್ರೆ ಅದ್ರೊಳಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಅಪಿಯರ್ ಆಗಿದ್ರು. 13th ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ನಂದು ನೋಟಿಸ್ ಆಗಿದೆ ಅಷ್ಟೇ.
ಯಾರು ಟೇಕ್ ನೋಟಿಸ್ ಇಂತ ಯಾರು ಹೇಳಿರೋದು?
ವಿವೇಕ್.
ಅದನ್ನು ಚೇಂಜ್ ಮಾಡ್ಬೇಕಾ?
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್ಸ್.
ಪ್ರಸನ್ನ
ಪ್ಲೀಸ್
ನೋಡ್ರಿ, ಸೈನ್ ಮಾಡಿಲ್ಲ ಅಂತ ಅದನ್ನ ಚೇಂಜ್ ಮಾಡಿ.
And that matter is posted on 18th, my lords.
18th, yes.
Grateful, my lords.
Petitioner, my lord, to change the Khata in the name of the petitioners, representation made on 19/3/24, my lord.
The competent authority is zonal commissioner
Yes, my lord.
to change the Khata.
Yes, my lord, we have given representation.
Yen names, Pawan Kumar? Anyone from BBMP? Yar the competent authority for transfer of Khata?
I think it is ARO, my lord.
Huh?
ARO.
ARO. You have given representation to the zonal commissioner. Huh? Where is your representation? Annexure A.
Yes, my lord.
ಅದೇ zonal commissioner ಕೊಟ್ಟಿದ್ದೀರಾ.
ಹೌದು.
KG ಬ್ಯಾಡ್ರಹಳ್ಳಿ. ಎಲ್ಲಮ್ಮ ಇರೋದು ಪ್ರಾಪರ್ಟಿ?
Bangalore North,
KG
KG Badrelli village, north.
Bangalore North ತಾಲೂಕಲ್ಲ ಇಲ್ಲಮ್ಮ. You are referring to the revenue districts. And you are asking the zonal commissioner to issue the Khata without even giving the proper address. Huh? ಯಾವ ವಾರ್ಡ್ ಬರುತ್ತೆ? BBMP ಯಾವ ವಾರ್ಡ್? You'll have to give the
Jayamahal extension.
Huh?
Jayamahal extension.
ಇಲ್ಲ,
KG
KG Badrelli ಅಂತ ಮಾತ್ರ mention ಮಾಡಿ.
ಮತ್ತೆ how should we find out?
Badrelli 72. Ward number 72 Badrelli.
Ward number
72.
You are sure?
Yes, I am there. Native.
72.
72.
Ward number 72. ಬರ್ಕೊಳ್ಳಿ. At the request of the learned counsel for the petitioners.
Sorry, man, bari Badrelli, KG Badrelli.
KG Badrelli.
KG ಬ್ಯಾಡ್ರಲ್ಲಿ ಇಲ್ಲ. ಬಾತ್ ಬೇಡ. Learned counsel Shri
Mallikarjun Reddy.
Mallikarjun Reddy, who is present in the court, is requested to take notice for the respondent. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures and the learned counsel for the respondent. Full stop. Next para. The grievance of the petitioners is that their representation given to the respondent for transfer of Khata has not been acted upon. Full stop. However, learned counsel for the respondent submits that the competent authority for transferring the khata is the assistant revenue officer and not the zonal commissioner. Full stop. Moreover, the representation at Annexure A does not contain any information regarding the ward number in which the property is situated, and therefore it cannot be expected that the zonal commissioner would consider such a representation. Full stop. Next para. At this juncture, learned counsel for the petitioner seeks leave of this court to withdraw the writ petition and give a proper representation to the concerned officer, namely the assistant revenue officer of the particular ward of the BBMP, along with all the requisite information. Full stop. Next paragraph. Accepting the submission of the learned counsel for the petitioners, comma, the writ petition stands disposed of, stands dismissed as withdrawn, while reserving liberty to the petitioners to file a proper application before the concerned assistant revenue officer of the BBMP. Full stop. If such application is given by the petitioners, comma, the concerned ARO is directed to consider the same in accordance with law and within the time frame stipulated in the provisions of the BBMP Act, the rules and the Act and the rules. Full stop. Yes.
Much better.
But the petitioner operates a liquid petroleum gas bottling plant, but within limits of the third respondent Panchayat, T. Begur Marat, which falls within Nelmangla Taluk. But he has secured permissions from all government departments, very sensitive departments, Marat, because since it's a bottling plant of the petroleum, liquid
There is
petroleum.
no interim prayer.
There is no interim prayer. Only request.
AGA takes notice for respondent number 1. Learned counsel Shri M.S. Devraju, who is present in the court, takes notice for respondents number 2 and 3. Learned counsel for petitioner is directed to serve 2 sets of copies of the writ petition along
Very
with
well.
annexures
Very well.
on the learned AGA as well as learned counsel Shri M.S. Devraju.
Very well.
Full stop. Next para. Learned counsel Shri M.S. Devraju is requested to secure instructions and make submission. Full stop. Release this matter on 25th of June.
Grateful.
The respondent 4 and 5. On the last occasion, my lord, your lordship, this matter, my lord, pertains to an unauthorized construction. Your lordships on the last occasion, my lord, was pleased to pose a query as to what action has been taken by the BBMP pursuant to the 313 notice, man. 313 notice, my lord, has been issued to the respondent 1 and 2, my lord, which is produced here with that annexure J, page number 49. Subsequently, my lord, I'm on instructions, my lord. Provisional order, my lord, has been served on the respondents 1 and 2 on 7/5/2024. Adad nantara confirmation order is stated to have been issued, my lord, on 25/5/2024. So adad nantara, my lord, if at all they give any representation, we will consider that representation, my lord.
Because the grievances, they've already put up 4+1 floor, my lords.
Have you stopped the construction?
The construction has not been stopped.
My lord, adr bagge idilla, my lord. There is no information. Just on instructions, my lord, I'm stating that provisional order and the confirmation order has been issued, my. It was posted last week, my lord, on 5/6/2024.
Allah, notice was not ordered?
Notice was not ordered. Just the BBMP was directed to seek instructions.
Issue notice to response number
One and
one and two. Learned AGA takes notice for response number 3. Learned counsel Mallikarjun Reddy.
Mallikarjun,
Yes, sir.
please.
You filed Wakalat?
Yes, my lord, I filed Wakalat.
Has already entered appearance for response number 4 and 5. Please, full stop. Next para. In terms of the directions issued on the previous occasion, learned counsel for the respondent BBMP submits on instructions that the provisional notices were issued and confirmation order has also been passed under section 248(3) of the BBMP Act 2020 on
25/5/2020.
25/5/2024. Full stop. Next para. Release this matter on 25th of June. Full stop. You have to immediately take steps so that they will appear on the next date of hearing.
Still then, there might be a.
Since the confirmation order has already been passed, the fifth respondent is directed to ensure that there is no further construction.
ADTP, my lord, fifth respondent is AWE, Ur Baralla. The authorized officer, my lord, is the ADTP who's not made a party in this writ petition.
The assistant director of town planning.
Town planning, how?
ಯಾವ subdivision?
My lord, this is RR Nagaram.
Rajarajeshwari Nagara.
Please.
Is directed to ensure that respondents number 1 and 2 shall not proceed with further construction, further illegal construction. Next para. At the oral request of the learned counsel for petitioner, the assistant director of town planning, Rajarajeshwari Nagara subdivision, BBMP, is directed to be impleaded as party respond number 6 to the proceeding. Full stop. Learned counsel Shri K.S. Mallikarjun Reddy undertakes to appear for the newly impleaded respond number 6. Yes.
My lord, ಇದರಲ್ಲಿ ಯಶವಂತಪುರ್ ಹೋಬಳಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಬಟ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ AWE RR ನಗರ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸೊ ಈವನ್ ಐ ಆಮ್ ನಾಟ್ ವೆರಿ ಶೂರ್, ಮೈ ಲಾರ್ಡ್.
RR Nagar. RR Nagar.
Rajaraj. Very much obliged. My lord, I may be directed to place those 248, 123 notices also on record, my lord.
In all for further procedure, it is your duty to now bring all the information before the.
I'll place them.
I did not direct you.
Please.
Yes.
Obliged.
Matters called out. There is no representation for either of the parties. Stop. Even on the previous occasion, there was no representation for the petitioner. Full stop. Next para. Release this matter on 20th of June 2024. Full stop. If there is no representation for the petitioner on the next date of hearing, the petition will be dismissed for non-prosecution.
Hearing for the petitioner. The respondent has proposed an arbitrator, Shri Shivalinga Gowda.
We have agreed on the arbitrator minutes. It can be referred to the arbitration center.
Who is that?
He's on the
Shivalinga
panel,
Gowda.
retired district judge Shivalinga Gowda minutes. All contentions may be kept open. He is on the panel of advocates.
B. Shivalinga Gowda.
Please.
First paragraph, accommodate. Next paragraph. Both the learned councils jointly submit that the parties have agreed to the appointment of Shri B. Shivalinga Gowda, retired district judge, please, as an arbitrator to decide the list between the parties. Stop. Next paragraph. Last operative portion only, the B. Shivalinga Gowda, retired district judge.
All contentions may be kept open.
Yes.
To the petition, my lord. We have already served a copy of the petition on the respondent. However, when we went to serve the copy of the hand summons, the same was refused by them. I have already filed an affidavit to that effect. I mean,
I undertake to appear for the respondent. My name may be Shambhala. I'll get the instructions and make my submission. They have received the hand summons. I don't know.
It's
Say
not.
that it is refused. Has been
Municipal
sent.
Commissioner
How?
Gadag Betegeri,
House. They have received the hand summons.
The hand summons is right here with me, my lord, the original. hand.
learned council.
Yes.
Uh,
Jeevan J. Niralgi.
Jeevan
J. Niralgi.
J. Niralgi
Yes.
undertakes to appear for
Respond.
the respondent. Full stop. However, learned counsel, you have got a copy of the petition,
Yes, madam.
seeks for a short accommodation to secure instructions and make submission. Full stop. Next para, release this matter on 19th of June. Please.
Appear for the respondent, appearing for the petitioners, my lord. We have served already the summons. We have no objections, your lordship, but however, the matter may be referred to mediation. The respondents are wanting to resolve the matter.
Mediation.
Yes, your lordship.
Mediation.
Yes, your lordship. They are wanting to resolve the matter, your lordship.
It cannot be done like that.
My lord, what they tell is, it might be referred to the jurisdiction, which is the arbitration. That is the clause which they have mentioned in the agreement. So let it be referred to the
If
arbitration.
there's an arbitration clause, this court cannot refer it to a mediation.
Then it may be referred to arbitration.
What is the claim amount?
My lords, the claim amount is 1 crore 67 lakhs.
So retired High Court judge has to be appointed.
It is strict judge itself. It is Sri Justice A.N. Venugopala. That is what we have.
So High Court judge.
Yeah.
See, it's more than 1 crore.
Fine, your lordship. And we've put to hardship, my lord.
Your previous madadaballama, same submission. Allah, second paragraph purple. After notice is issued to the respondent, learned counsel Sri Rama or Iyer.
Yes, sir. Yes, sir.
Has entered appearance.
Yes, sir.
For the respondent. Full stop. Learned counsel for the respondent fairly submits that this court may proceed to appoint an arbitrator to decide the list between the parties. Full stop. Next ಇನ್ನೊಂದು paragraph ಅಲ್ಲಿ there is compliance of all the requirement of law ಅಂತಂದಿದೆ. ಅದಾದ್ಮೇಲೆ We'll appoint Justice P. Vishwanath Shetty. Huh?
No, not an issue.
Justice P. Vishwanath Shetty, former judge of this court. Yes.
Much of.
My lord, this is appointment of an arbitrator. The contract is at annexure A, page 12, my lord. And the class is at 14, para 6 of 14. Notice has been issued at annexure B 15. And
Where is the arbitration clause?
class is at page number 14, my lord. Para 6. In case of any dispute, then the parties here to resolve the same through Indian Arbitration Act before going to the court of law.
Memorandum of understanding.
Yes, my lord. And the notice is at page number 17, my lord, annexure C. And para 11, my lord, there is a reference to the arbitration and also appointment of retired district judge as an arbitrator. And page number 25, my lord, there is a dispute as regards payment of interest and all. Page number 25 and page number 29, my lord, para 11, they have said our client state that amendments made in para 11 of your notice and reply that your clients wanted to refer the matter to the arbitration with the retired district judge and session judge Sri Javed Pasha, for which our client requires some reasonable time to take decision of the same, and our clients are also willing to settle the issue amicably, provided your clients may claim with necessary proof and payments without resorting to lay a false imaginary claims against our clients. And that has been replied also, my lord. And till date, they have not come forward to even for a discussion also, my lord.
Issue notice to the respondent.
Much.
My lord, serial number 22 appear for the petitioners, my lord.
Yes.
My lord, I pray this court to withdraw this petition, my lord. As per the observation made by this court on the last date of hearing, my lord, the petitioners have to approach the appointing authority at clause number 6, that is at page 82, my lord. Henceforth, to approach the appointing authority, I pray for withdrawing of this present petition with liberty to approach this court in case the appointing authority does not.
On the previous date of hearing, well, on 5/6/2024, the following order was passed. Extract from the next para. Learned counsel for the petitioner today submits that the petitioners may be permitted to withdraw the petition and approach the International Center for Alternative Disputes Resolution (India). Full stop. Next para. The submission of the learned counsel for petitioner is placed on record. Full stop. Accordingly, the civil miscellaneous petition stands dismissed as withdrawn, while reserving liberty to the petitioners to approach the International Center for Alternative Disputes Resolution (India). Yes.
Much of it.
Please.
The petitioner in this case,
I'm part of the respondent in this case, ma'am.
petition under section 29A of Arbitration and Conciliation Act for extension of time for the completion of the proceedings.
29A.
Please. But we had filed a petition before the Honorable Commercial Court by referring to the
some changes that have happened
Please,
recently.
please.
Now, in view of a recent decision of the
Honorable Supreme Court, please, Justice.
To go back before the
Commercial. Honorable Justice Woka has passed the judgment recently.
Yes.
Plus, we had annexure M is the.
My lordship is the respondent, my lordship, in this case engaged the senior counsel, is Parvat Kolkar.
What is this? You have already held that they have to go before the commercial court. And you are saying you have to, senior counsel will come. For what purpose? ಅಲ್ರಿ ನಂದು ಆರ್ಡರ್ ಇಲ್ರಿ ಇನ್ನು ಬಂದಿಲ್ವಾ ರಿಲೀಸ್ ಆಗಿಲ್ವಾ I'll pass necessary orders because I've already passed orders in
Please,
another matter.
Please, I was about to bring to the notice of.
Same orders,
Please.
pass. Permitting them to approach the.
Lords, already we had approached. A date may be fixed and both the parties may be directed to appear in the same court, my lords. We had already filed the petition before the commercial court. By referring to the circular.
Cannot be pending now, sir.
My lords may kindly.
Pending now. You will have to file a fresh application. In view of the disposal of that application.
Please.
How can you now go before the commercial court and make submission in the same application? Not possible.
My lords directs both the parties to appear by fixing a date, then we'll approach the honorable commercial court in the same.
File an application now. Isn't it? It cannot be, that order cannot be passed on your previous application.
Lords, on merits, it was not been passed, my lords, by referring to the circular issued by
Sir, it
this.
has been disposed of.
True.
Isn't it?
True.
Then how can we direct the parties to appear in the same application? You will have to make out a case now on, in terms of the directions issued by this court.
Please.
And say I am filing the application now in view of the directions given by the High Court.
Please.
It has to proceed from that stage.
Please.
Yes.
Lords, both the matters are connected. Another.
Same order, same order.
Great.
23, 24.
Please.
Yes. Disposed of.
Petitioner in this case, my lords. My lords, we have filed for appointment of arbitrator.
Yes.
The respondent had taken loan of rupees 1 crore 40 lakhs from the petitioner. And she could not return, and that is why she.
Agreement of sale.
Yes, my lords.
It arises out of an agreement of sale.
Please, my lords.
2021.
21 minutes.
Where is the arbitration clause?
It is on page 34, my lords. Clause 9.
Yes.
We have filed A before City Civil Court. My lords, she has been placed ex parte.
Under section 9.
Please, my lords.
We are not concerned with that.
Notice.
Where is the arbitration notice? Where is the arbitration notice? You are required to issue an arbitration notice calling upon the other side for agreeing on an appointment of an arbitrator. You have not issued notice? Unless there is compliance of the requirement under section 11, arbitration, appointment of an arbitration is not permitted.
Please, my
You have to
lords,
call
we will
upon the
issue-
other side for appointment of an arbitrator. Only if it does not come forward, then the question of considering an application under section 11 would arise. So you have not issued arbitration notice.
We will do the needful, my lords.
Perfectly. Learned counsel for the petitioner fairly submits that the petitioner has not issued any notice invoking the arbitration clause. And therefore, the civil miscellaneous petition cannot be considered. Full stop. Next para. However, learned counsel for the petitioner seeks a liberty to withdraw the petition and issue notice to the respondent invoking the arbitration clause. Full stop. Next para. Placing the submission of the learned counsel petitioner on record. You have your Wakalat here?
Please, my lords. Yes.
The civil miscellaneous petition is dismissed as withdrawn while reserving liberty to the petitioner to proceed in accordance with law after issuing notice of arbitration to the respondent. Yes.
Serial number 26. I'm also appearing along with the Mr. Balraj. I may file Wakalat also.
Yes.
And the review is filed by a consent order given by the advocate for review petitioner. Actually, the matter.
Review petition.
Yes, please.
Yes, sir. This is a review petition. Unfortunately, the advocate, without knowing the factual aspect, he has given a consent for remand. Now he learned that because it was last working day of the court, he has given a consent for remand. It is a mistake of an advocate because he has not taken full instruction from the party.
You are not the learned counsel who appears.
Along with him, I filed Wakalat also.
Huh?
Both are.
Both of them have filed.
Yaro?
Yes, sir. It is also along with me, bro.
Sorry, I was not there. I too conceived.
Earlier, I had only appeared.
He had only appeared.
Yavdo?
Review petition.
Writ petition he had appeared.
In writ petition, brother, I was only appearing.
Yarge?
For the petitioner. So both are appearing for the petitioner only.
Annapurna Bordolai antide?
She is for the petition in WP. I am appearing for the respondent number 4 in the WP.
This review petition is filed by whom?
For the respondent number 4.
It is filed by the petitioner.
No, madam. Respondent number 4 in the WP.
Respondent number 4.
Respondent number 4 in the WP.
M. Muniraju.
Yes, please.
M. Muniraju or Muniappa.
Yes.
Muniappa is the petitioner and Muniraju is the respondent.
My lord, your lordship, after passing the order observation, the learned counsel Jairaj admitted for remand at the para 5 of the order your lordship has passed. Because on the basis of remand order, now the proceedings are initiated. Factually, my lord, the party has not given full instruction. The reason was before the assistant commissioner, the review petitioner had filed an appeal before the assistant commissioner, making only Tahsildar as a party. Because registered document was out of 1 acre 21 guntas, 1 acre 10 guntas, 11 guntas was only sold, for which he has given a consent. But unfortunately, Tahsildar committed a mistake, entering 1 acre 21 guntas. Therefore, he approached, only made the Tahsildar revenue inspector as a respondent before the assistant commissioner, and the Tahsildar as a party, and it was against which the present petitioner had filed a review challenge that the authority has considered the matter in length, and he claims additional 10 guntas by way of an agreement. That is not permissible. Now he is claiming a 10 guntas of land on that basis. Additional, we have no objection for 1 acre 21, 11 guntas, but only for 10 guntas.
All that you have to say before the assistant commissioner. Why have you come back before this?
No, my submission to your lordship may kindly see. The open before the division, this full bench of this court has already held, because a person claiming a civil right, he has to approach civil court. So far as 10 gunta is concerned only for limited request, I am requesting. The lordship may kindly, I request, of course, your lordship, because I have given a consent, but that consent was without knowing this aspect. Now, therefore, I request, because 10 guntas is, but Pune revenue authority cannot decide, because they claim additional 10 guntas. For 1 acre 11 guntas, there is no objection. Registered document. Therefore, I request.
Sir, I have not said anything on the merits of the matter. I remanded the matter back to the assistant commissioner. All these submissions have to be made before the assistant commissioner.
No, my submission, your lordship, in the writ petition, for the first time he claimed that additional 10 guntas. That is not his.
We have not touched anything in respect of the merits of the matter.
Your lordship, correct, your lordship.
ನೀವ್ ಹೇಳ್ತಾ ಇರೋದು ಏನಾದ್ರು ನಾವು ರೆಕಾರ್ಡ್ ಮಾಡಿದೀವಿ
Sorry,
What
your
is this,
lordship has not fluctuated.
Why do you want to unnecessarily file this kind of petition?
No, my
Waste of
request-
time.
My request is because floodgate open agutte anta only request. That is only a request. I am not only persuading this court. Because 10 guntas ಬಗ್ಗೆ 1 acre 11 guntas we have no objection.
Yeah, I have not understood what is the grievance. Ian, what is the grievance?
What happened? The petitioner had purchased an extent of 1 acre 10 guntas out of 1 acre 21 guntas.
From whom?
From the father of the respondent number 4, madam. So what happened? We are approached before the assistant commissioner by challenging the mutation entries. So mutation was entered by the Tahsildar in respect of 1 acre 21 guntas instead of 1 acre 10 guntas. Without arraying the petitioner as a party before the assistant commissioner, the appeal was allowed. So my lordship was observed. So without making as a party, the order passed by the assistant commissioner was not good. Therefore, the remaining
That is remanded to the assistant commissioner. Should you not make the submissions before the assistant commissioner now on the merits of the matter? Why have you filed the review petition then?
On the basis of registered sale deed, they are entitled for.
Because
That is something to be considered by the assistant commissioner. That would be on the merits of the matter. Why have you filed the review petition then?
Because a consent was given, that should not be happen. Only for that limited purpose we have.
Consent ಏನು ಇಲ್ಲ sir. There is no consent recorded.
No, your lordship, because consent
I have recorded
for
the
remand.
fact
Okay, only
that
consent for remand.
The order was passed without impleading the concerned aggrieved party. And I have remanded the matter so that opportunity will be given to the petitioner.
At this
You will be heard.
My request, your lordship may kindly consider. At least a limited period of disposal may be given, because it was otherwise it will drag on, because covered by the full bench judgment. Only a request, remanded, your lordship may say within 3 months disposal, so that it will be disposed. Only with this request only a request.
Learned HCDP. The Sheshu is requested to take notice for response number 2 to 4. Notice to respond number 1 is not necessary for the following reasons. Next para. This review petition has been filed by Sri M. Muniraju, who was respondent number 4 in the writ petition. Full stop. This court, in the writ petition, while noticing the fact that orders were passed by the assistant commissioner and the deputy commissioner acting under the provisions of section 136 bracket 2 and bracket 3 of the Karnataka Land Revenue Act of 1964 had passed orders without the petitioner.
Only by the assistant commissioner, not by the DC.
No.
The deputy commissioner, the appeal filed by the petitioner only, madam. Appeal filed by the petitioner only, in the writ petitioner.
Deputy commissioner.
Writ petitioner has only approached before the deputy commissioner by challenging the order of the assistant commissioner, madam.
Learned counsel submits that when this aspect of the matter was brought to the notice of the deputy commissioner, the deputy commissioner has not considered such submission and has simply dismissed the revision petition.
Yes, revision petition filed by the writ petitioner, madam. The contention of the writ petitioner, the deputy commissioner has not considered the case of the.
Correct.
But they have only approached before the deputy commissioner by challenging the order of the.
That I have understood. ಏನು ಹೇಳಿದೆ? By the assistant commissioner, by the deputy commissioner, the assistant commissioner, without issuing notice to the petitioner, who was the aggrieved party. Full stop. It was further noticed that even the deputy commissioner did not take note of the grievance of the petitioner. Full stop. Therefore, the writ petition was partly allowed while setting aside the orders passed by the assistant commissioner as well as the deputy commissioner, and the matter was remanded back to the assistant commissioner. to reconsider the matter while giving opportunity of hearing to the petitioner. Full stop. Next para. This court does not find any grounds to allow the review petition. Full stop. Nevertheless, the review petition stands disposed of with a specific direction to the Assistant Commissioner, Bangalore North Subdivision, to dispose of the appeal as expeditiously as possible and at any rate within a period of 3 months from the date of receipt of a copy of this order.
Grateful.
Your Lordship, serial number 27, 2 weeks time. For complaints of office objection, 2 weeks time is paid.
2 weeks.
2 weeks.
2 weeks are granted at the request of learned counsel for petitioner for complaints of office objections. 27 ಆಯ್ತಲ್ರಿ 28 ಇದು. ಅವ್ರು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ ಇವಾಗ.
For the petitioner in this case, my lord.
My lord, I may permit it to appear on behalf of respondent 1 and 2, my lord. I am filing Wakalat.
Learned counsel Sri
AC Balraj.
AC Balraj undertakes to file Wakalat on behalf of the respondents.
1 and 2.
Both of them.
Both of them.
Stop.
I have no papers.
Huh?
Papers. Because through paper publication, we have got knowledge. These proceedings. We don't have papers.
Next para. In that view of the matter, the paper publication taken out by the petitioner is accepted. Full stop. Next para. Learned counsel for the petitioner is directed to serve copies of the petition along with annexures from the learned counsel for the respondents. Full stop. Release this matter on 25th of June 2024 to enable the learned counsel for the respondents to secure instructions and make submissions.
With much of.
Yes.
24th, my lord.
24th.
26 in it. After 25.
26th.
Yes. Much obliged.
For the petitioner in this matter, my lord, the
Respondent number 1 to 6.
my lord, the parties entered into a JDA, my lord, in the year 28/11/2007. My lords, agreed by the conditions in the JDA, my lords, the petitioner, my lords, approached the, my lords, the respondents are landowners of survey number 51/1, 41/1, 41.
Objection?
No, appointment of arbitrator, I have no objection. Appointed. As per the direction.
What is the claim amount?
My lords, claim amount is 1 crore, my lords. 1 crore plus 2 crores, my lords, totally.
So we'll appoint a retired High Court judge.
Please, my lords.
Second paragraph. On issuance of notice to the respondents, learned counsel, Srikantha, AS,
yes,
has entered appearance on behalf of the respondents.
1 to 6. 1 to 6. The 7 was expired.
1 for expired.
For respondents number 1 to 6.
Yes.
Full stop. Learned counsel would also submit that respondent number 7 is no more.
Yes. That is for deletion, the appellant has filed the memo.
Before the trial judge only we filed. We filed a memo before the trial judge only and we got it deleted. My lords.
Trial judge.
The earlier. In the commercial AA, my lords.
That we are not concerned with that one.
Please, my lord.
Have you not filed a memo here?
We have filed, my lords.
Huh?
For deletion.
Here also.
Here also we have filed, my lords.
Yeah, and it is deleted, is it?
Please, my lords.
It is permitted to be deleted?
Please, please.
By which order?
The last date of hearing, my lord, it has been adjourned for appropriate
Carrying
order.
On
Fact.
10/4.
By order dated 10/4/2024, this court permitted deletion of respondent number 7. You not carried out the amendment. You should round it off and say, by this order, respondent number 1 is deleted.
My lords, carry out.
Please do it now.
Please, my lords.
However, learned counsel for the respondents fairly submits that this court may proceed to appoint the arbitrator to decide the list between the parties. Full stop. And next paragraph of complaints. Amele. Shall we appoint Justice H.G. Ramesh?
Please, my lords.
Huh?
Please, my lords.
Yes. Yes.
My lord, emergent notice was in fact issued on the registered address of the respondent company, my lord. But it has come back as no such firm at that address, my lord. Believe they're intentionally evading notice. May I seek for notice to be issued by hand, my lords?
But it will be difficult to accept even if you file an affidavit.
Please, my lord.
It will be difficult. Along with the notice, we will permit you to take out hand summons.
Please, my lords.
Huh?
Please, my lords.
Issue fresh notice to the respondent. Full stop. The petitioner is also permitted to take out hand summons
Please, my
to
lord.
the respondent.
Please.
Yes.
Memo for kindly be submitted withdraw the petition.
The challenge to the writ petition is the notice issued by the municipalities at Annexure T. And the petitioner has obtained the interim order from the Honorable Court. But in the event, my lord, if the petitioner wants to withdraw the writ petition, the interim order should not tenure to the benefit of the petitioner.
You know, what was the grievance?
The notice was issued as per Annexure T.
Huh?
That
The second respondent.
on the representation made by the petitioner to give a NOC for the purpose of getting the electricity supply from the CESCOM, that the notice was issued as per Annexure T that there is a violation in the
Page number?
Page number 87.
87.
Please. May I read, madam? ವಿಷಯ ಸೊರಬ ಪುರಸಭೆ ವ್ಯಾಪ್ತಿಯ ಮಾರ್ಕೆಟ್ ರಸ್ತೆಯ ವಾರ್ಡ್ ನಂಬರ್ 7ರ ಖಾತೆ ಸಂಖ್ಯೆ ವರ್ಗಿನ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಎನ್ಒಸಿ ನೀಡುವ ಕುರಿತು ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರ ಪತ್ರದಲ್ಲಿ ಟೌನ್ ಮುನ್ಸಿಪಲ್ ಸೊರಬರವರ ಪ್ರತಿವಾದಿಯ ಮಾಡಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವೆ ಇರುವುದು ಸರಿಯಷ್ಟೇ. ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ತಮ್ಮ ಖಾತೆ ಸಂಖ್ಯೆ ಮತ್ತು ಶ್ರೀಮತಿ ರೇಖಾ ಪ್ರಶಾಂತ್ ಅವರ ಹೆಸರಿನಲ್ಲಿದ್ದು ಪುರಸಭೆ ನಿಯಮ ಉಲ್ಲಂಘನೆ ಮಾಡಿ ಭೂಗಡಿ ಅಂಚಿನಿಂದ 6 ಮೀಟರ್ ಸೆಟ್ ಬ್ಯಾಕ್ ಬಿಡದೆ ವಾಣಿಜ್ಯ ಕಟ್ಟಡವನ್ನು ನಿರ್ಮಾಣ ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಸದರಿ ವಿಷಯದ ಬಗ್ಗೆ ಈ ಕಚೇರಿಯಿಂದ ಸ್ಥಳ ಪರಿಶೀಲನೆಗಾಗಿ ದಿನಾಂಕ 22/11/22 ಸಂಜೆ 4 ಗಂಟೆಗೆ ಸದರಿ ಕಟ್ಟಡ ತನಿಖೆಗಾಗಿ ಸಮಯ ನಿಗದಿಪಡಿಸಲಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ತಮ್ಮ ಸಮಕ್ಷಮದಲ್ಲಿ ಕಚೇರಿಯ ಕರ ವಸೂಲಿಗಾರರು, ಕಂದಾಯ ನಿರೀಕ್ಷಕರು, ಪ್ರಭಾರ ಕಂದಾಯ ಅಧಿಕಾರಿ ಮತ್ತು ಜೂನಿಯರ್ ಇಂಜಿನಿಯರ್ ಅವರು ಜಂಟಿಯಾಗಿ ಸ್ಥಳ ತನಿಖೆ ಮಾಡಲಾಗಿದ್ದು, ಕಟ್ಟಡದ ದಕ್ಷಿಣ ದಿಕ್ಕಿಗೆ ಮುಖ್ಯ ರಸ್ತೆ ಕಮಟ ಕಡಮುಡಗಿ ರಾಜ್ಯ ಹೆದ್ದಾರಿ ಅಂಚಿನಿಂದ ಸೆಟ್ ಬ್ಯಾಕ್ ಬಿಡದೆ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ತಾವು ಹೆಚ್ಚುವರಿಯಾಗಿ ನಿರ್ಮಾಣ ಮಾಡಿರುವ 20x50 ಅಡಿ ಕಟ್ಟಡವನ್ನು ಈ ಕೂಡಲೇ ತೆರವುಗೊಳಿಸಿ ಈ ಕಚೇರಿಗೆ ಲಿಖಿತವಾಗಿ ಛಾಯಾಚಿತ್ರದೊಂದಿಗೆ ವರದಿ ನೀಡಿದಲ್ಲಿ NOC ನೀಡುವ ಸಂಬಂಧ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ವಹಿಸಲಾಗುವುದು. NOC was sought for the purpose of obtaining electricity supply to the building constructed by the petitioner. This was notice issued to the petitioner. This has been stayed by this honorable court on 11/1/2023. But my apprehension is that, taking advantage of the interim order, if the petitioner obtains NOC from the, or if the petitioner obtains the electricity supply from the CH-08.
See what memo has been filed. The copy has given to you?
11.
Copy ಕೊಡಿ ಅಮ್ಮ ಅವ್ರಿಗೆ. Please give a copy. You ಓದಿ. Please read that memo.
The petitioner in the above writ petition has sought for in all 5 reliefs. The second respondent has assured the no objection certificate, that is prayer B, that is pursuant to the interim order granted by this honorable court. And has assured that not to implement the impugned notice dated 30/11/2022 produced at Annexure T to the writ petition, and the petitioner and the second respondent has assured to the issue occupancy certificate and agreed to consider prayer D of the writ petition, that is to make proper alignment of the UGD in front of the complex building, and in the circumstances, the petitioner seeks permission to withdraw the above writ petition with liberty to approach this honorable court in the event failure of the second respondent to consider prayer C and D by allowing this application.
Lama, they wanted to take action against you for putting up a construction in violation of the sanction plan and in the setback area. You came before this court. You obtained an interim order.
Kindly pass over.
Instruction.
Kindly pass.
We currently have it 2 weeks, but I'll ascertain from the municipality with regard to the memo for withdrawal filed by the petitioners.
We will reject it. This. If that is so, on the basis of your objection, we'll reject it.
That is what in the memo of withdrawal it says that the municipality has.
Can't take advantage of the interim order and withdraw the writ petition.
Next week. Next week any date.
Pass over. We'll pass over. Please get your senior. Pass over.
Yes, I appear for the decision. The matter was referred to the mediation. In the mediation, the matter was settled. The terms and condition was that the petitioner is going.
Mediation.
Idrulagade, on the building, it is 80-year-old building. It was in dilapidated condition. Where, my lord, the petitioner was the owner of 90% of the building and the respondent is owner of the 10%. Whereas, my lord, since it was not in a good condition, that building needs to be demolished. For that, respondent has objected. For this, my lord, there was a proceeding before the corporation. Corporation has passed an impugned order wherein it has directed both the parties to repair the building. That order has been challenged. During the pendency of the writ petition, my lord, the matter was referred to the mediation. In the mediation, my lord, the petitioner has offered to buy the property of the petitioner by the respondent.
You are the owner of 10% of the building.
No, I'm 90%.
90%.
Yes, my lord. Now, the other side.
Respondent has got only 10%.
Yes. Then, my lord, there was an offer by the petitioner to purchase its property. For that, they refused. Then they gave offer to purchase their property. For that, we have agreed with certain conditions. My lord, we have said that, my lord, the khata of the single khata has to be made and property has to be demolished and handed over. For that, 3.5 crores was the value. For that, we paid 10 lakh rupees as advance. But thereafter, the respondent, it seems, was not well. She was hospitalized. and it could not move from there. Now also we are ready to buy that property, whatever we have agreed. The only thing is that they have to get the single khata for the property and conversion, they have to make it. That was the condition which was agreed before the mediator. If they need some time, my lord, we have no objection, we'll wait. It can be, otherwise, my lord, even it can be referred back to the.
Is there any photograph of the building?
Yeah, yes, my lord, I have.
No, my lord.
In connected petition.
Now, only difference is, my lord, earlier, my lord, as it is inside building, my lord, entire building is also. I produced my
In
my
the
writ petition,
WP 26165,
in my writ petition.
there is a photograph.
Innೊಂದು petition ಕೊಟ್ಟು ಅದು ವಾಪಸ್ ಕೊಟ್ಬಿಟ್ರೆ.
Yes. ಇಲ್ಲ ಒರಿಜಿನಲ್ ಇದೆ ನೋಡಿ.
ಯಾವ್ದ್ರಲ್ಲಿ?
26.
ನನ್ನ writ ಅಲ್ಲಿ.
Our writ petition and photos.
I will look, man. Front portion. It's a big complex, my lord, where, my lord, he has purchased some, not 90%, my lord. We are having some 3 cents in that, my lord. Agreed was, my lord, as is various condition they wanted to purchase, my lord, we agreed. No, my lord, they, after demolition of entire building, they, after obtaining a single layout plan, where the door number is there, my lord, single layout cannot be granted.
You have 10% with you.
Yes, we agreed, man. We agreed to.
So agreed to give it up.
Yes, man. We agreed.
Huh?
Yes, man.
You have to purchase it.
Yes, man.
Yen problem in.
Now condition is, my lord, we have to demolish and give to him. This, my lord, is.
They are retaining some portion of the property in that.
Portion of retaining.
No, apart from this 10%, there is, behind that, they have got their own property that they have agreed, they said that they will not give it. We have no objection.
Sorry.
Whatever the building which is in existence and whatever we have agreed, that they have to demolish, and the demolition has to be made by them. The reason is this, my lord, they will not allow, they create the problem. The respondent.
After selling the property, how
I
can
will sell
Again-
it, everything.
Again, there is a confusion with regard to the measurement and other things. They want to retain something, some portion and all those things. We want to know that what exactly they want to do it. It is in dilapidated condition. So we said that the 3.5 crores is a very fancy price that we have agreed to pay. With the condition that they have to do these 2 things.
Yen ಮಾಡ್ಬೇಕು?
They have to get a single khata. Now there are 2 portions.
It's not in their hands.
No, my lord, they can approach and get it.
No.
No, certainly, my lord, they can approach and get it.
ಖಾತಾ ಇದೆ ಇವಾಗ.
2 khatas are there in their the portion.
How can there be 2 khatas in respect of one building?
They have
Shop. There are 3
shops
shops.
and something.
3 shops. It is door number is there, my lord. Building plan is already sanctioned. Door number is given. What he says now, after demolition, my lord, single layout khata, I have to get it done and give it to him. That is not the condition. How can I can?
I'm not asking single khata for my building, my lord. Whatever the
ನೀವು ಪ್ರಾಪರ್ಟಿ ಕೊಂಡ್ಕೊಂಡ ಮೇಲೆ ನೀವ್ ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ಈಗ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗೋದಕ್ಕೆ ಸಮಸ್ಯೆ ಇದೆ. We approached the sub-registrar, they said that there is a problem with their khata.
ಏನು?
There are 2 khatas in their name. Either it has to be merged and they have to sell it. Here, there, my lord, conversion is also a problem. It is in Mangalore city. They have got some technical problem over there. That was brought to the notice of the respondent. The respondent initially agreed to do that. But afterwards, they said they have come up with the counter argument stating that you have to do it and all those things. We said we are giving the fancy price considering these facts. Again, we cannot spend money on those things. Otherwise, price has to be negotiated further. For that, they took time. Thereafter, it seems respondent was not in her health was deteriorated. She was hospitalized. From there, it was stopped and it has not.
Appearing for the Mangalore City Corporation.
Mr. Harish
Bhandari.
Harish Bhandari. Where is he?
Only dispute is that, man. What he says, I have to demolish and I have to get it a single layout khata. That is his condition. That too later, after 6 months.
No,
mediation
not after
period.
6 months. It is the first condition which was discussed before the court, before the mediator.
Sir, building itself is going to fall down now.
My lord, they are not allowing us to do that.
Who?
The other respondent.
Once they sell the property,
For
everything is
selling,
in your hands.
yes, my lord, selling, there is a technical problem. If they resolve it, we will have no objection.
You are saying they have got 2 khatas in there.
Yes, my lord, there is a confusion because they are retaining the behind portion of the property, which is, we don't want it. But there is a clubbing of the portion of that property with this, And they are asking that they will create further problem. Tomorrow, if I buy it and if I go for demolition,
Please show the Khata.
my lord, that hasn't produced, I will produce it with exact problem, my lord, that I will bring it to the notice of the.
Another landman, not in this building.
No,
What
just
is it?
behind that. It is not.
That is.
ಇಲ್ದೇ ಇರೋದನ್ನೆಲ್ಲ
ಇಲ್ಲ 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 ಅದು
ಊಹೆ
ಇಲ್ಲ ಆ ತರ ಇಲ್ಲ ಅಲ್ಲಿ ಸುಮಾರು ವರ್ಷದಿಂದ they fought.
clarified in the presence of the learned counsel for the corporation.
Yes, my lord, that can be done. That can be done.
Please get him.
Please.
Please get Mr. Arif Bandar. Pass over.
$230.
Huh?
230.
ಬನ್ನಿ ಅವ್ರು ಕರ್ಕೊಂಬನ್ನಿ ಇದು ವಾಪಸ್ ಕೊಟ್ರಿ ಅವ್ರಿಗೆ.
Lords, leave, my lords. Kindly pass over the matter, my lords, because I left my specs in the car, so.
ಬಂದ್ರೆ ಅವ್ರಿಗೆ ಬನ್ನಿ. You please wait. We'll take up the previous matter. ಕೊಟ್ರಿ ಅವ್ರಿಗೆ ಇವತ್ತು ಖಾತಾದು ಕಾಪಿ ಇದ್ರೆ ಕೊಟ್ರಿ, ಪ್ಲೀಸ್ ಗಿವ್. You are aware of the facts of this case?
Yeah, no, it's an old building.
Now they went before the mediation center, Bangalore Mediation Center. They have agreed. This person has got 10% share in that building. He has agreed to sell it to the petitioner. Petitioner has also agreed to purchase it. Now they are finding some difficulty having regard to the khatas executed in your office. They are saying he has to get the khata amalgamated and so and so, so and so. Please go through the khata and tell what is the difficulty. Pass over. Kodi avrige. Kodi adella kottu avrige torsi.
Yes.
Let him take instructions and make submission.
Please.
Otherwise I'll have the matter day after tomorrow.
Yes, day after.
You please take instructions.
Yes.
Learned counsel for the petitioner submits that the rival parties have agreed and arrived at a settlement. Full stop. The contesting respondent number 4, who has 10% of share in the petition scheduled property, has agreed to sell the same in favor of the petitioner. Full stop. However, there appears to be some difficulty having regard to the khatas standing in the name of the fourth respondent. Full stop. Next para. Learned counsel Sri Harish T. Bandari, appearing for the respondent, Corporation of the City of Mangaluru, is requested to take instructions from the corporation regarding the grievance of the parties. We'll stop. Next para. Release this matter on 14th of June. Yes. ಈಗ ಇದ್ರಲ್ರಿ
ಅದೇ ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಶೀಟ್ ಮೇಕಂಡ್
Kindly pass over, my lords. Actually, Swami, no, it's very weird reason for which I'm asking for passover.
One ನಿಮಿಷ. Forming of layout.
There is actually a wrong submission ಇದರಲ್ಲಿ. ಏನಕ್ಕೆ ಅಂತ ಹೇಳಿದ್ರೆ, way back in the year 2014 itself, layout form ಆಗಿದೆ, ರೋಡ್ ಎಲ್ಲ ಇದೆ ಅಲ್ಲಿ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಪಂಚಾಯತ್ ಮೆಂಬರ್, ಅವ್ರ ಮೆಂಬರ್ ಏನೇ ಒಬ್ರು ಮನೆ ಕಟ್ಕೊಂಡು ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಕನೆಕ್ಷನ್ ತಗೊಂಡು ಪಕ್ಕಾ ಮನೆ ಕಟ್ಕೊಂಡಿದ್ದಾರೆ ಅಲ್ಲಿ, 2 story ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಕೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಈಗ my only contention is this. My only contention is that since the year 2014, I've been making constant representations before all the authorities, including the DC. DC conducted a spot inspection. At spot inspection ಮಾಡಾದ್ಮೇಲೆ, in the Tashidar's report, that is R2's report, my lord, which is filed before this honorable court, a layout has been shown, my lord. It's a part of the court record.
Now you have come before this court.
Yes, my lords, I have come before this
With
court.
what grievance?
My lords, my only grievance is that let there be allotment for the petitioners, my lord. Petitioners 1 to 14. Let the property be allotted to petition number 1 to 14 anta Swami.
Why?
The reason being that is, ನಾವು ನಮ್ಗೆ ನಿರ್ಗತಿಗಳು ನಾವು ಬಂದ್ಬಿಟ್ಟು ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀವಿ, ಯಾವುದೇ ಕ್ರಮ ತಗೊಂಡಿಲ್ಲ ಅವರು. ಇನ್ಫ್ಯಾಕ್ಟ್ my lords, that's the reason why I wanted to have a passover. There is one document which I want to draw my lords' kind attention to. My lords, annexure H nodi Swami, along with my petition.
Page number?
Page number. Page number. 39, my lords. Annexure H. My lords, this is the particular document which is issued by none other than R4, my lord, saying that this person is residing there. And why is this particular document was issued? For the purpose of issuance of Aadhaar card, my lords. ಯಾಕಂದ್ರೆ ನನ್ನ ಹತ್ರ ಬೇರೆ ಏನು ಇಲ್ಲ ನನ್ನ ಹತ್ರ. ಲೇಔಟ್ ಫಾರ್ಮ್ ಆಗಿದೆ, DC ಅವ್ರು ಬಂದ್ಬಿಟ್ಟು ಆಸ್ ಪರ್ ದಟ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಡೈರೆಕ್ಷನ್ಸ್ ನಾವಲ್ಲಿ ಕಟ್ಕೊಂಡ್ವಿ, ನಾವು ಕಟ್ಕೊಂಡು ನಾವು ಇದೀವಿ. ಅಂಡ್ ಸಿನ್ಸ್ ದೆನ್ ವಿ ಬಿನ್ ಆಸ್ಕಿಂಗ್, DC is also telling that directing respondent number 4 to conduct the meeting and give it to people who are eligible. That meeting has not been conducted from 2014 onwards. It's been 10 years. ಅದೇನೆ ಪಂಚಾಯತ್ ಮೆಂಬರ್ ಆಯ್ತು ಅಂತಂದ್ರೆ ನೋಡಿ ಸ್ವಾಮಿ, ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಕನೆಕ್ಷನ್ ಪ್ರತಿಯೊಂದು ಇದೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಐ ವಾಂಟೆಡ್ ಟು ಸಬ್ಮಿಟ್ ದಿಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂಡ್ ದಿಸ್ ಬಿಲಾಂಗ್ಸ್ ಟು ದಟ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಹೌಸ್ ವಿಚ್ ಇಸ್ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಬೈ R4's member, my lord, on a property which was supposed to be granted to one of the people who are eligible. Plus, the other contention which was taken up was R40, petition number 15 is a temple. Temple kattak barala anta heliddu. 1 to 14 has got nothing to do with the temple. As regards the temple is concerned, this writ petition has already been dismissed. Now, if the temple was to be demolished, not to be demolished, that is a thing which the respondents have to take a decision on that, my lord. But as regards 1 to 14 are concerned, my only grievance is that not only from 2014, my lords, even way back, they were residing there. They themselves brought it to the notice of the R2, that is the DC. And the DC has specifically stated that. Lux, one other letter, my lords. That is the DC's order. It is submitted along with the report furnished by the Tashildar, my lord. That is the R4's objections, my lord. The very next page, the date is 3/9/2016, my lord, where the DC directs to conduct a spot investigation. And, my lords, based on that spot investigation, at page number 6, my lord, 6 of the report submitted by Tashildar, my lord.
Objection?
No, I filed statement of
You have filed statement objection. What is your stand?
ಅದೇ ನಾವು ಹೇಳಿದ್ದು ಏನಂದ್ರೆ, they are residing in the, my lord, address given in the cost title. They themselves are given an address in the cost title. They are not residing here because according to them they are residing in, my lord, the cost title, the address of the kind of looked into. ಎಲ್ಲ 1 ರಿಂದ 14 ಜನ. ಅದು ನಾಟ್ ದಿಸ್ ಪ್ಲೇಸ್.
ಅದಿರಲಿ.
ಇಲ್ಲ,
What is your contention?
Yes. Now, unless that encroachment is removed, we are not in a position for road or
So
site.
what do you say if he is presenting the documents showing sites have already been formed and it has been allotted, and one of your members has put up construction there, electricity supply is given,
Swami.
would it not be contrary to your?
ಇದು ಓರಲ್ ಸಬ್ಮಿಷನ್ ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಇಲ್ಲ.
I'll place it on record.
ರೈಟಿಂಗ್ ಅಲ್ಲಿ
I'll place everything on record.
ಏನು ಇಲ್ಲ.
All perfect.
ಇದು ಯಾರು ಅಲಾಟ್ ಮಾಡಿದ್ರು ಏನು ಬೇಕಾದ್ರೆ ಫಾರ್ಮೇ ಹಾಗಾದ್ರೆ ಅಲಾಟ್ಮೆಂಟ್ ಎಲ್ಲಿ ಬರ್ತದೆ ಸ್ವಾಮಿ?
Seeks for a short accommodation to place on record certain documents which would show that a layout has already been formed on the land in question and sites have been allotted in favor of persons who are not eligible, comma, which includes one of the present sitting members of the Gram Panchayat. Full stop. Learned Counsel submits that he has with him documents which would show electricity supply given to such a house constructed by
Such houses.
a member of the Gram Panchayat.
Such houses. The judge are not just one.
Similarly, many such houses have been constructed and electricity supply are also given to such houses. Full stop. Next para. Release this matter.
ಅಲ್ಲ ಇದು ರಿಟ್ಪಿಷನ್ ಏನ್ ಹೇಳಿದೆ ಹೊಸದಾಗಿ ಏನೋ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ಇಲ್ವೇ ಅಲ್ಲ ಸುಮ್ಮನೆ ಈಗ ಯು ವಾಂಟ್ ಟು ಪೋಸ್ಟ್ಪೋನ್ ಇಟ್ ಬೈ ಸಮ್ ಅವರ್ ಇಲ್ವೇ ಇಲ್ಲ. ಅಲಾಟ್ಮೆಂಟ್ ಇಲ್ಲ. ಯಾರು ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದು? ನಮ್ಗೆ ಮಾಡಕ್ಕೂ ಬರೋದಿಲ್ಲ ಅಲಾಟ್ಮೆಂಟ್ ಬೈ ದಿ ಆಶ್ರಯ ಸ್ಕೀಮಲ್ಲಿ ಇದ್ದದ್ದು ಗ್ರಾಮ ಸಭಾದಲ್ಲಿ ಸೆಲೆಕ್ಟ್ ಆಗಬೇಕು.
ಹೌದು ಸರಿ, ಬಟ್ if that fact is true,
ಫ್ಯಾಕ್ಟ್ ಟ್ರೂ ರಿಟ್ಪಿಷನ್ ಹೇಳ್ಬೇಕಿತ್ತು. ಈಗ he want to prolong it, that is why.
subsequently it has come to his notice that this is the information, he wants to place it on record. You also put it to your clients. Find out.
If it is possible, it should be dismissed with cause. That is what I submit.
No, if it is found to be true.
Found to be true, I submit. Yes.
So therefore, you also have to take instructions.
Yes.
We will permit you to place it on record.
Yes.
A copy will be given to you.
Yes.
You give it to your clients and secure instructions.
No, his object is to postpone it as much.
No, my object is not to postpone. I think ಮನೆ ಬೇಕಿದೆ ನನಗೆ.
Once a house to be allotted.
ಅಲ್ಲಲ್ಲ ಇದೆಲ್ಲ ಇದೆಲ್ಲ rich people come into the court and say that we are encroached. It may be granted to us. Ultimately it comes to that.
ಏನ್ ಹೇಳ್ದೆ? Release this matter on 19th of June 2024.
Either 18th or 20th, Swami. 19th on personal inconvenience.
20th.
Sorry.
Comma, the learned, before which the needful shall be done by the petitioners.
Sorry.
Stop. A copy of
I'll serve them.
information sought to be placed on record shall also be made available to the learned counsel for the respondent Gram Panchayat.
7.
Huh?
Respondent 7.
Gram Panchayat, yes.
Much obliged.
This matter inspection report is ready.
Petition in this matter.
Inspection is conducted, it's ready. I will file it in the counter, my lords.
Huh?
Inspection report is ready, my lords.
Inspection report.
This
Matter pertains to a property for which measures 2,150 square feet.
Do you have a copy of the inspection?
No,
report?
I do not have copy. Just summarizing what it is.
Learned counsel for the respondent BBMP submits that the inspection report is ready.
I will file.
Stop. Learned counsel is requested to file the same in the office during the course of the day. Full stop. A copy of the same shall be served on the learned counsel for petitioner. Full stop. Release this matter on 19th of June.
Obliged.
Appearing for the respondent BBMP. Spot inspection may be directed, your lordship.
It is not conducted.
No, your lordship. We have received the petition on the last hearing date.
the respondent, BBMP, more particularly, the third respondent, Assistant Revenue Officer, is directed to conduct a spot inspection in the presence of the petitioner on 18th of June at 11 a.m. and submit a report before this court. Full stop. A copy of the report shall also be served on the learned counsel for petitioner. Full stop. Release this matter on 24th of June.
In the meantime, your lordship may continue the.
The interim order granted earlier stands extended till the next date of hearing.
Okay.
The petition notes.
Inspection has been held.
But according to my instruction notes, inspection is conducted, my lords.
Is conducted.
Yes, my lords.
Release this matter on 24th of June 2024 to enable the learned counsel for the respondent BBMP to file the spot inspection report, while serving a copy of the same on the learned counsel for petitioner. Yes.
Date on them. Date.
But
They need to file the report, my lord, but
no.
there is one-time settlement offered by.
Want to
BPM.
avail of, you want to avail of the facility.
Well, yeah,
Huh?
they're in talks, so therefore I pray for short date.
The matter stands adjourned by 2 weeks to enable the petitioner to make use of the benefit of one-time settlement
Settlement, yes, ma'am.
announced by the respondent BBM.
Interim order may be
Full
extended.
stop. Interim order granted earlier stands extended till next date of hearing.
Much okay.
This case,
Petition in this matter, pray for a short accommodation to take steps against the respondent number 6, madam.
Huh?
Pray for a short accommodation to take steps against respondent number 6. We have instructed our clients
Original
to.
records by advocate respond for 3 to 5.
This case, my lordship.
Here is it.
Original record is there, my lordship. Last
Huh?
two, original record is there, my lordship. Last two date hearings, December court has.
What is the matter? What is the matter?
Questioning the order passed by the executive officer Talak Panchayat.
Huh?
Executive officer Talak Panchayat, questioning the.
Challenge an order passed.
India with next time, I prepare the objection also. At it,
Learned counsel for the respondent, Panchayat Development Officer,
yes, and also executive officer.
for the respondent Panchayats, submit that the original records have been secured, as directed earlier. Full stop. Nevertheless, learned counsel submits that statement of objections may be permitted to be filed at the hands of the respondent Panchayat. Full stop. A week's time is granted to the respondent Panchayat to file statement of objections.
So also respondent 7 to 9, I will also file it straight.
7 to 9.
7.
Private person.
And the other contesting respondents. Needless to observe that the original records shall be made available before this court on the next date of hearing also. Yes. Release this matter on 25th of June.
For the petitioner in this case, my lords, this honorable court, in the last date of hearing, my lords, this honorable court directed me to, with liberty to file a application for bringing the proposed respondent number 6 as a party, my lords. I have filed the application for the same. And I have served the copy on the other side also, my lords, the BBMP. Office has raised objection, my lords, sir. Work order has been issued to the proposed respondent number 6. And he is also proper and necessary party, my lords. For that reason, last occasion, this honorable court directed me to file a necessary application.
Contract for what?
For spraying the mosquitoes, this thing, my lords.
Fumigation.
Fumigation, my lords, without issuing me notice, my lords terminated me.
Ah.
And without clearing my balance of amount also, they have terminated me, my lords. For that I have challenged before this honorable court. During that time, I have filed civil suit also before the civil court, my lords. Injunction order was operating. In meantime, my lords, they have terminated me. I have challenged the same before this honorable court, my lords. At that point of time, they have issued work order to the proposed respondent number 6, my lords. That's why this honorable court last occasion directed me to file a necessary application to brought him on record. For that reason, I have filed amendment application and also filed amended petition also, my lords.
My lords, I appeal for respondent 125, BBMP.
Kindly issue notice to respondent number 6, my lords. I consider in my application.
Notice was not ordered?
Notice was not ordered to respondent number 6, my lords.
Issue notice to the proposed respondent on IA number 1 of 2024.
24. Date may be given. Same.
My lords,
Date may be given, my lords, in it.
Contract matter,
Please, my lords, because he is doing a coolie work, my lords. Without clearing, there is lot of balance from the BBMP, my lords. Without clearing that, my lords, he has purchased investing so much of money, purchased the missionaries. Because of the political influence, the government has changed, my lords, they have terminated the petitioner, my lords.
Release this matter
may submit.
on 25th of June.
Lords, at Annexure A, if my lordships were to, please, Annexure A nalli, Swami. There were a lot of complaints that were received, almost about.
We'll consider.
Please.
Ah.
And 2
25th.
notices were given, my lords, and he was heard also.
Yes.
Please.
Hmm? 41.
Inspection was ordered, my lords, last occasion. My inspection is agide ante.
Agidya?
The spot inspection is carried out, your lordship.
The report is not.
The report has come today. We will be filing.
Learned counsel for the respondent BBMP submits that the report is ready.
Yes, your lordship.
Full stop. Learned counsel is requested to file the same in the office during the course of the day.
Yes, your lordship.
While serving a copy of the same on the learned counsel for petitioner.
Lordship,
Full stop.
I'll file it tomorrow with your permission.
By tomorrow. Release this matter on 20th of June.
Much.
Yes.
Public.
Point number 6, 7, 8, and 11.
For the petitioner in this matter.
I request for us. Well, I undertake to file Wakalat on behalf of respondent number 12.
Lordship.
My lord, in serial number 42, MS Harinath has filed Wakalat on behalf of respondent number 3 today morning, my lord. My name may be shown in the cause list.
In WP number 7384.
Exactly, my lord. Exactly, my lord.
Learned counsel Sri
MS Harinath.
MS Harinath.
Yes, my lord.
Submits that he has filed Wakalat on behalf of respondent number 3.
3, my lords.
In WP number 7384 of 2024.
Exactly, my lord.
Office to verify and show the name of the learned counsel in the cause list.
Much obliged.
My
And I may be permitted to file objections. My lord.
The short question is involved, my lord. GMC, my lord. Section 8 application filed before the civil court has been allowed. That has been challenged, my lord. Section 8 under Arbitration Act has been filed, my lord, by me. before the learned civil court. There is an arbitration clause that exists in the agreement. The civil court has no jurisdiction. The civil court appreciating that, my lords, referred the matter for arbitration. That has been, please.
Refer the matter.
Under section 8, my lords, the application was allowed. My lords,
My lord, if I may submit, my lord. If I may submit, my lord. My lord, I am one of the partners in a partnership firm, my lord. The partnership firm was constituted in the year 2020. Two of the partners died in the year 2021. Immediately upon the death of the partnership, one of the sons of the partners, namely Nagapaya, filed a suit saying that he is the only shareholder in the partnership, according to the will that was executed by the father. Therefore, the partnership deed, whatever the share to the extent of his father, requires to be transferred in his name. As per the partnership deed, my lord, if you can peruse page number 49, it says if there are more than one LRs, then it has to be a unanimous decision amongst the LRs, or the partnership has to be reconstituted and then a new deed has to be entered into. Another son of the deceased Nagapaya filed a suit for partition based on the will that was executed, my lord. In a suit for partition that is filed, there is another suit that is filed by the respondent herein saying that sorry, my lord, I stand corrected. One of the defendants here files a notice saying that we want to dissolve the partnership deed. That notice was sent on 5/1/2023. Sorry, 21/12/2022. In view of this dissolution notice meeting that they called for, one of the partners by name Vasanthi Badrinaran, who is respondent number 15 in my petition, files a suit for injunction in OS number 188, my lord. There, injunction is granted. In another suit filed partition, that is OS 2121 of 2018, an application seeking for reference of arbitration was invoked, my lord. That order of reference to arbitration was rejected. My lord, that order is seen in Annexure M, my lord, where the trial court clearly narrates that whenever there's a substantial dispute with regard to the partition of the arbitration, reference to arbitration cannot be invoked, my lord. Now, in a parallel proceeding where injunction was filed, whenever there's a substantial right of parties are in dispute, reference and the parties to that partnership firm are not made a party to this, arbitration invocation cannot be upheld. They said we have to adjudicate the dispute between the partnership partition deed, and then the arbitration can be looked into. So there, the application seeking reference to arbitration was rejected. Now that order is seen in page number 149, my lord. May I read, my lord?
That is also under challenge here.
That is not under challenge. Now, this application comes to be rejected. In a suit filed by Vasanthi Badrinaran seeking temporary injunction, the respondents there again moves an application seeking for reference to arbitration, my lord. That application is allowed, referring the matter to arbitration. Now, I am challenging that application saying that when this is substantial right of the party is in dispute, that should be adjudicated and the parties therein have to come into a settlement there. Then I can invoke the arbitration, my lord, because arbitration is a very narrowed thing with regard to partnership and shares. Partition is a wider aspect, my lord. Undivided shares of the party has to be disputed, has to be cleared on. Therefore, until the partition deed is clear, arbitration invocation is incorrect is what I'm contending, my lord. Staying that proceedings in OS 128, an interim order has been granted by this honorable court on 18/4. This requires a detailed hearing, my lord.
You want to file
Lord, if-
objections?
My lord, I undertake to file Wakalat on behalf of respondent number 12.
Respond number 12.
12.
Next para, similarly, learned counsel Shri
Suhas, yes.
Suhas, yes.
For respondent
Undertakes to
number
file
12.
Wakalat for respond number 12. ಮತ್ತೆಲ್ಲ ಸರ್ವಿಸ್ ಆಯ್ತಾ?
ಇಲ್ಲ my lord, respondent number 1 to 4 ಗೆ await ಅಂತ ಇದೆ.
3, my lord.
ಇವತ್ತು 3 ಬಂದಿದ್ದಾರೆ,
Okay, 1, 2 and 4.
12 ಬಂದಿದ್ದಾರೆ.
2, my lords, it appears.
13 and 14 lots I represent.
Huh?
13 and 14 lots I represent. Lots.
What was remaining was only response number 1 to 4.
1 to 4. my lord.
ಅದರಲ್ಲಿ ಒಬ್ರು ಬಂದಿದ್ದಾರೆ.
ಹೌದು, ಇನ್ 3
So
ಜನ.
1, 2 and 4.
Please my lord.
List this matter of the service of notice on response number 1, 2 and 4.
Interim order may be extended. my lord.
The order granted earlier stands extended till the next date of hearing. Full stop. Next para. At the same time, learned counsel for the respondents are requested to file their statements of objection. Yes.
Much obliged.
May I request
Much
lots, for a short accommodation lots. Lots, let them also take lots the hand summons so that lots they can serve the, let them lots take the hand summons, lots otherwise keep on lots.
ಈಗಾಗಲೇ ಹೋಗ್ಬಿಟ್ಟಿದೆ.
ಅಲ್ಲ.
They have taken steps.
No, no.
It
Lots,
is awaited.
in addition to that, lots, in addition to that, lots, if they serve lots, the parties lots through their counsel or
By
the,
next date of hearing, it is, if it is served, then they will appear.
lots, if it is not served, lots, once again,
They will have to take steps now, again.
Again, it will prolong the
totally.
proceedings.
in addition to that, lots, if they,
All right, we will give a date in the next week. Let us
very well,
release these matters on 19th of June,
very well.
20th, my lord, 20th, 19th, I have it right.
20th.
Much obliged.
Yes.
My lords. Lords, spot inspection has been conducted day before yesterday, my lords. Spot inspection has been conducted day before yesterday, and I received the reports today, my lords. My learned friend gave the
Other
reports
matters
today.
are coming.
I
Other
may be
matters are coming
permitted to
tomorrow.
file a statement of objections for
I
this.
will file it, my lordship. this-
Huh?
I will file it, my lordship, now on. The other
Same order.
matters, sir.
My lords, similar matters have been listed tomorrow, my lords.
Course of the day.
Similar matters have been listed tomorrow, at the
Tomorrow.
very same building.
Same building.
Same
Yes,
building,
please.
Release these matters tomorrow,
tomorrow.
along with ಯಾವ್ದ್ರಿ ನಂಬರ್ ಕೊಡ್ರಿ.
ಅದೇ ಇವತ್ತಿಂದ ಆಗಿರೋದು ನಾಳೆಗೆ ಬರ್ತದೆ.
ನಾಳೆ
Please, I'll furnish my lords.
7,
know the number.
7529 7610 and 7521 of 2024 minutes.
Yes.
Problems.
My lords, I may be permitted to file statement of objections for this.
But ನಾಳೆಗೆ ಹಾಕಿದ್ರೆ ಮತ್ತೆ how can
Yes.
you file objection?
ನಾಳೆ submission.
Yes.
Please.
Pay for the petition and.
Challenges to the rejection of nomination, my lords. Under the Cooperative Societies Act, there is a avenue for filing a cooperative, an election dispute. It's covered by the, your lordship's judgment, my lords. Para 8 and para 10 of this judgment. Para 8, 9 and 10.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ಇವತ್ತು.
Of course, your lordships followed the other coordinate bench judgment, lords in Shripad Rao's case. Justice Arada judgment.
You are also aware of this. Yes. Yes, yes.
ಈ judgment ತಗೊಂಡಿದ್ದು ನೀವು. ನಾ ಹೇಳಿದ್ದೆ ಅವಾಗ. ಆಯ್ತು.
ಅಷ್ಟಿದ್ರೂನು in paragraph number 9.
Yes.
You have also considered other submissions.
Other submissions also, my lords. The last sentence in para 10 is what your lordships have. Having regard to the settled position of law, only an election tribunal is permitted to declare the election or results of the election as void or illegal or consequently the same set aside.
11 ಓದ್ಬಿಡಿ.
Please, Vilas. The judgment of the Supreme Court cited by the learned counsel for the appellant as well as the learned senior counsel for the returning officer would have aptly summarized the essence of the judgments, which clearly hold that the legality of the election process of election and the declaration of the results can be gone into only by an election tribunal constituted for that purpose. Fourth respondent herein had filed a writ petition seeking direction that the returning officer should prepare a list in conformity with the list published by the Registrar of KMC under Section 26 of the Act 1961, and the returning officer should permit only such persons whose registration is renewed as per law and whose names are enlisted in the list published under Section 26 of the Karnataka Medical Council Registration Act 1961. However, as noticed above, the learned single judge who had initially found the returning officer could not have published a separate list. However, found having regard to the amended rules, the returning officer was entitled to publish a separate list which could constitute the final voters list. Therefore, having specifically directed the returning officer shall permit all those members whose claims were independently examined and separate orders were passed in terms of Rule 4.3 of the amended rules was required to have been disposed of in the writ petition itself. Unfortunately, the writ petition was not disposed of and the matter was thereafterwards considered beyond the scope of the writ petition. You have noticed the case in Sant Janardhan Swami's case. Supreme Court has clearly held that the High Court could not have stated the continuation of the election process, even though there may be some alleged illegality or breach of rules while preparing the electoral rolls. However, a challenge to the said illegality or the breach of the rules while preparing the roll would be questioned by the aggrieved party only by filing a duly constituted election petition before the tribunal. Here it's a case of rejection of the nomination paper, my lords. It's purely a election dispute. Let them go before the.
Yes, sir.
Please, Your Lordship, may kindly have only 3 facts so that I immediately address the other point. The petitioner is one of the elected member of the committee of the association in High Court unit. Kindly see Annexure H. Annexure H, page 48. Treasurer post-ge, she filed a nomination paper. Suchakaru anta column 8. One Mr. Manjunatha Suchakaru. Anumodakaru, one Mr. Satish.
Yes.
ಈ ನಾಮಿನೇಷನ್ ಆ ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಸೈಡಿಗೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇದೆ. ಎಷ್ಟು ಹೊತ್ತಿಗೆ ರಿಸೀವ್ ಆಯ್ತು ಅನ್ನೋದು ಸಹಿತ ಟೈಮಿಂಗ್ ಸಹಿತ ಬರ್ದಿದ್ದಾನೆ. Then your lordship may kindly see annexure H1. One Mr. S. Chetan has also filed nomination for the post of Khajanchi, that is treasurer. Avarige Suchakaru, one Mr. Rajesh Gowda, second Santosh Kumar MB. Then kindly see page 54. Santosh Kumar also filed nomination paper for the post of treasurer. For him, proposer is Rajesh Gowda. Anumodakaru seconder Chandregowda. So Rajesh Gowda one case nalli ಎರಡು nomination paper ಗೆ treasurer post ಗೆ Chetan as well as Santosh Kumar ಇಬ್ಬರ nomination ಗೆ ಸೂಚಕರು ಕಾಮನ್ ಸೂಚಕರು. ನನಗೆ ಸೂಚಕರು ಮಂಜುನಾಥ್ ಅಂಡ್ ಅನುಮೋದಕರು ಸತೀಶ್ ಬಿ. ನಾನು ಇದನ್ನ ಈ ರೀತಿ ಒಂದು ಟ್ಯಾಬ್ಯುಲರ್ ಫಾರ್ಮ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಿದೆ ಫೈಲ್ ನಲ್ಲಿ your lordships.
But this will be on the merits of the matter.
ಅಲ್ಲ ಇದು ಫ್ಯಾಕ್ಟ್ಸ್ ಏನು ಅಂತ ಇಷ್ಟಾದ ನಂತರ my nomination is rejected by an order at annexure J. ಅಂದ್ರೆ ನಾನು all that I want to point out is ಯಾವುದು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡೋ ಅಂತ ಯಾವ ಫ್ಯಾಕ್ಟು ಈ ಕೇಸ್ನಲ್ಲಿ ಇಲ್ಲ ಅನ್ನೋದಕ್ಕಾಗಿ ಈ ಫ್ಯಾಕ್ಟ್ಸ್ ಅನ್ನು ಹೇಳ್ತೀನಿ. ಅನ್ನೆಕ್ಷರ್ ಜೆ ತಾವು ನೋಡಿದ್ರೆ ಈ ಮೂಲಕ ನಿಮಗೆ ತಿಳಿಯಪಡಿಸುವುದೇನೆಂದರೆ ಬೆಂಗಳೂರು ವಕೀಲರ ಸಹಕಾರ ಸಂಘಕ್ಕೆ ತಾವು ಇದು 51 ಇದು annexure J may not be relevant for the present purpose. Lordship may kindly go to annexure K. ನಾನು ಅಧ್ಯಕ್ಷ ಇದಕ್ಕೂ ನಾಮಿನೇಷನ್ ಹಾಕಿದ್ದೆ, ಅದು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಐ ಆಮ್ ನಾಟ್ ಚಾಲೆಂಜಿಂಗ್ ಇಟ್. annexure K. ಆ annexure J ದಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಫಸ್ಟ್ ಅಧ್ಯಕ್ಷರದ್ದು ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾ, ಅದು ಐ ಆಮ್ ನಾಟ್ ಅಗ್ರೀಡ್. ಖಜಾಂಚಿ ಸ್ಥಾನಕ್ಕೆ ಸ್ಪರ್ಧಿಸಲು ಸಲ್ಲಿಸಿರುವ ನಾಮಪತ್ರದಲ್ಲಿ ಸೂಚಕರಾದ ಮಂಜುನಾಥ್ ಜಿ ರವರು ನಿಮ್ಮ ನಾಮಪತ್ರ ಸಲ್ಲಿಸುವುದಕ್ಕಿಂತ ಮುಂಚಿತವಾಗಿ ಸ್ವೀಕೃತವಾದ ಬೇರೊಬ್ಬ ಅಭ್ಯರ್ಥಿಯ ನಾಮಪತ್ರದಲ್ಲಿ ಸಹಿ ಮಾಡಿರುತ್ತಾರೆ. ಇನ್ನೊಂದು ಐದರ್ ಆಸ್ ಎ ಪ್ರಪೋಸರ್ ಅವ್ರ ಸೆಕೆಂಡರ್ ಇನ್ನೊಂದಕ್ಕೆ ಮಾಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಖಜಾಂಚಿ ಸ್ಥಾನಕ್ಕೆ ಸಲ್ಲಿಸಿರುವ ನಿಮ್ಮ ಪತ್ರವು ತಿರಸ್ಕೃತಗೊಂಡಿರುತ್ತದೆ ಎಂಬ ಅಂಶವನ್ನು ನಿಮಗೆ ಸ್ಪಷ್ಟಪಡಿಸಿದೆ. ಸೊ ನನ್ನ ಪ್ರಪೋಸರು ಇನ್ನೊಂದು ಯಾವುದೋ ಇದಕ್ಕೆ ಸೈನ್ ಮಾಡಿದ್ರು ಅನ್ನೋದಕ್ಕಾಗಿ ನಂದು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದೇವೆ ಅಂತ ಹೇಳ್ತಾರೆ. Your Lordship may kindly see ಅವರು ಇನ್ನೊಂದು ಸೈನ್ ಮಾಡಿರೋದು that is at ಅಮೃತೇಶ್ ಶಂಕರ್ ಏಜ್ ಎಷ್ಟು ಅಮೃತೇಶ್ ಜವರೇಗೌಡ ಅಮೃತೇಶ್ ಅಧ್ಯಕ್ಷರು ಕಲ್ಪನಾ, ಅಧ್ಯಕ್ಷರು ಬಾಲಕೃಷ್ಣ, ಅಧ್ಯಕ್ಷರು ಸತೀಶ್, ಅಮೃತೇಶ್ ಅಧ್ಯಕ್ಷರು ನಿಂತಿಲ್ಲ, ಉಪಾಧ್ಯಕ್ಷರಿಗೆ ನಿಂತಿಲ್ಲ.
Now the learned senior counsel on the other side is raising a preliminary objection.
Preliminary objection ಗೆ ನಾನು straight way, Your Lordship may kindly see annexure F1, page 27.
Yes.
ಅದರಲ್ಲಿ ಅಧ್ಯಕ್ಷರ ಪೋಸ್ಟಿಗೆ ನಾಮಿನೇಷನ್ಸ್ ಫೈಲ್ ಆಗಿದ್ದಾವೆ. annexure F2 ಸತೀಶ್ ಅನ್ನೋರು ಅಧ್ಯಕ್ಷರ ಪೋಸ್ಟಿಗೆ ಪೇಜ್ 30.
ಮಂಜುನಾಥ ಜಿ
ಅವರು ಮಂಜುನಾಥ ಜಿ ಆ ಅಧ್ಯಕ್ಷ ಪೋಸ್ಟಿಗೆ ಸತೀಶ್ ಅನ್ನೋರಿಗೆ ಸೆಕೆಂಡ್ ಮಾಡಿದರು. So ultimately it boils down to a fact that Manjunatha ji had seconded the name of one Satish B for the post of president. On that ground, ಈ ನಾಮಿನೇಷನ್ ಸತೀಶ್ ಬಿ ಅವರ ನಾಮಿನೇಷನ್ ಮೊದಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ, ನಿಮ್ಮದು ತದನಂತರ ಬಂದಿದೆ, ನಿಮ್ಮದು ರಿಜೆಕ್ಟ್ ಮಾಡ್ತೇನೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಒಂದನೇದು. ಎರಡನೇದು, ಟ್ರೆಸರರ್ ಪೋಸ್ಟಿಗೆ 2 ಜನ ಅಭ್ಯರ್ಥಿಗಳು ಕೊಡ್ತಾರೆ. ಒಬ್ರು ಚೇತನ್ ಅಂತ ಹೇಳಿ, ಇನ್ನೊಬ್ರು ಸಂತೋಷ್ ಕುಮಾರ್ ಅಂತ. ಅದು ತಾವು ನೋಡಿದ್ರಿ. ಅದು ಎರಡರಲ್ಲೂ ಸೂಚಕನ ಹೆಸರು, ಅವು ಎರಡೂ ನಾಮಿನೇಷನ್ಗೆ ಸೂಚಕನ ಹೆಸರು ಒಬ್ಬರೇ, ರಾಜೇಶ್ ಗೌಡ ಅಂತ. ಈ ಬ್ರೇನ್ ವೇವ್ ಏನು ಬಂದಿತ್ತಲ್ಲ ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ಗೆ, 2 ಜನರಿಗೆ ಸಹಿ ಮಾಡಿದ್ರೆ ಒಂದನ್ನೇ ತಗೊಳ್ಬೇಕು, ಇನ್ನೊಂದು ರಿಜೆಕ್ಟ್ ಮಾಡಬೇಕು ಅಂತ. ಅದು ನಮ್ಮ ನಾಮಿನೇಷನ್ ನೋಡಿ ಆದ ಕೂಡಲೇ ಮರ್ತು ಹೋಗ್ಬಿಡ್ತಾವ್ರಿ. ಸೊ ಚೇತನ್ ಅಂಡ್ ಸಂತೋಷ್ ಕುಮಾರ್ ಅವರಿಬ್ಬರದ್ದು ನಾಮಿನೇಷನ್ ಎಕ್ಸೆಪ್ಟ್ ಆಯ್ತು. ದೋ ಒಬ್ಬರೇ ಪ್ರಪೋಸರ್ ಆದ್ರು, ಇರ್ಲಿ, ಅದನ್ನು ನಾವೇನು ಹೇಳೋದು. ನಾವು ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ Rule 14. Election of office bearers. (14) AG, capital 14 capital AG. Election of office bearers ಅಂತ ಶುರುವಾಗುತ್ತೆ.
Karnataka Cooperative Societies rules.
ಹೌದು,
1960.
14A.
14 AG. ಆ 14 ನಲ್ಲಿ ಎ ಕೆ
ಕ್ಯಾಪಿಟಲ್,
ಎರಡು ಕ್ಯಾಪಿಟಲ್. ಒಂದ್ಸಲ ಎಲ್ಲ ಆಲ್ಫಾಬೆಟ್ಸ್ ಮುಗಿದು ಸೆಕೆಂಡ್ ರೌಂಡ್. ಅದರಲ್ಲಿ ಕೈಂಡ್ಲಿ ಸಿ ಸಬ್ ರೂಲ್ 5. No director shall propose or second under sub rule 4 more than one candidate for the office of the president or vice president or any other office bearer of the society. So more than one candidate ಗೆ ಮಾಡಬಾರದು ಅಂತ ಅಲ್ಲಿ kindly see the word is for the office of president and or vice president or any other office bearer, provided that if any director has proposed or seconded more than one candidate for the office of president or vice president or any other office bearer of the society, nomination which is received first shall be considered for scrutiny. ಈಗ ಈ rule, my respectful submission is, this is a rule which says no director shall propose or second more than one candidate for the post of president. ನಾನು ಪ್ರೆಸಿಡೆಂಟಿಗೆ ಒಂದಕ್ಕಿಂತ ಹೆಚ್ಚಿಗೆ ಮಾಡಿದ್ದಿದ್ರೆ ಸೆಕೆಂಡ್ ಆಗಿ ಬಂದಿದ್ದು ಹೋಗುತ್ತೆ. Similar argument will apply to vice president. Similar argument would apply to any other office bearer, that is treasurer. ನನ್ನ ಕೇಸ್ನಲ್ಲಿ ಸತೀಶ್ ಬಿ ಅನ್ನೋ ಪ್ರೆಸಿಡೆಂಟ್ಗೆ ಮಂಜುನಾಥ್ ಜಿ ಪ್ರಪೋಸ್ ಮಾಡಿದ್ರು.
So this will be
ಟ್ರೆಸರರ್ಗೆ ಮಾಡಿಲ್ಲ.
It will be on the merits of the matter.
ಅಲ್ಲಲ್ಲ.
Therefore, you are first required to cross the threshold bar
ನಾನು ಇದನ್ನು
of the maturity of the writ petition.
ತೋರಿಸ್ತಿರೋದು ಇಷ್ಟೇ ಕಾರಣ. ಈ ರೂಲಿನ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ನಾನು ಮಾಡಿದ್ದೋ ಅಥವಾ ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ನ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗು ಕರೆಕ್ಟ್ ಹೌದು ಅಲ್ಲ ಅನ್ನೋ ಒಂದು ಪ್ರಶ್ನೆ ಬಿಟ್ರೆ ಬೇರೆ ಯಾವುದೇ ಪ್ರಶ್ನೆ ಆನ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಆರ್ ಆನ್ ಲಾ will not arise in this case.
Yes.
That is the first submission. And my respectful submission is a pure question of law of interpretation of Rule 13 arises in this case without there being any other material to be looked into by the court, any disputed fact that would arise. With this, my lord, I would bring to your lordship's notice a judgment of ಇಲ್ಲ ಅದೇನೋ ಜಡ್ಜ್ಮೆಂಟ್ ಇದನ್ನ ಮಿಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ನಾನು 2:30ಗೆ ಅದನ್ನ ಮಾಡ್ಕೊಂಡು ಇದರಲ್ಲಿ
All right, we'll continue at 2:30.
ನನಗೊಂದು 10 ನಿಮಿಷ ಮುಗಿಸ್ಕೊಂಡು ಬರ್ತೇನೆ.
All. Extension. All.
Serial number.
ರೇಷ್ 59 ನಮ್ದೊಂದು ವಿತ್ಡ್ರಾವಲ್ಗೆ ಮಾಡಲಾ? ಹಾಂ, ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಬರ್ಬೋದು ಆ ಟೈಮ್ ಬಂದ್ಬಿಟ್ಟು ಬೇಕು ಅಂದರೆ. ಹೌದಾ? ಹಾಗಿದ್ರೆ ಆ ಟೈಮ್ಗೆ ಕರಿಬೇಕು ಅಷ್ಟೇ. ಡೌಟಾ?
Court officer? Court officer?
ಓಕೆ ಓಕೆ.
Court officer? Court officer? Court officer?
ಕೇಳಿಸ್ತಿದೆ
ಸರ್, ನೀವು ಒಂದ್ ಸ್ವಲ್ಪ ಸೀರಿಯಲ್ ನಂಬರ್ ಒಂಚೂರು ಮೈಕ್ ಹತ್ರ ಕರಿತೀರಾ ಸರ್? ಅದು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
ಎಷ್ಟು ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರು?
ನಮ್ದು 61 ಇದೆ.
ಆಯ್ತು ಮೇಡಮ್.
ಸೊ ಒಂಚೂರು ಅದ್ ಮೈಕ್ ಹತ್ರ ಹೇಳಿದ್ರೆ ಒಂಚೂರು ಕೇಳಿಸುತ್ತೆ ಅಂತ. ಒಂಚೂರು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ, ನೀವ್ ಹೇಳೋದ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ.
ಸರಿ ಮೇಡಮ್, ಆಯ್ತು.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
42, 26.
Okay, thank you.
ಕೊಟ್ರಮ್ಮ ಇದೆ. ಆಮೇಲೆ ಇನ್ನೊಂದು ಕೇಳಿದ್ವಿ ಇವಾಗ ಏನು ಮೊನ್ನೆ ಆರ್ಡರ್ ಆಗಿತ್ತಂತಲ್ಲ, ಚೇಂಬರ್ ಇದೆ ಅದು.
ಅದು ನಿನ್ನೆ ಇದು ಇದ್ರ ಮೇಲೆ ಆಯ್ತಲ್ಲ 29A.
ಇದೇ ತಾನೇ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದು.
ಜಡ್ಜ್ಮೆಂಟ್ ಸರ್ ಕೇಳಿ, ಜಡ್ಜ್ಮೆಂಟ್ 29 ಟೈಮ್ ಆಗುತ್ತೆ. ಓ, ಇದು SLPಗೆ ಹೋಗಿದ್ಯಾ? ಡಿಸೈಡ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ, ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳ್ಕೊಂಡಿರ್ತಾರೆ, ಅದಕ್ಕೆ ಕೊಡ್ತಾರೆ.
ಡಿಸೈಡೆಡ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ
ಈಗ ಮೊನ್ನೆ ಇವಾಗ ಒಂದಾಯ್ತು ಮತ್ತೆ 1 year ಏನೇ ಆರ್ಬಿಟ್ರೇಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡೋದಕ್ಕೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಕೇಳ್ಕೊಂಡಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಇವತ್ತು ಆರ್ಡರ್ ಆಗಿದೆ. ಆ ಆರ್ಡ್ರು ಅದು ನೋಡ್ಕೊಂಡು ಮಾಡಿ
ನೆನ್ನೆ ಆಯ್ತಲ್ಲ,
ಅದೇ ಅದು ಕೊಡಿ.
ಅದಲ್ವಾ? ನೆನ್ನೆ ಇದೆ ಮ್ಯಾಟ್ರು 29A. ಇವ್ರ ಜೊತೆನೆ ವೈಶಾಲಿ ಅವ್ರ ಹೆಸರೇನದು Election matter. Ma'am.
ರಾಜೇಶ್ವರ ಪಿ ಎಂದು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಫಾರ್ 1 year.
ಹೌದು 23-24 connected matter.
ಇದು ಈ ಆರ್ಡರ್ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ.
But certainly it is a decided matter.
ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಮ್ಮ.
ಯಾವುದು?
ಅದೇ ಇದು
ಇದಾ?
ಇದೆಲ್ಲ ಸ್ಕೇಲ್ ಇವಾಗ ಆರ್ಡರ್ ಆಗುತ್ತಲ್ಲ.
ಆರ್ಡರ್ ಆಗಿರೋದು.
44 ತನಕನೇ ಬಂದಿರೋದಲ್ಲ.
ಈ ಕಾಪಿ
ಇನ್ನೂ ಸೈನ್ ಆಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ.
ಹೋಗಿದ್ದು ಅದು ಯಾವ್ದೋ ಫೈನಲ್ ತರ್ಸ್ಕೊಂಡಿದ್ದು.
ಬಟ್ ಅದನ್ನು ಸೈನ್ ಆಗಿಲ್ಲ.
ಹೌದು ಸೈನ್ ಆಗಿಲ್ಲ. ನಿನ್ನೆ ಸೈನ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಅದಾದ್ಮೇಲೆ ನಂಬರ್ ಕಾಪಿ
44
ಮಾಡ್ಕೊಡೋದಕ್ಕೆ ಮರ್ತೋಗ್ಬಿಡ್ತೀನಂತೆ.
44 ತನಕನೇ ಬಂದಿರೋದು.
4ಕ್ಕೆ ರಿಸರ್ವ್ ಆಗಿ ಅರ್ಜುನ್ ಆಗಿದೆ ಸರ್. ಬನ್ನಿ ನಾವು ಮಧ್ಯಾಹ್ನ
48 ಇದೆ. ಫಸ್ಟ್ ಪಾಸ್ ಅವರಾ?
ಬನ್ನಿ ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ, ಯಾರು ಗೊತ್ತು ಹೇಳ್ಬೇಕಂತಲ್ಲ. ಹ್ಮ್ 33 ಬರ್ಕೊಂಡು
Your lordship's permission, the mic. Your lordship's permission.
The prayers made in the petition are far too many. And the petitioners would like to file another petition restricting the prayer only for a restoration of the board of directors.
Listen.
We'll stop. The learned counsel therefore submits that liberty may be reserved to the petitioners to file another writ petition only in terms of the prayer made in the memo. Full stop. Next paragraph. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as withdrawn, reserving liberty to the petitioners to file a fresh writ petition seeking restoration of the board of directors.
Grateful, Malad.
Serial number 45, DBI Jain, inspection report.
For the
45.
petitioner.
For respondent. Inspection has been conducted, ma'am.
Yes,
Inspection has been conducted. We will file the report.
report is ready.
Report is ready.
Learned counsel for the respondent, CBMP submits that the report, inspection report is ready. Full stop. Learned counsel is directed to file the same in the office by tomorrow, comma, while serving a copy of the same on the learned counsel for petitioner. Full stop. Release this matter on 19th of June. Yes.
46, Ajit PB.
My lords, I appear for the petitioner. I'm supposed to produce a copy of, enlarged copy of Annexure B, my lords. I have it with me. I'll produce it before the register. So I'll file it in the register.
Learned counsel for the petitioner submits that an enlarged copy of annexure
D, ma'am.
D,
Layout plan. So the-
comma, layout plan, comma, is ready. And the same will be filed in the office during the course of the day. So, release this matter on 19th of June.
My lords, interim order on the fixed.
Interim order granted earlier stands extended till next date of it.
47, Mahesh BJ, non-filling affidavit.
Petition. This is similar to, my lord, the serial number 11, mobile tower, the unilateral withdrawal of the license, my lord, only based on some letters issued by the MLA and the Home Ministry. That too, my lord, on the speculation of, in case of any extreme weather conditions, there is chance of the falling of the mobile tower. No inspection, nothing, my lord. Nothing is done, except no even prior notice or anything. That is the reason, my lord, the earlier, my lord, this honorable court has directed the person who has issued Annexure A to file an affidavit as to basis on which the Annexure A has been.
You have filed it.
My lords, I'm filing it, my lords, sir.
Huh?
My lordships could kindly pass over, my lords, sir. File yaro nam togonಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, sir. If my lordships could kindly pass over, I'll file it, my lords.
Pass over.
Please.
48, Abhijit MM. Sanction plan.
Honorable Court on last date of hearing directed me to produce the sanction plan license issued by the respondent number 4, care of the petitioner, respect of the construction. Also, copies are served to the others. In meantime, I challenge the Annexure D, E, F, G, the implement communication made by the respondent number 2 and 3 in favor of the respondent number 3 to 6, and permit me to continue the construction in the my site. In similar, the other
Development officer.
other site owners in the interim order in similar petition, I have produced the same Annexure H, J, J1, J2.
My lord, the land, some lands, my lord, which agriculture land, it was without conversion and they have, without approving the layout plan, my lord, they have farmed the layout, the vendor of the original owner. This, the petitioner is the purchaser of the site from the one site purchased from the original owners. His vendor is purchased from the one site. This honorable court, my lord, in the earlier writ petition, my lord, since it is the similar notice was issued by the planning authority, because they are farming the unauthorized layout under section 17(4) of the KTCP Act, my lord, notice was issued seeking explanation. That was challenged in the original owner in the writ petition, my lord, where my lord, this honorable court said, my lord, treat that as a notice and file the reply before the authority. This person, my lord, when that matter is pending, the petitioner is starting for constructing the building in the without that the proceedings are pending. Now this person purchased the site one from that and started for conversion.
When did you purchase the property?
2012, ma'am. 2012. I've started in the construction from last.
This person was not a party to the proceedings earlier.
Earlier he was
no.
This comes under CGLD.
The Annexure J2, ma'am. In similar petition, other petitioners are site owners obtain the interim order.
Petitioners are at liberty to submit applications in prescribed form with respondent number 3 for sanction of permanent power supply along with requisite fee.
That I guess the respondent number 6.
Submitted. Respondent 3 BESCOM to consider the same.
Also, in meantime, can see the Annexure J2, ma'am. The ink page number 52.
No, what are the directions issued regarding it? That is only GMKEB.
No,
Yes,
it is
the writ petitions were directed against the
original land
electricity supply companies.
The BESCOM.
Earlier, my lord, the original landowner, my lord, in certain lands, my lord, he farmed the layout without the conversion and agriculture land it is. Otherly, my lord, we have.
You are also a party to the proceedings?
Other only against the BESCOM, my lord, the annexure.
The Annexure J1,
only the
J2, ma'am.
Only the BESCOM.
Yes.
My lord, I have one copy, my lord, I'm sorry, only one copy. Earlier, the landowner has filed the
writ petition where we have issued the notice to the landowner under section 17.
In paragraph number 2.
Yes.
It is noticed that BDA issued show cause notices to the
Yes.
vendors.
Yes,
For the petitions as to why action should not be taken
that is
for
the,
forming unauthorized layout in contravention of the provisions of the KTCP Act.
yes, that is the judgment also, my lord. He challenged that, that is the original landowner challenge that.
That impugned communication was stated in the annexure H mode. That the writ petition filed by the layout owners. And subsequently, the site purchasers also filed the similar writ petition. I'll see the annexure J2 mode. See the annexure J, the ink page number 44.
That matter is pending, my lord. This petition are started for construction of the building. Well, therefore, my lord, annexure D, my lord, the page 35 was issued by the second respondent BDA, my lord, page 35. We issued, my lord, stating that that matter is pending, my lord, not to allow the constructions.
To the PDO.
That it was issued to the police inspector, my lord, the Tavarakere.
Allah, Panchayat Development Officer.
Allah, annexure D, my lord, page.
Annexure D ne.
Howdo. Issued by the.
Issued by BDA to the Panchayat Development Officer.
Other previous document ಇರ್ಬೇಕಾಗುತ್ತೆ ನಮಗೆ annexure D ಅಂತ ಮಾಡಿದ್ದಾರೆ. Police inspector ಅಂತ.
The annexure D, ink page number 35. 35.
Here.
The annexure E is the to the Panchayat Development Officer.
Annexure E nu ಅಷ್ಟೇ, ನಮ್ಮಲ್ಲಿ annexure D nu ಅಷ್ಟೇ.
ನಮ್ಮಲ್ಲಿ annexure D ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ BDA.
ಏನ್ರಿ?
Different. Annexure D and E ಇದೆ.
ಇಲ್ಲಿ ಬೇರೆ ಒಂದೇ ಕಾಪಿ ಆಗಿದೆ.
ಯಾವ್ದೋ ಬೇರೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ ನೀವು? Annexure F ಅಲ್ಲಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅವರು ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಅದಿದೆ. ಅದಿದೆ. Annexure D ಅಲ್ಲಿ it's
BDA
written by the assistant executive engineer BDA.
ಹೌದು, to the police.
To the Panchayat Development Officer.
ನಮ್ಗೆ ಕೊಟ್ಟದಲ್ಲಿ
next document. Annexure E ಇದೆ.
ಏನೋ ಮಿಕ್ಸ್ ಅಪ್ ಮಾಡಿದೀರಾ ನೀವು?
ಅಲ್ಲ, ಅದು annexure.
ಎರಡು ಅಷ್ಟೇ, annexure E ನು ಅಷ್ಟೇ, ಇದು ಅಷ್ಟೇ.
annexure E ನಮ್ಗೆ ಕೊಟ್ಟದ್ದು ತಹಶೀಲ್ದಾರ್ ಗ್ರಾಮ ಪಂಚಾಯತಿಗೆ ಬರ್ತದೆ.
ಆಯ್ತು.
ಈ ಲೆಟರ್ ಅಲ್ಲಿ ನಾವು because the pending, my lord, as per the direction of this government, the proceedings are pending, not to allow to construct the building or.
Yes.
ಅಂತ ಕೊಟ್ಟಿದೆ. That was challenged in this petition.
That is what is challenged in this petition. Yes.
So currently the annexure.
How can we permit you to proceed with the construction?
No, currently the annexure J mode. The similar petition, the other site purchaser moved the petition.
That is regarding the power supply.
No, annexure J mode. There are different petition. That is only against the Westcom. Annexure J. Currently the second part of the order. The petitions are admittedly the owners of sites, which are typically
called revenue sites.
Revenue sites.
And the impugned orders for the cancellation of khatas issued by the Bangalore North Taluk Panchayat, consequent to the orders passed by the Special Tahsildar Bangalore North Taluk. After the orders, this court in writ petition number 59438/2016. However, the Special Tahsildar order is called in question in writ petition number 22050 of 23. There is the annexure H mode. And this court, considering the ground, urged that the action is taken after an unreasonable delay, has directed the Tahsildar not to give effect to such orders. For reasons of parity, the respondents must be directed not to cancel the khatas issued in favor of the petitioner until further orders, but directing the petitioner to pay taxes without default and without claiming equity, it is ordered accordingly. And in similar, consider annexure J2, my lord. There's one more writ petition not in page number 52, my lord. Annexure J2 regarding construction. Annexure J2. The second para, 10th line. However, the Tahsildar has issued the improved communication to the police inspector requesting him to stop the construction on the ground that there is a violation of the orders passed by this honorable division bench and that there is a violation of the provision contained in section 95 of the Karnataka Land Revenue Act 1964, in that the lands have not been converted and no permission for construction has been obtained by the petitioner. Land Senior Counsel submits that if there is a violation of any of the orders passed by this court or the honorable division bench, it does not give any right to the Tahsildar to proceed against the petitioner. On the other hand, the Tahsildar could bring the same to the notice of the honorable court that there is a violation of the interim orders passed by this court. Moreover, several disputes have taken place earlier and orders have been passed by this court protecting the interest of the revenue entries shall be maintained in the name of the landowners, developers, subject to the further orders and the proceedings in writ petition number 22050 of 23. Consequently, there shall be an interim of stay of the impugned communication at annexure M made by the respondent Tahsildar Bangalore North Taluk and further proceedings thereto until further orders. In respect of the construction, the order was passed in the writ petition.
See, that is regarding the revenue entries.
The writ petition number 22050.
Actions ought to be taken under section 95.
Yes, yes, madam.
This is not the same here.
Regarding the site owners,
Grievance may be the same, but the cause of action there was pursuant to the action taken by the Tahsildar.
the same, madam. Same, madam.
Karnataka Land
Tahsildar.
Revenue.
Tahsildar, in here also, madam.
Here, it is the Bangalore Development Authority which is seeking to take action in
Yes, madam.
accordance with the provisions of the Town and Country
Yes,
Planning Act.
That communication was challenged by the layout owners in the writ petition number 22050 of 23, madam.
Where is that?
The annexure H, madam.
Page number?
40, madam. This is the order 42 in page number. Said order was
Again, Tahsildar.
yes, madam. Said order, then BD is a response number 3.
Yeah. But the action is directed against the Tahsildar.
Yes, madam. Later on, based on this order, the site
Again,
purchaser.
that is also a KLR matter.
Kerala, madam. In the currency, the LB matter, that the annexure, J, madam, in page number 44, that is the LB matter. 44. In this case,
It is regarding, again, regarding Khata,
Khata, madam.
cancellation of Khata.
Khata. And here I'm thinking
You
for.
are aggrieved of what now in this writ petition?
Permit me to continue the construction, madam.
Huh?
Permit me to continue the construction, madam.
So the prayer there is different and the prayer here is different.
No, one, regarding the one prayer, that this order is covered, madam. In another prayer, another order is covered.
ನೀವೇ ಫೈಲ್ ಮಾಡಿರೋದಾ? ದಿ ಸೇಮ್ petitioner has filed.
No, madam. No, madam. There is other site purchase.
Issue direction to by quashing impugned letters.
The communication.
How can it be quashed, sir? If they are seeking to take action in accordance with law, how can it be quashed?
It may be covered by the main petition, the 22050.
Matters are still pending consideration. And as I have noticed, the prayer there is different, the prayer here is different. You are asking for a direction to permit you to proceed with the construction, in spite of admitting the fact that the land is not, the layout is not sanctioned by the Bangalore Development Authority.
The NOC was issued at the time of the
NOC kododu.
at the time forming the layout, NOC was issued.
Yaro?
BDM.
Please show. Please show, sir.
I have no copies.
It's impossible. They are not permitted to issue such NOCs. And the only authority which is authorized to issue a sanction for a development of a layout is the planning authority. And in this case, it is the Bangalore Development Authority alone. No Gram Panchayat, no Taluk Panchayat, no municipality, no corporation can sanction the plan for formation of a layout. It is only the planning authority.
Also conversion is concerned, that is also
Conversion is
pending.
one aspect. After conversion, you will have to approach the planning authority for sanctioning a plan for formation of a layout. That is why it is called unauthorized layout. See, we have been noticing how the Bangalore Development Authority is keeping quiet without taking action in respect of such unscrupulous, unauthorized layouts that are mushrooming around Bangalore. As a consequence of which now they are trying to take action. And you are coming before this court and asking for a direction. Ask them not to stop your construction.
Petitioner will suffering.
Huh?
Petitioner is suffering. Is already 600 houses are constructed. More than 3,000 people are living in that layout now.
600
houses are constructed in the entire layout is the 40 acres layout.
Tell them, let them come before the court. We can't permit you to proceed with the construction like this.
Yes, my interest will cut in.
We are not concerned with the action of the Tahsildar here. See, if the order of conversion is also not taken, then cause of action arises under both the statutes, the Karnataka Land Revenue Act and under the Karnataka Town and Country Planning Act. You are aggrieved of the action of the BDA, which is taking action in terms of the Town and Country Planning Act. How can we stop them?
Till conclude the writ petition number 22050.
Huh?
Till conclude the 22050 of 23. I am entitled.
Only there is no permission given to go ahead with the construction. You please see Annexure J. The only one that you can rely upon. Annexure J. You know the page number? 44. 44. That is regarding the cancellation of the Khata. You please read it. This court has not given any permission to any person to go ahead with the construction.
Meantime, permit me to withdraw the petition.
Want to withdraw the petition?
Please.
Learned Counsel for the petitioner has filed a memo dated 12/6/2024 seeking leave of this court to withdraw the writ petition as not pressed. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as not pressed.
Bill number 49.
My lord, in this case, I have filed Wakalat for the respondent in the morning.
I appeal for petitioner.
I have filed Wakalat for the respondent in the morning, my lord. Annexure A has been questioned. Annexure A is only a notice which has been issued.
Council Sri SM Mahesh.
Yes, Mahesh. Yes, Mahesh. Yes.
Appearing to video conference submits that he has
I filed
Wakalat.
Wakalat in the morning.
He has filed Wakalat on behalf of the respondent, Municipal Corporation, Hiriyur.
Annexure A is challenged. Annexure A is only a notice calling upon him to produce certain documents. I do not know how the writ petition is maintained.
My lord, I have issued
Let
a
him
reply.
furnish
to
it
that
or
annex-
let him give a reply to it.
Yes.
I have issued reply already at annexure B. Your lordship considered that annexure B, my lord, page number 13. That is a reply which I have issued. My reply is that ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪದ್ಮಾವತಿಯಾದ ನಾನು ಕೆಎಸ್ಆರ್ಟಿಸಿ ಬಸ್ ನಿಲ್ದಾಣದ ಮುಂಭಾಗದಲ್ಲಿ ಸತ್ಯನಾರಾಯಣಾಚಾರ್ ಮಾಲೀಕತ್ವದ ಶೀಟಿನ ಶೆಡ್ಡಿನಲ್ಲಿ ಬೇಕರಿ ನಡೆಸಲು ಬಾಡಿಗೆ ತೆಗೆದುಕೊಂಡಿರುತ್ತೇನೆ ಹಾಗೂ ಬೇಕರಿ ನಡೆಸಲು ನಿಮ್ಮ ಕಚೇರಿಯಿಂದ ಪರವಾನಗಿ ಪಡೆದು ಕಂದಾಯ ಕಟ್ಟಿರುತ್ತೇನೆ. ಆದರೆ ಸದರಿ ಶೀಟಿನ ಶೆಡ್ ಹಳೆಯದಾಗಿದ್ದು ಸೋರುತ್ತಿದ್ದ ಕಾರಣ ಅದಕ್ಕೆ ಹೊಸ ಶೀಟನ್ನು ಹಾಕಿರುತ್ತೇನೆ ಅಷ್ಟೇ. ಆದರೆ ನಾನು ಯಾವುದೇ ಹೊಸ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡಿರುವುದಿಲ್ಲ ಹಾಗೂ ನಗರಸಭೆ ಅಧಿನಿಯಮಕ್ಕೆ ವಿರುದ್ಧವಾಗಿ ಯಾವುದೇ ಉಲ್ಲಂಘನೆ ಮಾಡಿರುವುದಿಲ್ಲ. ನಮ್ಮನ್ನು ಕಂಡರೆ ಆಗದವರು ಯಾರೋ ನಿಮಗೆ ತಪ್ಪು ಮಾಹಿತಿ ನೀಡಿ ಸುಳ್ಳು ಆರೋಪ ಮಾಡಿರುತ್ತಾರೆ. ಬೇಕರಿ ನಡೆಸುತ್ತಿದ್ದೇವೆ ಮತ್ತು ಸಾಕಷ್ಟು ಬಂಡವಾಳ ಹಾಕಿರುತ್ತೇವೆ. ಹೀಗಾಗಿ ನೀವು ಸ್ಥಳಕ್ಕೆ ಭೇಟಿ ನೀಡಿ ಪರಿಶೀಲಿಸಬೇಕಂತ ತಮ್ಮಲ್ಲಿ ಮನವಿ ಮಾಡಿಕೊಳ್ಳುತ್ತಿರುತ್ತೇನೆ. I have issued a response, my lord. Subsequent to which that threatening to demolish my structure, for which I have approved this honorable. This was precisely my contention on the last date of the day, for which status quo has been ordered so far, not to take precipitative actions.
My lord, in that case, I have not received that annexure.
Consider your reply
So far, no.
and take action.
Yes, my lord. Yes.
Are they not
Sometime
to proceed and take action in accordance with law, considering your reply?
Kindly,
Yes.
my lord. So this is a
Yes.
notice under 187, now for which I have issued a reply. They can't threaten to demolish my structure, they have to take action in accordance with law.
But they have a right to consider your reply and proceed in accordance with law.
Kindly, my lord. That order may be.
Perfect. Next para. Learned counsel for the respondent submits that the petitioner is before this court aggrieved of the impugned notice at annexure A dated 2/5/2024, whereby the petitioner has been called upon to furnish documents to show the basis of the construction put up by the petitioner. Full stop. It is alleged that complaints have been received from various quarters that the petitioner is putting up construction without securing a sanctioned plan or building license from the respondent authority. Full stop. Next para. Learned counsel for the petitioner, however, draws the attention of this court to annexure B and submits the petitioner has caused a reply to the impugned notice at annexure A, stating that the petitioner is not the owner of the property, but she is a lessee and she has been running a bakery in a small premises which has sheet roofing. Full stop. It is also stated that since the sheet was dilapidated and the roof was leaking, the petitioner has only removed the old asbestos sheet and has put up new asbestos sheet, and she has not taken up any new construction. Full stop. Next para. Having regard to the facts narrated herein above, this court is of the considered opinion that the respondent, municipal commissioner, or any authorized officer is required to consider the reply given by the petitioner and thereafter proceed in accordance with law. Full stop. Next para. Consequently, the writ petition stands disposed of with a specific direction to the respondent to consider the reply given by the petitioner at annexure B, comma, afford opportunity of hearing to the petitioner and thereafter proceed to take action only in accordance with law.
Until then, let them be.
Till then, no precipitative action shall be taken against the petitioner.
Great.
Yes, great.
Much of.
14. Serial number, sorry. Serial number 50. Ramesh K.R.
For petition this matter. Avoid service of notice to respond number 3.
Release this matter after service of notice on respond number 3.
This date maybe. Any date
Divan.
maybe.
After service of notice.
Arun
Yes.
B.M.
My lords, I appear for the petitioner in this matter. The
Ah,
petitioner's husband was the owner of the property.
what is the office objection?
Office objection that notary seal ಅಲ್ಲಿ sign ಇಲ್ಲ ಅಂತ sign ಇದೆ ಅದರಲ್ಲಿ. I verified.
Photo to be furnished at annexure F.
ಅದರಲ್ಲಿದೆ page number 9 ಅಲ್ಲಿ notary seal ಇದೆ ಅದರಲ್ಲಿ. And second one photograph black and white ಇದೆ ಅದು. That colored photograph was not immediately available. Annexure F. Only 2 office objection. One notary seal ಇಲ್ಲ ಅಂತ but affidavit ಅಲ್ಲಿ seal ಇದೆ. ಅವ್ರದ್ದು sign ಇದೆ ಅದರಲ್ಲಿ.
ಇಲ್ಲ ಒಂದೇ ಒಂದು. There is only one office objection regarding annexure F ಅಷ್ಟೇ.
ಅಷ್ಟೇ. I'm sorry, my lords. This property was allotted by the housing board and the adjacent owner is constructing the building illegally. Corporation initially had issued a notice. Your lordship may kindly turn to page 20, typed copy on 6/3/2024. Original is on page 19. The typed copy is in page 20. Annexure D. ಅದರಲ್ಲಿ 313 ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದಾದ್ಮೇಲೆ ಏನು ಮಾಡಿಲ್ಲ. Then I moved the commissioner in the next annexure 27/3/2024. ಅದಾದ್ರೂ ಏನು ಮಾಡಿಲ್ಲ. Son of the petitioner has moved on 27/3/2024 and 5 floors building and I have approached that earliest point of time with to the commissioner and she stays in Mudigere. There is
Then at the counsel Shri Pawan Kumar, who was present in the court, takes notice for respondents number. Starting ಅಲ್ಲಿ office objection regarding annexure F is overruled. Next para. Learned counsel Shri Pawan Kumar, who was present in the court, takes notice for respondents number 1 to 3. Issue notice to respond number 4. Issue emergent notice to respond number 4. Returnable by 26th of June 2024.
I have sought for an interim order, no further construction.
Learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures.
Please,
on the
madam.
learned counsel for the respondent BBMP. Full stop. Next para. Since the contention of the petitioner is that
No setback and 5 floors in a residential building.
the fourth respondent is putting up construction in violation of the sanction plan
And the provisions of the BBMP Act.
comma, without leaving the setbacks and putting up
Additional floors.
an additional floor. And in spite of notice under section 313 being issued on 6/3/2024, the fourth respondent is proceeding with construction,
Please, my lords.
comma, the learned counsel for the respondent BBMP is directed to secure instructions from the third respondent, Assistant Director of Town Planning, bracketally West, as to the action taken against the fourth respondent consequent to the complaint given by the petitioner and the notice issued at annexure D. Full stop. Next para, if the third respondent is of the opinion that the fourth respondent has been putting up construction in violation of the sanction plan, comma, necessary action shall be taken to ensure that no further construction is put up by the fourth respondent. Full stop. Next para, release this matter on 26th of June.
Grateful, my lords.
P2, Fayaz Saab BG.
Here for petitioner in this case, Lord. Lord, the office notice, Lord, annexure E page 31, Lord. The contents of the BBMP seal is not readable. That is only the office objection. Page 31 annexure E, Lord. Is the plan approved by the BBMP. The office seal, the contents of the office seal is not readable. That is only the office
Annexure
objection.
E.
Annexure E page 31, Lord. So office seal alliranta contents is not readable. That is only the office objection, Lord.
You are the complainant, huh?
Pardon, Lord?
You are the complainant.
I am the owner of this property, Lord. Lord, this on 23/10/1991, this petitioner purchased this property. Thereafter, in order to develop this property by constructing a residential house, Lord, he approached the BBMP and then he applied the plan for construction that, Lord. That is annexure E page 31.
Plan is sanctioned.
Plan is sanctioned. That is building licenses page 32, Lord. Annexure F page 32. So the license has been granted to construct ground plus 3. Naturally then. Residential 1 ground plus 3. Lord, kindly see annexure G1 is the building that photographs. He is putting up construction only as per the plan, Lord. That is ground plus 3. So thereafter, Lord, this without even issuing any notice and seeking for the any explanation or calling me to produce the document.
One floor additional
Plus, page G1 nalli 33 notice.
Photograph.
G1 nalli. Lord, kindly see ground plus 3, Lord, kindly see.
Side al nodi sir. 4ನೇ floor ಕಾಣ್ತಾ ಇದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಇತ್ರದ್ದು ಡಿಸೈನ್ ಮಾಡಿರೋದು ಇಲ್ಲಿ ಕಾಣುತ್ತೆ. ಮರಳು ಹಾಕಿದ್ದಾರೆ.
ಏನಾಯ್ತು ಹೇಳಿ ನೆಕ್ಸ್ಟ್.
ನೆಕ್ಸ್ಟ್ ಏನು ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನಿದೆ ಅಂದ್ರೆ ದೇರ್ ಆಫ್ಟರ್
they have issued notice to you.
Yes, no.
Saying that
notice, prior notice has been issued and no, this explanation is sought from me. Then even in the provisional order, that is also not served. In also there is no reference with regard to that notice calling me from producing any document or seeking any explanation from me with regard to
the chief commissioner. There is an appeal provision.
Appeal provision is
go there.
now they are threatening, Lord, and also even the confirmation.
Here you should have gone there.
Allah, even confirmation order is also not served on me. That 1 week back only I came to know with regard to that, Lord.
No, sir.
One week back only I came to know this. Even the final orders, confirmation orders also not served to me. So that's why I approached this honorable court, Lord. The opportunity has not been given to this petitioner to produce these documents.
Yes.
To produce this document and also to establish that case he is not put up any construction by violating the plan approved by the
before the commissioner also.
Till that time there is, because for there is a apprehension, Lord, because for this notice has been a confirmation or provisional orders not served on me. Till that time
we will give you 2 weeks time. Go before the chief commissioner. Till then we will ask them not to do anything. Workal.
Till IAS consider anta, because for all regular sitting there iralla adukkoskara till consideration of my interlocutory application for that.
Office objections are overruled. Learned counsel Sri Pawan Kumar, who is present in the court, takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures from the learned counsel for respondent. Next para. Learned counsel for the respondent submits, raises a preliminary objection that the petitioner, who contends that being the owner of the property, he has secured a sanctioned plan and building license to put up ground plus
3, Lord.
3 floors. Comma, but the respondent authorities are threatening to take action and have issued notices under section 248(1) followed by an order of confirmation dated 27/12/2023, comma, but the petitioner has not received any notice and the allegation made by the petition respondents is incorrect. Full stop. Nevertheless, comma, the petitioner has an appeal remedy. Yaudralri?
253.
Under section
253.
of the Brihat Bengaluru Mahanagara Palika Act, 2020. To call in question any decision taken by the competent authority under the provisions of the said chapter, namely chapter 16. Full stop. Next para. Per contra, learned counsel for the petitioner submits that the petitioner has put up construction only in accordance with the sanctioned plan and the building license, and the action taken by the respondent authorities is contrary to facts and law. Full stop. Next para. Nevertheless, comma, having regard to the express provision contained in section 253, which enables the petitioner to file an appeal before the chief commissioner, comma, the writ petition stands disposed of, reserving liberty to the petitioner to approach the chief commissioner within a period of 2 weeks from today. Full stop. The chief commissioner may also consider any interim prayer that would be made by the petitioner. Full stop. Next para. Needless to observe that till the chief commissioner would consider the interim prayer that would be made by the petitioner, provided the appeal is filed within a period of 2 weeks, comma, the respondent authorities are directed not to precipitate the matter any further.
53, Prasanna Kumar CS.
Education institution. It's running a hostel for ladies in a rented premises. The neighbors, it appears to have larger complaint. ಹುಡುಗಿ ರಾಷ್ಟ್ರ ಮಾಡ್ತಾ ಇದ್ರೆ ಹುಡುಗರು ತುಂಬಾ ಓಡಾಡ್ತಾ ಇದಾರೆ, ನಮ್ಗೆ ತೊಂದರೆ ನ್ಯೂಸೆನ್ಸ್ ಆಗತ್ತೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟರು. ಆ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ they initiated the proceedings. I went there, okay, I don't want to rub with the neighbors. Give me 6 months time, I'll vacate it. They have given me only 7 days time to do it. Your lordship give me till the end of the December, I'll vacate it. I'll shift the hostel to some other place. I need some time to shift it, that's all.
I don't think that would be the ground on which action would be taken by the BBMP. Let us see the notice.
Your lordship may kindly see. Your lordship may see the annexure D, the complaint. Annexure D, the complaint given by the neighbors.
Notice is issued to you?
Notice issued to me.
Annexure E. Please read the notice.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಟ್ಟಡ ಸಂಖ್ಯೆ 12 ಮತ್ತು 14 ಶಿವಶಂಕರ್ ಲೇಔಟ್ 1ನೇ ಮುಖ್ಯ ರಸ್ತೆ ಟೌನ್ಶಿಪ್ ಹತ್ತಿರ ಬಾಗ್ಲೂರು ರಸ್ತೆ ಕಟ್ಟಿಗೆನಹಳ್ಳಿ ವಾರ್ಡ್ ಸಂಖ್ಯೆ 5ರಲ್ಲಿ ಬರುವ ಪೇಯಿಂಗ್ ಗೆಸ್ಟ್ ಎಂಬ ಉದ್ದಿಮೆಯನ್ನು ಅನಧಿಕೃತವಾಗಿ ಪೇಯಿಂಗ್ ಗೆಸ್ಟ್ ನಡೆಸ್ತಿಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು. ನಡೆಸುವ ಬಗ್ಗೆ ಸರ್ಕಾರದಲ್ಲಿ ಸ್ವೀಕೃತವಾದ ಮನವಿಯಂತೆ ಉಲ್ಲೇಖ 2, 3, 4ರಲ್ಲಿ ಸದರಿ ಉದ್ದಿಮೆಯ ಬಗ್ಗೆ ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ಅಗತ್ಯ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳಲು ನಿರ್ದೇಶಿಸುತ್ತಾರೆ. ಸದರಿ ದೂರನ್ವಯ 26/2/24 ದಟ್ ಇಸ್ ದ ಕಂಪ್ಲೇಂಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಖಂಡಿಸಿ. ಸ್ಥಳ ಪರಿಶೀಲನೆ ನಡೆಸಿದ ಕಟ್ಟಡದ ಸಂಖ್ಯೆ 12 ಮತ್ತು 15 ಶಿವಶಂಕರ್ ಲೇಔಟ್ 1ನೇ ಮುಖ್ಯ ರಸ್ತೆ ದತ್ತಾ ಟೌನ್ಶಿಪ್ ಹತ್ತಿರ ಬಾಗಲೂರು ರಸ್ತೆ ಕಟ್ಟಿಗೆನಹಳ್ಳಿ ವಾರ್ಡ್ ಸಂಖ್ಯೆಯಲ್ಲಿ ಬರುವ ಕೇಂಬ್ರಿಡ್ಜ್ ತಾಂತ್ರಿಕ ಮಹಾವಿದ್ಯಾಲಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಪೇಯಿಂಗ್ ಗೆಸ್ಟ್ ಉದ್ದಿಮೆಯಾಗಿದ್ದು ನಾಮಫಲಕ ಅಳವಡಿಸಿದೆ ಪಾಲಿಕೆಯಿಂದ ಮತ್ತು ಪೊಲೀಸ್ ಇಲಾಖೆಯಿಂದ ಅನುಮತಿ ಪಡೆಯದೆ ಅನಧಿಕೃತವಾಗಿ ನಡೆಸುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಇದು ಕಾನೂನು ಬಾಹಿರ ಚಟುವಟಿಕೆ ಆಗಿರುತ್ತೆ ಹಾಗೂ ಸದರಿ ಉದ್ದಿಮೆ ಕಟ್ಟಡದ ಸಂಖ್ಯೆ 12ರಲ್ಲಿ ಸುಮಾರು 27 ಕೊಠಡಿಗಳಿದ್ದು ಅದರಲ್ಲಿ 80 ವಿದ್ಯಾರ್ಥಿಗಳಿರುವುದು ಹಾಗೂ ಕಟ್ಟಡದ ಸಂಖ್ಯೆ 15, 21 ಕಟ್ಟಡಗಳಿದ್ದು 71 ವಿದ್ಯಾರ್ಥಿಗಳಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ ವಾಸಿಸುತ್ತಿರುವ ಸಾರ್ವಜನಿಕರಿಗೆ ತೊಂದರೆಯಾಗುತ್ತಿರುವ ಬಗ್ಗೆ ಸಂಬಂಧ ಬಂದಿರುವ ದೂರಿನ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ತಾವು ಈ ಪತ್ರ ತಲುಪಿದ 3 ದಿನದೊಳಗಾಗಿ ಸದರಿ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸೂಕ್ತ ಸಮಜಾಯಿಷಿ ನೀಡುವುದು.
Yes.
The complaint, your lordship, may kindly say annexed D.
Yes.
First para, second para. ಮೇಲ್ಕಂಡ ವಸತಿಗಾಗಿ ಕಟ್ಟಿರುವ ಗೃಹವನ್ನು
The building belongs to you?
The building doesn't
belong to me. It's a rented premises.
Rented premises.
Rented premises. I am accommodating my girl students in the hostel. ಅದಕ್ಕೆ complaint.
You have not taken the permission.
The question is, your lordship, may kindly see, they say PG, it is not PG, it is a hostel for the girl students.
Hostel go ಅಷ್ಟೇನೆ.
ಬೇಕಾಗಿ ತಗೊಂಡಿಲ್ಲ, ಒಪ್ಕೊಳ್ತೇನೆ. ನನಗೆ 6 ತಿಂಗಳು ಟೈಮ್ ಕೊಡಿ, ಹೊರಟೋಗ್ತೀನಿ. 6 ತಿಂಗಳು ಟೈಮ್ ಕೊಡಿ, ಖಾಲಿ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತೀನಿ. Humanitarian, I like to shift about 120 girls. ನನಗೆ ಬೇರೆ ಒಂದು ಜಾಗ ಹುಡುಕೋಬೇಕು ಹಾಸ್ಟೆಲ್ಗೆ. ಇಂಜಿನಿಯರಿಂಗ್ ಸ್ಟೂಡೆಂಟ್ಸು ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಕೊಡೋದು ಹುಡುಗಿರ್ಗೆ ಹಾಸ್ಟೆಲ್ ಹುಡುಗರು ಓಡಾಡ್ತಾರೆ, ತುಂಬಾ ನಮ್ಮ ನ್ಯೂಸೆನ್ಸ್ ಆಗ್ತಿದೆ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟರು. Your lordship, kindly say annexed D. I am not someone contesting the claim at all. I am prepared to quit, but I need some time. 7 ದಿವಸದಲ್ಲಿ ನಾನು 120 ಹುಡುಗಿರಿಗೆ ಹಾಸ್ಟೆಲ್ ಹುಡುಕ್ಲೆ. The humanitarian grounds. ನಾನು 130 ಹುಡುಗಿರು 140 ಹುಡುಗಿರು ಇದಾರೆ ಸ್ಟೂಡೆಂಟ್ಸ್, ನಾನು ಎಲ್ಲಿ ಕಲಿಸ್ಲಿ ನಾನು ಅವ್ರನ್ನ? ನನಗೆ 6 ತಿಂಗಳು ಟೈಮ್ ಕೊಡಿ, ನಾನು ಖಾಲಿ ಮಾಡ್ಬಿಡ್ತೀನಿ. I don't seek any more time. 7 days ನಲ್ಲಿ ಆಗತ್ತೆ. ಬೆಂಗಳೂರಿನಲ್ಲೂ ಅಷ್ಟು ರೂಮ್ ಇರೋ ಒಂದು ಬಿಲ್ಡಿಂಗ್ ಹುಡುಕಿ ನಾನು ಅವ್ರನ್ನ ಶಿಫ್ಟ್ ಮಾಡೋದಕ್ಕೆ ಫರ್ನಿಶಿಂಗ್ ಇದೆ, ಇದಿದೆ, ಅದೆಲ್ಲ ಶಿಫ್ಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಪ್ರಾಕ್ಟಿಕಲ್ ಡಿಫಿಕಲ್ಟೀಸ್
Cannot be a reason, sir, to postpone action which is sought to be taken in accordance with law.
This true. ನಾನು ಕೇಳಿದ್ದೆ 6 ತಿಂಗಳ ಟೈಮು, ನಾನು ಇನ್ನೇನು ಕಂಟೆಸ್ಟ್ ಮಾಡಲಿಲ್ಲ.
ಕೊಡೋದಕ್ಕೆ ಅವ್ರಿಗೆ ಪವರ್ ಇಲ್ಲ.
ಅಲ್ಲ,
such power.
The court has the power. The court has the power. It's a mercy petition before this court.
No.
Entire in the residential area, my lordship. That is a residential area.
ಅಲ್ರಿ, ನೀವು ಓನರ್ಗೂ ನೋಟಿಸ್ ಕೊಡದೆ ಇವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ.
He is running the business, my lordship. He is running the commercial activities.
ನೀವು ಯಾರಿಗೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು?
Owner, my lordship.
ಮತ್ತೆ
Actually, he took the rent, we have showed the notice from the tenant, my lordship.
ನನಗೆ ಓನರು ಬಿಲ್ಡಿಂಗ್ ಕೊಟ್ಟ, of course I should have done it. I fairly admit that there is some lapse on it, but that should not be penalized the entire student community, girl student. ನಾನು ಎಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋಗ್ಬಿಡ್ಲಿ ನಾನು?
Only 30 days time, sir.
30 days ಆಗೋದಿಲ್ಲ, ಬಿಲ್ಡಿಂಗ್ ಹುಡುಕಕ್ಕಾಗಲ್ಲ. ಅಲ್ಲಲ್ಲ,
that is your problem.
ಅಲ್ಲ, ನನ್ನ
in a rented place.
ಅಲ್ಲ, ನನ್ನ ಪ್ರಾಬ್ಲಮ್ ರೆಂಟೆಡ್ ಪ್ರೆಮಿಸಿಸ್. ನಾ ಇನ್ನೊಂದು ರೆಂಟೆಡ್ ಪ್ರೆಮಿಸಿಸ್ ಹುಡುಕ್ಬೇಕು.
ಹುಡ್ಕೋತಾರೆ
ಯಾರು?
You don't have a building.
No, I accommodate.
You don't have a building.
No, I don't have a building. I run the hostel. They come with all outstation student, girl students. So ಅವ್ರಿಗೋಸ್ಕರ ನಾನು ಇದು ಮಾಡಿದ್ದೀನಿ. ತಾವು ಒಂದು
Learned Counsel Sri Pategoda PK
KV, my lordship.
KV undertakes to file Wakalat for both the respondents. Number akri 1 and 2 ಅಂತ ನಂಬರ್ ಹಾಕ್ರಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಗೆ.
1 and 2 respondent ಇಬ್ಬರೇ ಇರು 1 and 2.
ನಂಬರ್ ಇಲ್ಲ ಇಲ್ಲಿ.
ನಂಬರ್ ಇಲ್ಲ ಅಂತ
Respondent number 1 and 2 ಇದೆಯಲ್ಲ?
ನಮ್ಮಲ್ಲಿ ಇಲ್ಲ ಸರ್.
ಅಲ್ಲ
ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಸರ್, ಸಾಹೇಬ್ರ ಕಾಪಿ ಇಲ್ಲ ಅಂತ ಇರೋದು.
ನಮ್ಮಲ್ಲಿ ಇಲ್ಲ ಸರ್.
I'm sorry.
I am requesting your colleague, please to do it.
I'll see that, Aman. I'm sorry, I don't know. ಈ ಕಡೆ ಇಲ್ಲ, ಈ ಕಡೆ ಫೈನಲ್ ಮಾಡಿದ್ದೆ, postponement number 1 and ಈ ಕಡೆ.
Learned counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures from the learned counsel for the respondent. We'll stop. Next para. Learned counsel for the petitioner submits that the petitioner institution is running an engineering college and in a rented premises, the petitioner has made accommodation for hostel facility for the girl students studying in the college. Full stop. Action is sought to be taken by the respondent authorities on a complaint said to be made by the local residents, comma, at annexure D, comma, alleging that the petitioner has been running the hostel facility bar paying guest facility without obtaining necessary permission from the respondent BBM. Full stop. Learned counsel submits that the petitioner does not dispute the fact that the petitioner has made accommodation for the girl students to occupy the rented premises. Full stop. Nevertheless, comma, learned counsel submits that this court should take a lenient view having regard to the fact that girl students are residing in the premises and it would be highly difficult for them to vacate the premises immediately. Full stop. Next para. Although this is a mercy petition, comma, nevertheless, having regard to the admitted fact that the hostel bar paying guest facility is being run by the petitioner without obtaining prior approval from the respondent authorities, and since the building is not sanctioned for hostel facility or paying guest facility, comma, the respondents cannot be prevented from proceeding in accordance with law. Stop. Next para. Nevertheless, comma, having regard to the difficulties that the girl students may face, comma, the petitioner is granted 4 weeks time to ensure that alternative arrangement is made to the girl students, or they may themselves make any alternative arrangement. Full stop. Release this matter
Could your lordship make it,
on 15th of July.
could your lordship make it 8 weeks, my lord? When otherwise, it's difficult to,
No, no, sir.
relocate all the girls in the, because
54.
they'll have to be ferried by my bus. If they go to different places, I can't come and do it. Your lordship will make kindly 8 weeks, man. It's, as I said, it's a mercy petition. It's on behalf of the 8 weeks, your lordship will make it. I'll make, see that they make efforts to get the another premises. 4 weeks would be too short, man.
ಆಯ್ತು 8 weeks ಅಂತ ಮಾಡಿ release this matter on 12th of August. Yes.
Much obliged.
Serial number 54, Vivek BR.
But petitioner number 2 is running a nursery in CV Ramanagar. Petitioner number 1 is the owner of the
property. And BBMP has issued a closure notice stating that it's a commercial activity and it is not permitted to run.
Previous matter lay. In office objection ಏನದು?
The office objection was with regarding to filing of tracking sheet for having sent the copies to the caveator advocate. The caveator advocate has
Office objection is overruled. Yes.
Yes. But BBMP has issued a notice to me saying that I am running a commercial activity within the residential zone, therefore and it has ordered for closure of the school. I had issued a reply. In fact, initially this similar notice was issued way back in the year March 2022, my lord, at annexure F, page number 41. Thereafter, I have filed replies and I have produced the sanction plan, approved building sanction plan and approved plan, everything, and also tax paid receipts, confirming, and I have communicated to them saying that this particular school property, it is located within a residential zone demarcated for mixed use, wherein a nursery school is a permitted activity. It is not a commercial activity. And I have even communicated to them with the zoning bylaws saying that I have not violated any of the regulations. And even though it's a residential property, I am paying taxes for commercial rates. I have enclosed tax paid receipts. After receiving my reply in the year 2022, they kept quiet, my lord. And after 2 years now, similar notice came to be issued in January 2022. Again, I have submitted my lord, that notice your lords will find at annexure L, page number 47. To annexure L 40, page number 47 is the notice issued by BBMP.
Yes.
This is in January.
Yes.
Similarly saying that we are running a nursery school, which is not a permitted activity, and I should asking me to submit certain documents, to which my reply is at annexure M, page number 49. At annexure M, I furnish a reply along with a copy of the building sanction plan, registration certificate obtained from the education department, and also tax paid receipts.
Building plan approved by the Gram Panchayat.
My lord, back then, this building was constructed in the year 1985, my lord.
This building is situated at Nagavara Palya.
Yes, ma'am. The sale deed is in the year yes, ma'am. The sale deed is in the year of 1982. I constructed the building in the year 1985. And subsequently, I have used it sometime for residential use, my lord. Recently, from last couple of years, I have given it to petitioner number 2 for running a nursery. And they have been running a nursery school there. And I have produced all the documents at annexure M, my lord, including the tax paid receipts and the building sanction plan, approved plan.
Registration certificate issued by the regional education officer.
Yes, my lord. In favor of petitioner number 2 for running the nursery school there.
Where is it?
My lord, that registration certificate, your honors will find it annexure E, page number 39. This is issued in favor of petitioner number 2.
Pre-primary.
Yes, my lord. That is nursery. To annexure M, my lord, I have issued this letter along with all the supporting documents. My letter was not considered. My response was not considered, and subsequently, my lord, the annexure A came to be passed, the closure notice. And annexure A, my lord, very cryptically says, your reasoning is Samaja issues, samanjasavagiruvodilla. Ashte reason. Yenak samanjasavagirodilla gottilla. Annexure A at page number 20 is the impugned order. They've not even mentioned what is the provision of law that I have violated.
Yes, let us see the zonal regulation.
Yes, my lord. Your Honor, may I have produced at annexure page number 55, my lord. Annexure Q2.
No.
Regulation, I have a copy of the regulation. Kindly. This is zoning regulation revised master plan 2015. I have just provided the extract, madam. Residential mixed zone, what are the internal page number 3? Residential mixed zone. Permissible land use. Main land use category are under residential. Ancillary land category C3, I2, T2, U4. U4, my lord, your honors may kindly take the next page. U4. In U4, it says all uses of U1, U2, U3 are permissible. In U1, my lord, at serial number 3, primary schools subject to separate space standards. While even a primary school is allowed to operate under a residential zone which is classified for mixed use.
What is this space standards?
Lord, space standard has been that whether I am compliant with the space standard or not, it is the education department, and they have produced all the documents.
No, sir.
Yes, my lord.
No.
Unless I had complied with the space standard, the education department would not have.
And
yes, my lord.
That you will have to apply for a sanction of a plan.
Yes, my lord.
In terms of the zonal regulation. Even if it is permissible.
Yes, my lord.
For you to use a small portion of the property for commercial use.
Yes.
You will have to still show it for that purpose in the plan. That has to be sanctioned by the authority.
Very well. My lord, I have assessed.
ನಿಮ್ಗೆಲ್ಲ ಹಿಂಗ್ ಇಷ್ಟ ಬಂದಂಗೆಲ್ಲ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ ಸರ್.
ಅಲ್ಲ ಸೊ ಇದರಲ್ಲಿ ನಾನು ಇದು ಪ್ರೈಮರಿ ಸ್ಕೂಲ್ಗೆ ಸ್ಟ್ಯಾಂಡರ್ಡ್ಸ್.
If we don't try to implement all this.
Yes, madam.
We are seeing what are the consequences.
Very well, I very well understand, my lord.
Come before the court of law, you should be clear.
My lord, it is not their case that I am not compliant with the space standard.
That I have complied with all the requirements of law and therefore they cannot take action against me.
My lord, that's
otherwise not possible.
I will produce the necessary requirements for running an pre-primary school, my lord.
Yes.
I will produce that before your lordships. Your honors may kindly have it tomorrow or day after. I am compliant with all the statutory requirements, my lord, for running the
We will
nursery.
do one thing. We will ask the respondents to consider your reply and give a proper pass a proper order giving the reasons for not accepting the reply given by the petitioner.
Very well.
ನೀವು ಏನು reasons ಇಲ್ಲದೆ ಸುಮ್ಮನೆ cancel ಮಾಡ್ಬಿಡಿ ಅಂತ there is no reasons at all. You will have to refer to the provisions of law and say why it is not permissible for them to continue with the school there. We will dispose of the writ petition with such a direction. We will set aside this annexure A.
Lord, let them.
This is a notice, isn't it? Annexure A is a show cause notice.
Lord, this is a closure order, Lord. ಈ ಕೂಡಲೇ ನೀವುಗಳು ಕಟ್ಟಡವನ್ನು ವಸತಿ ಕಟ್ಟಡವನ್ನು ವಾಣಿಜ್ಯ ಕಟ್ಟಡವಾಗಿ ಪರಿವರ್ತಿಸಿ ಅನಧಿಕೃತವಾಗಿ ಶಾಲೆ ನಿಲ್ಲಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ. And subsequent to this, they have issued a letter to Bescom asking them to disconnect the power supply.
Yes. Barkal. Learned Counsel Sri Pawan Kumar, who is present in the court, takes notice for the respondent BBMP. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned counsel for the respondent. Full stop. Next paragraph. The petitioners are aggrieved of the impugned order at annexure A dated 3/2/2024 passed by the Assistant Executive Engineer, BBMP, CV Raman Nagar Subdivision, calling upon the petitioners to close down the nursery school which is run by them in the premises in question. Full stop. Learned Counsel submits that earlier too, in the year 2022, such a notice was issued to the petitioners, and on being satisfied with the reply given by the petitioners, no further action was taken by the respondents. Full stop. Nevertheless, the Assistant Executive Engineer has proceeded to now call upon the petitioners to close down the nursery school. Full stop. Learned Counsel submits that earlier, when a notice was issued, by the Assistant Executive Engineer on 16/1/2024 at annexure L, calling upon the petitioners to show cause as to why action should not be taken to close down the nursery school, the petitioners caused a reply dated 20th of January 2024 at annexure M. Full stop. Learned Counsel submits the petitioners had, along with the reply, furnished copy of the building plan approved by the then Bayappanahalli Gram Panchayat, semicolon, the registration certificate dated 19/8/2022 issued by the Regional Education Office, permitting the petitioners to run the nursery school, semicolon, tax-paid receipts to show that the petitioners had paid the property tax on the basis of non-residential premises, semicolon. Copies of the earlier reply, earlier notice dated 25/3/2022 and the reply notice dated 25/4/2022. Full stop. The Learned Counsel would further submit that in spite of such a reply being given by the petitioners, the impugned order has been passed without assigning any reasons having regard to the documents furnished by the petitioners. Full stop. Learned Counsel would further submit that even in terms of the zonal regulations, in terms of the revised master plan, the property in question falls within residential bracketally mixed closed zone, and it is permissible to establish and run primary schools, subject to space standards, and nursery creches in terms of table 6, category U1 dash public and semi-public category in as ancillary uses permissible in residential bracket mixed close zone, full stop. Next para. Having regard to the contentions of the learned counsel for the petitioners, this court is of the considered opinion that the concerned assistant executive engineer is required to pass reasoned orders having regard to the reply given by the petitioners. Full stop. Next para. In that view of the matter, the writ petition is partly allowed while setting aside the impugned order at annexure A dated 3/2/2024. Full stop. The matter stands remanded back to the assistant executive engineer, CV Raman Nagar subdivision to reconsider the written reply given by the petitioners, the submissions recorded by this court in the present order, afford an opportunity of hearing to the petitioners and thereafter pass a reasoned order. Full stop. Next para. Ordered accordingly.
Number 55, Vasantappa.
The only office objection is that, my lord, seal and signature of in the plan annexure D is not visible on that. Not claiming any relief on that annexure D, my lord. There is a modified plan in the very next annexure, my lord, annexure D1.
Office objection regarding annexure D is overruled for the time being.
Yes.
Yes.
Petitioner is the owner of the property, my lord. Secure the sanction plan for construction of residential apartment consisting of ground, first, second, third, fourth, and terrace floor, my lord, which is at annexure D1. Now, my lord, the respondent BBMP caused the notice and confirmed the confirmation order is passed at annexure G2, my lord, page number 124. Contending that, my lord, I have not obtained the sanction plan for the construction of fourth and terrace floor. There is a plan sanction, my lord. I have not violated any conditions of the plan sanction. Yes, my lord.
If they are saying no, that plan is not sanctioned to put up that additional floor, how
No,
can
my
you
lord,
contend? No,
No, my lord,
please look at the
there is a
plan.
plan. There is a plan to construct first, second, third, and terrace floor, my lord. Fourth floor is also there. Can't you see the plan, my lord?
Yes.
At annexure D1.
Yes.
Ground floor. In the middle of the sanction plan, my lord, at the first floor, second, third, fourth, and terrace floor.
Ground, first, second, third, and fourth.
Fourth. And that side, my lord, terrace floor is also there. Terrace floor.
Terrace floor, ಖಾಲಿ
ಅಷ್ಟೇ ಖಾಲಿನೇ ಅದು ಖಾಲಿ ಅಂತಂದ್ರೆ ಬರೀ ಮೆಟ್ಲಿಗೆ ಏನೋ ಒಂದು ಇದು ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ
ಅಷ್ಟೇ. ಇದಕ್ಕೆ ಏನೋ
ರೈನ್ ವಾಟರ್ ಬರ್ದಿರಾ ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಅಂಡ್ ಲಿಫ್ಟ್ ರೂಮ್, ದೇರ್ ಇಸ್ ಎ ಲಿಫ್ಟ್ ರೂಮ್
ಅಷ್ಟೇ.
ಅಷ್ಟೇ ಸ್ವಾಮಿ ಮಾಡ್ರು. ಅಷ್ಟೇ ಮಾಡ್ರು. The respondents authorities without inquiring, without spot inspection, my lord, they have issued the
Can't be so
notice
simple,
stating
sir.
that we have constructed, we have violated the sanction plan. Without obtaining the sanction plan for construction of fourth floor.
Two fact-finding authorities cannot go wrong so easily, sir.
There is a sanction plan for construction of fourth floor.
Sir, if you put up only as many floors has been sanctioned, why would they want to take action against you?
No, my lord, we have not constructed.
Yes,
They let them inspect and
Yes, yes.
produce the report, my lord.
That is the
Tomorrow
opinion of
itself.
the tribunal also.
Tribunal is also approached, my lord, the commissioner, before the commissioner. Commissioner is also confirmed that order, my lord. At page number 138, madam. Annexure H1.
Fifth floor, please come to page number 122. Fifth floor. ಮಂಜೂರಾತಿ ನಕ್ಷೆಯಲ್ಲಿ 5ನೇ ಮಹಡಿಯನ್ನು ನಿರ್ಮಿಸಲು ಅನುಮತಿ ಇರುವುದಿಲ್ಲ. ಆದರೂ ಪರಿಶೀಲಿಸಲಾಗಿ ಕಟ್ಟಡದ ನಿರ್ಮಾಣಕಾರರು ಹೆಚ್ಚುವರಿಯಾಗಿ 5ನೇ ಮಹಡಿಯನ್ನು ನಿರ್ಮಾಣ ಮಾಡಿದ್ದು ಮಂಜೂರಾತಿ ನಕ್ಷೆಯನ್ನು ಸಂಪೂರ್ಣವಾಗಿ ಉಲ್ಲಂಘನೆ ಮಾಡಿರುವುದು ದೃಢಪಟ್ಟಿರುತ್ತದೆ.
And above that also, my lord, ಮಂಜೂರಾತಿ ನಕ್ಷೆಯಲ್ಲಿ 4ನೇ ಮಹಡಿಯನ್ನು ನಿರ್ಮಿಸಲು ಅನುಮತಿ ಇರುವುದಿಲ್ಲ ಅಂತ ಬರೀತಾರೆ. ಅದ್ರ ಮೇಲೆ ಸ್ವಲ್ಪ. ಮಂಜೂರಾತಿ ನಕ್ಷೆಯಲ್ಲಿ 4ನೇ ಮಹಡಿಯನ್ನು ನಿರ್ಮಿಸಲು ಅನುಮತಿ ಇರುವುದಿಲ್ಲ. ಆದರೂ ಪರಿಶೀಲಿಸಲಾಗಿ ಕಟ್ಟಡದ ನಿರ್ಮಾಣಕಾರರು ಹೆಚ್ಚುವರಿಯಾಗಿ 4ನೇ ಮಹಡಿಯನ್ನು ನಿರ್ಮಾಣ ಮಾಡಿದ್ದು ಮಂಜೂರಾತಿ ನಕ್ಷೆಯನ್ನು ಸಂಪೂರ್ಣವಾಗಿ ಉಲ್ಲಂಘನೆ ಮಾಡಿರುವುದು ದೃಢಪಟ್ಟಿರುತ್ತದೆ. But there is a plan for construction of fourth floor. This shows, my lord, that they have not at all inspected the property. And even, my lord, they have not issued the notice to the petitioner, who is the owner of the property. At the end of the notice, my lord, they have stated that yes, Ramesh antare. Ramesh yaru antano gottilla, who is a stranger to the petitioner family.
This factual information, but what is provided cannot be.
Let them inspect, my lord. Let them inspect and produce the report tomorrow itself, my lord. We have constructed the property as per the sanction plan.
Where is the photograph?
Photograph ಹಾಕಿಲ್ಲ sir. Photograph ತಂದಿಲ್ಲ.
ಯಾಕೆ?
ಹಾಕಿಲ್ಲ sir. By oversight.
Oversight.
ಇಲ್ಲ, ಬೇಕಾದ್ರೆ ನಾಳೆನೇ ಹಾಕೊಳ್ಳಿ ಸರ್, ಬೇಕಾದ್ರೆ ಹಾಕೊಡ್ತೀನಿ ನಾನು. ಏನು ತೊಂದರೆ ಇಲ್ಲ. ನಾಟ್ ಇದನ್ ಸರ್.
When is the order passed by the KAT?
KAT, my lord, it's on based on the earlier notices issued by the
So ಇವಾಗ chief commissioner.
Chief commissioner is at 123, my lord. Now 138. Annexure H1.
1/4/2023. Huh?
Please, madam.
More than a year.
Yes, my lord. Now they are again threatening to demolish the building, my lord.
Why nothing is said about the modified plan?
The
order?
earlier plan also, my lord, the same floors is obtained, my lord.
Huh?
In the earlier plan also, that annexure D, my lord.
What is the difference between that earlier plan and modified plan?
What difference, my lord? I think, my lord, in the earlier plan also ground floor, first, second, third, fourth, and terrace floor is there, my lord.
ಅಂದ್ರೆ ಈ
It was
ಆರ್ಡರ್
obtained. Please, my lord.
ದೇಸೆ ತಳ ನೆಲ ಮೇಲಿನ 3 ಅಂತಸ್ತುಗಳು ಅಂತಾರೆ. ನಾಟ್ ಗ್ರೌಂಡ್ ಪ್ಲಸ್ 4 ಫ್ಲೋರ್ಸ್.
ಅಲ್ಲ in the
as you are contending.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಅಂತಾನೆ ಇದೆ sir.
There is no mention of that modified plan itself.
Modified plan ಅಲ್ಲಿ
in the order of the chief commissioner,
please,
there is no reference to the modified plan.
But sanction to construct ground floor ಅಂತಾನೆ ಇದೆ. Ground floor, first, second, third, fourth, and terrace floor.
Then you have to produce a better copy of annexure D then.
Please, madam, I will furnish.
ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಸ್ ಓವರ್ ರೂಲ್ಡ್ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, ತೆಗೆದಾಕ್ಬಿಡಿ. ಅಲ್ಲಿ the petitioners are required to furnish an enlarged better copy of annexure D by the next date of hearing. Next para. Learned counsel Shri Pawan Kumar, who is present in the court, takes notice for all the respondents. Learned counsel for petitioner is directed to serve 2 sets of copies of the petition along with annexures on the learned counsel for the respondent BBMP. Full stop. Next para. Learned counsel for the petitioner submits that although a modified plan was sanctioned ಅದೇ ರೆಫರ್ ಮಾಡ್ತಾರೆ 2014 ಅವರು.
2014 is.
That is what has been mentioned. Modified plan mention ಮಾಡ್ತಾರೆ, but on 3/11/2014, permitting the petitioner to put up residential apartments consisting of ground, first, second, third, and fourth floors. Nevertheless,
along with the terrace floor.
Terrace is terrace.
Sorry.
It is not for construction, sir.
Yes, ma'am.
4th floor ಕಟ್ಟದ ಮೇಲೆ ಮೇಲ್ಗಡೆ ಟೆರೇಸ್ ಇದ್ದೇ ಇರುತ್ತೆ.
ಅಲ್ಲ ಅದ್ರ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಅಲ್ಲಿ ಇತ್ತು ಅದಕ್ಕೋಸ್ಕರ.
ಅದೇ ಟೆರೇಸ್ ಅಲ್ಲಿ ವೇಕೆಂಟ್ ತೋರಿಸಿದ್ದಾರೆ, ನಾಟ್ ಫಾರ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್. Nevertheless, On remand, the Chief Commissioner has stated in the impugned order that plan was sanctioned for putting up basement plus ground plus 3 upper floors. Full stop. Learned counsel submits that the petitioner has put up construction only on ground plus 4 upper floors in terms of the sanction plan. What about the violation in the setback area?
That also, my lord,
37.60% violation.
that is my, without inspection, my lord, my contention is that, my lord, they have not at all inspected the the scheduled premises.
ಹೌದು ಹಂಗೆ ಬರ್ಕೊಂಡ್ಬಂದ್ಬಿಡ್ತಾರೆ. Full stop. The learned counsel would further submit that the finding regarding the violation in the setback area is also without notice to the petitioner. Full stop. Next para. However, learned counsel for the respondent BBMP submits that the impugned order was passed by the Chief Commissioner on 1/4/2023 and there is no immediate threat as sought to be made out by the petitioner. Full stop. Next para. Release this matter on 26th of June 2024. Full stop. Learned counsel for the respondent BBMP is directed to secure instructions from the third respondent, assistant executive engineer, regarding the variation in the factual information as could be seen from annexure D1, the modified plan and the findings of the Chief Commissioner. Full stop. Yes.
Pass over matter.
ಏನು ಮಾಡಲ್ಲ ಬಿಡ್ರಿ.
Not to precipitate at least, my lord. They are coming near the scheduled property, my lord. They are threatening to demolish, my lord. At least not to precipitate.
The respondents are directed not to precipitate the matter any further.
Great.
Pass over matter.
Pass over matter. Serial number 31, SV Prakash. SV Prakash.
The request of learned counsel for petitioner, release this matter on 14th of June 2024 for orders. Yes.
Serial number
32.
Serial number 32.
Huh? ಅಜ್ಜನ್ ಆಯ್ತಾ? Yes, yes.
Serial number 44.
Appearing for respondent number 6, my lords, can I kindly have it tomorrow, my lord, senior counsel has expressed his. My lords, senior counsel, dear Ravi Shankar is currently traveling to Dharwad.
44.
So, can you please take him the next week, my lord?
Belagge he was heard,
Senior
my lord.
counsel is traveling.
Kindly have it tomorrow.
My lords, senior counsel is traveling to Dharwad right now, so can you please take in the next week? Humble request.
Heard. Learned senior counsel Sri Jaikumar S. Patil for the petitioner for some time. Full stop. Release this matter on when you on 19th or 20th? On 19th of June 2024
Kindly,
for further
My lords can
at 2:30 p.m.
please, grateful.
my lords, subject to my lord's convenience, could it be on 20th, my lords?
ಆಯ್ತು 20th.
Oblige.
30, my lord.
30.
Great, please.
Much obliged.
47. Mahesh BJ. 47. Serial number 47.
My lord.
I'm pretty sure I am here.
ಏನು ಪಾಸ್ವರ್ಡ್ ಮಾಡಿದ್ರು?
I'm trying for extension of interim order, my lord.
At the request of learned counsel for the, where is the, you didn't get the file?
No, another, the opponent, advocate.
No, Mr. Karthikeyan.
For BJ Mahesh.
Please come this side.
Sorry.
At the request of learned counsel for the respondent BBMP, release this matter on 19th of June.
Much obliged.
Hearing interlocutory application.
May I make a submission? If my lordships permit, I'll place the affidavit on record.
47.
Sir.
Kindly extend that,
Learned counsel for Sagdakudiyadu. Learned counsel for the respondent BBMP has furnished the affidavit of the V. Samandaya, Assistant Director Town Planning, RR Nagar Zone, BBMP. Full stop. Copy of the same is served on the learned counsel for petitioner.
kindly extension of interim order, I'm praying for them.
Next para. Release. What is the matter?
My lords, it is about the mobile tower, my lords. Similar to serial number 11, my lords. There locality nalli irorellaru ಬಂದು complaint ಕೊಟ್ಟಿದ್ದಾರೆ. Telling that.
ಕೊಡ್ತಾರೆ, complaint ಕೊಡ್ತಾರೆ. Now it is for you to see if action has been to be taken, it should be taken only in accordance with law.
Yes.
It is not now, you simply cannot accept the such contentions.
Yes.
Because otherwise you will not be able to put up towers anywhere.
Yes, sir. Yes. Go down, my lord, yes. ಏನಾಗಿದೆ sir?
Not possible.
So they have got too much of pressure from political pressure, they've got pressure from the police, from the local corporator. ಎಲ್ಲ ಕಡೆಯಿಂದ ತುಂಬಾ pressure ಬಂದು we had to pass this order. I'll leave it to my lordship's decision, my lords. I've placed the documents also on
This
record.
is erected according to Karnataka Municipality Telecommunication Infrastructure and
Next para.
Act only. So,
A week's time is granted to the petitioners to file objections to the affidavit. Release this matter on 26th of June.
Hearing interlocutory application. Serial number 56.
My lord, I have filed IA, my lord, seeking for corrections in the order, my lord. Clerical mistakes, my lord. typographical mistakes ಇದೆ. I sought for corrections in the order.
Correction in the name ಅಷ್ಟೇನಾ?
Name ಅಷ್ಟೇ. In both the writ petitions.
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ?
In writ petition 53019, page number 4, para 3, line number 3 మరి. Line 3, Celestine Montero ಅಂತ ಆಗಿದೆ. ಅದು Celestine Miranda ಆಗ್ಬೇಕು. Page number 4 of the order. ನಾನು IN ಅಲ್ಲಿ page number 11. So
Order on IN number 1 of 2024. This application is filed by the petitioners seeking correction of a typographical error. More particularly, the name Celestine Miranda, which is wrongly typed as Celestine Monterio in paragraph number 3. ಆಮೇಲೆ
ಈ writ petition ಅಲ್ಲಿ ಅಷ್ಟೇ ಸ್ವಾಮಿ, ಒಂದೇ ಕರೆಕ್ಷನ್. ಇನ್ನೊಂದು writ petition ಇದೆ, ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್. ಇದ್ರಲ್ಲಿ ಒಂದೇ ಸ್ವಾಮಿ ಕರೆಕ್ಷನ್.
Full stop. Next para. Accepting the submission of the learned counsel for petitioner. The application is allowed. Full stop. Office is directed to correct the name accordingly and issue a fresh certificate copy. ಇನ್ನೊಂದು ಯಾವ್ದ್ರಿ?
ಇನ್ನೊಂದು writ petition 2024 of 2015. In that, para 2 of the order at page number 18 of my application. ಇದರಲ್ಲಿ ಒಂದು 5 corrections ಇದೆ. Para 2, line number 2, page number 18. ಇದರಲ್ಲಿ ಲೂಯಿಸ್ ಮೊಂತೆರೋ ಅಂತಿದೆ, ಅದು ಸ್ಪೆಲ್ಲಿಂಗ್ ಒಂದು ಇದಾಗುತ್ತೆ. MONTEIRO ಆಗ್ಬೇಕದು. And next line 3 ನಲ್ಲಿ the mother of the petitioners here in other, actually the father of the petitioners.
Same order. Certain corrections, typographical of the typographical errors, particularly in respect of the name Mrs. Louis Monterio, which is wrongly typed as Mr. Louis Monterio.
No, it is typed as Mr. Louis Monterio.
ಆಯ್ತು ಬಿಡ್ರಿ,
ಅದು ಮಿಸ್ಟರ್ ಆಗಬೇಕಷ್ಟೇ.
semicolon. Instead of showing the same as mother of the petitioners, comma, it is shown as father of the petitioners. Full stop. Similarly, in respect of the name Carmine Monterio, there is a spelling mistake. Full stop. Next para, office is directed to take note of all the mistakes as pointed out in the application, comma, correct the same and issue fresh certificate copy. Please.
58. Yes, Vasant Madhava. Impleading.
Your Lordships, kindly, my lords. I appear for the impleading applicant, my lords. I have filed the IA, my lords.
Lord, I'll file my statement of objections because the application tells it is for bona fide reasons the purchase, the impleading proposed respondent has purchased. Lord, the respondent number 4 was the party before KAT, before this honorable court from the last 2016. In spite of which she sells the property to the proposed respondent, my lord. Therefore, her contention in the affidavit, it is a bona fide, she is a bona fide purchaser, which I submit it's a wrong statement. I'll file my statement of objections.
Even what is the matter about?
Lord, the petitioner was put in.
May I request your Lordships to take this matter next week, my lords? I'll be present before your Lordships and argue the matter, my lords.
Please wait.
My lord,
Please, my lords.
I was sanctioned a site by the respondent number 1 society. Sale deed was executed and possession certificate was also issued. Subsequently, my lord, there was a change in sanction plan by BDA and the numbers were changed. All the adjacent sites were given rectification deed. When it came to my property, the secretary played a fraud and gave it to some other person who is the respondent number 2 before the Lordships. There's a preferably a fraud played, my lord. I have produced the a sketch also before your Lordships would go to show that all the 3 sites the rectification deed was executed. As far as my site came, they gave a the different person was brought into that particular place. My lord, the JRCS from whom before the
Without cancelling the allotment made to you.
Yes, ma'am. Without cancelling the sale deed, without doing it. My lord, JRCS tells
So you raised a dispute.
Yes, my lord. JRCS tells since a mistake is committed by the society.
Who is the person who is seeking to get impleaded?
Yes, my lord. He is a subsequent purchaser.
Purchaser.
Yes, my lord. She claims the possession from respondent number 4. In spite of these proceedings,
He or she will become a necessary
yes,
party.
no, what they have stated in the affidavit is that she is a bona fide purchaser.
That is
not
not going to be considered now, sir. Barkali. Order on IA number 1 of 2024. This application is filed by the proposed respondents contending that they are the subsequent purchasers at the hands of respondent number 2.
4 million. Sobhagyaman.
4. Respondent number 4, my lords.
Respondent number 5 in my petition. 5. Sobhagyaman.
4 is address.
Purchase from Sobhagyam.
Yes.
Sobhagyam is respondent number
5.
5. And therefore, the applicants interest will be prejudiced if they are not permitted to participate in the proceedings. Full stop. Next para. Learned counsel for the petitioner seeks to contend that the impleading applicants are claiming to be bona fide purchasers. Full stop. Next para. In the considered opinion of this court, the question as to whether the impleading applicants are bona fide purchasers or not is not the question to be decided in this application. Full stop. Nevertheless, since admittedly the applicants have purchased the property in question from the fifth respondent.
Yes.
And the petitioner is seeking to claim that the property was originally allotted and registered in favor of the petitioner. And the same could not have been resold to any other person,
Yes.
including respondents number 2 and later respondent number 5. Comma, in the considered opinion of this court, the impleading applicants will become proper and necessary parties to the proceedings. Full stop. Next, accordingly, the application is allowed. Learned counsel for the petitioner is directed to carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today.
My lord, similar application in the connected matter, my lords.
Same order.
Please.
58.2, same order.
59 order passed. Serial number 60. Chandana Tariga K. Serial number 60.
Here for the petitioner.
Yes.
My lord, petition is one for mandamus. Petition is under section 64, my lord, the facts are these. The petitioner before this honorable court had filed an application for licensement, that is pursuant to the orders of this honorable court in annexure E, page 16.
The respondents have not issued the building license.
They have not issued a building license. Therefore, there is the under 64 2, my lord, that if the building license is not issued within 60 days.
Deemed provision.
Yes, my lord. That provision is invoked. And to direct the respondent to issue the license. Under
You are appearing for?
I am for the PDO, my lords, Panchayat.
Panchayat,
Yes, my lords, respondent number 1.
what is the difficulty?
Lord, there were 2 resolutions, my lords, on 20/2/2023. Lord, one headed by Vice President and 14 members. Not resolving that, my lords, the license could be granted by imposing a penalty of ₹2,000, invoking the provisions of section, my lords, 298. Because, my lords, there was some deviation in the building construction. Therefore, my lords, to regularize it, my lords, a sum of ₹2,000 could be imposed as per the resolution passed by the members consisting Vice President and 14 members. Whereas, my lords, the President and other 9 members have not refused to agree for such a resolution and refused. Therefore, my lords, however, my lords.
And how many members?
President and 9 members, my lords. Out of 25 members, President and 9 members have disagreed.
Which side is the majority?
Lord, Vice President and 14 members. For which, my lords, by the time, my lords, writ petition is filed.
For what?
Lord, saying that, my lord, under provisions of section 64(2), non-consideration of the application for renewal of the revised plan and license, Lord, it would be amounts to deemed license. It is a declaration sought for in the writ petition.
Deemed license.
Because
and you will be the construction would be regularized only if it is in accordance with the building bylaws.
Building bylaws. There is no violation is one subject.
No, idiantalla. ಅದಕ್ಕೆ 2,000 ಏನೋ penalty impose ಮಾಡಿ
ಹೌದು.
they wanted to regularize it.
My lord, the petitioner is willing to
ಅಷ್ಟೇ ಮತ್ತೆ
pay
go ahead.
that.
What is the difficulty then?
Yes, there is no difficulty at all.
Who is this respondent number 2 and 3 who were subsequently?
Now, my lords, the president and vice president want, my lord, want to
Again, the
oppose. Vice president has
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
seen volte face.
Ours is a democratic setup. The same principles of democracy are required to be followed even in the panchayats, municipalities, or all local bodies.
The circumstances under which, my lord, president and vice president, circumstances under which, my lord, this president and vice president, this petitioner, my lord, himself went to the office of the earlier Panchayat advocate and he himself brought the file and give it to the.
That's all
president.
dealt with in the previous
Those
order.
circumstances, my lord.
See, whatever it is.
Yes, ma'am. Then
the
resolution.
It has been recorded.
Is resolution, my lord, on the same day, resolution was passed, my lord,
ಆಯ್ತು.
it was rejected.
Please understand.
Yes.
A opinion of the majority is in the meeting has to prevail.
It is rejected.
That is it.
It is rejected. On the
Majority.
Yes, it is rejected. Subsequently, my lord, after the other members went out, some of the member, my lord, passed this very same day, my lord, on the very same meeting, my lord, with the penalty, my lord. Here, my lord, he is having a 50. He is having.
President plus
Also,
Rejection is subsequent. Rejection is subsequent.
Produce
Lord,
the.
it was filed, my lords, on, along with the memo.
He is the
dated
owner of.
6/3/2024, my lords. 6/3/2024, a memo is filed, my lords, along with the resolutions. First, my lords, majority view, then, my lords,
In this respect of suit is filed, my lord, suit is dismissed, my lord, considering all this.
Naturally, these are not matters that can be taken up before the civil court.
They themselves.
Neither can it be brought before this court.
They themselves, my lord, filed a suit, my lord, regarding the, my lord, their owner is in respect of half cents. In the half cents, my lord, they have constructed 2 cents, they are encroaching the road and some other property. The application itself is filed for construction of 2 cents, even though he is having a owner of half cents, 225 square feet is the owner. He is constructed
is not
in
correct.
2 cents of land. Having considering all these things, my lord, it was rejected.
My lord, may kindly.
But
see
only thing is that was not communicated to the petitioner. That is
too-
under 64(2), my lord, decision was taken, not communicated. Even though they have a deemed license, my lord, he can construction only as per bylaws of the.
Correct.
That's all.
That is the
Construction
reason
was not as per bylaw.
298(3)(A) is attracted.
Then
And,
the other portion of the property which according to you is encroached upon, ಯಾರಿಗೆ ಸೇರಿದ property?
Panchayat road, man.
No, my lord, it is not a Panchayat road.
And other.
My lord, there was a, it is not the Panchayat road. My
Commission
owner,
report, in the another writ petition, commissioner was appointed, man, Karambai was appointed a commission, he submitted the report.
In another writ petition. Which writ petition?
I produced the commission report, man.
ಅಲ್ಲ, in another writ petition.
Yes, and another writ petition, but there is a dispute in the regarding the suit, my lord. And the matter was remanded to the suit, my lord, where, my lord, the dismissal order was passed in the suit. In the writ petition, my lord, commissioner was appointed by this court, my lord. Commissioner was submitted a report regarding the way. road.
Where is that?
In my, I produced.
Annexure R1, commission report.
Is. There are series of writ petition between the panchayat and parties, my lord. Paragraph 7 onwards, my lord, or 5 onwards, my lord. The PD of the panchayat has given me the copies of the photographs. It shows the parking of the car belonged to the respondent and also the name board of his office installed in the entrance of the existing road with direction. I asked the respondent whether the car shown in the photograph is belong to him or not, and name board installed is belong to him. He has told me that the car shown in the photograph belongs to him.
We
and
are
the-
not concerned with.
then-
my lord,
then
that is
para-
regarding the
seven,
approach
7,
road. Approach road to this particular property, not regarding the encroachment. Kindly see the report, my lord. It says, kindly
Para
see
eight.
paragraph 4.
Seven.
Yes, 7.
Seven.
On spot inspection and on the basis of the sketch prepared by me, I am submitting report to this honorable court that there is no road or pathway to approach the property in survey number 127/19 through the bus stand. The question was whether through that to open space, there is an approach road.
commissioner says there is no approach road. Now the question involved in this is under section 64 and 298A 3 is the answer, where they have passed the resolution. 14 members attended, and the president, who is inimically disposed of towards the petitioner because he is a practicing advocate, does all this. He again collects about 7 persons and signs a resolution which is never communicated. The basic question is whether within 60 days there was a resolution, a decision taken and communicated. 64(2) refers to communication of the resolution. They have not communicated it. They admit it. My lord, this is only an animosity against the petitioner, who is a practicing advocate in that area, who purchased the half cents, and later with the permission of the owner, 1.5 cents was included, for which the Panchayat had given permission, assented, PDO assented to it. Matter was taken in appeal. The appellate authority does not dispose of the application. Even till today, that is pending.
Another 1.5 cents were added under Artha?
That is from the owner. Owner has consented that, and consented for construction.
No.
My lord, kindly see
there is no title deed for that?
My lord, in the application, it is stated.
Which is the document of title, which forms the basis of your claim that you are the owner of the property and you are permitted to put up construction.
My lord, the permission was granted for half a cents. Permission was
title deed.
Title deed is the.
Where is your title deed?
I shall place it, my lord. Order of conversion is at page 13, annexure C, my lord. It is an order of conversion in respect of 13 cents of land which belong to my belong to the owner of the land. And after that, the owner has consented that 1.5 cents, additional 1.5 cents also I can permit. I can construct.
How?
Therefore, my lord,
without you acquiring the land,
yes,
in a manner known to law,
yes.
How can you say further it is permitted to be added?
My lord, the additional.
If you don't have document of title, how can you ask for permission to construct?
My lord, the 1.5 cents, the owner consented and annexure D was filed. And on that count, the Panchayat does not pass a resolution. Panchayat passes a resolution that this additional construction may be regularized. Annexure D. And this honorable court, in the document placed before the court at annexure E, refers to the fact that if an application is filed by the petitioner, a fresh application for sanction of the building, then it would not be an impediment for consideration of the application by the Panchayat. That is found at page 23.
The executive of the Taluk Panchayat has now passed an order?
No, he has not passed the order. He has not passed the order. And this for 1.5 lakhs, the
A
petitioner.
period of 4 weeks ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Yes, my lord, that was not done. And the petitioner herein is in possession of the 1.50 cents by an registered agreement of sale by which he was put in possession. And there is also a permission for construction of the building. That's a registered agreement of sale, my lord. And
Even if you claim that you have entered into an agreement,
and
that
was
will not give you a title.
No, my lord, the
Seek, permission to put up the construction.
general power of attorney is also executed, registered agreement of sale under, and he is put in possession. 53A comes into effect and he cannot, he is entitled to make an application.
No, no.
That application is not considered. And the president, because my lord, and also kindly see the earlier order of this court in the very same petition, he makes on, he goes on making several allegations against the person, and that was ordered to be deleted. That is the earlier order of this honorable court. And it is purely and the personal rivalry.
Let us forget all those things.
Please,
Let us only go by
the records.
On the merits of the matter. If you are the owner of the property, you are entitled to seek building license. They are bound to issue a building license if it is in accordance with law.
Yes, my lord, here is.
There is nothing more in this.
Yes. Because
they cannot, we will not permit them to say something else which are not germane to the issue.
My
Let us not go into all other aspects.
My respectful submission is.
So if you are able to convince this court that you are the owner of the property and you are entitled to put up the construction,
yes,
we will direct them to consider your application and dispose it off in accordance with.
Kindly have
No
it on,
difficulty.
kindly have it on 19th, my lord, I shall produce
the learned counsel for the petitioner is requested to place on record all material information showing the title of the petitioner over the land in question. Full stop. The learned counsel for petitioner as well as the learned counsel for the respondent, Panchayat, are requested to furnish a brief synopsis along with chronology of events.
Yes.
To enable the court to consider the matter on merits and dispose of the same. Full stop. Next week,
please, Miller. Before, yes, I shall furnish all the details.
Release this matter on 20th of June, 2024.
My lordship, item 59 was not taken up.
Clauses 2, serial number 1 and 1.1. Take it up next week.
Clauses 2.
Clauses 2, serial number 1 and 1. It is regarding clarification, modification of our IA was filed by respondent number 10, your lordship.
Respondent after clarification, but then respondent is only Civic, the rating agency.
You know what is this matter?
It is pertaining to the order which was passed by this honorable court on 26/9/2023. It was coercive measure was given to respondent number 5 and 6 and direction respondent number 5 and 6 are the bank, your lordship. And the petitioner is the borrower. It is pertaining to subvention period, subvention clause, and EMA and pre-EMA component, the writ petition was filed before this honorable court. After the matter was heard, this honorable court had given interim relief for the petitioner, restraining respondent number 5 and 6 not to take coercive measures against the petitioner with regard to the home loan transaction. In accordance with the same, respondent number 10 also was directed not to take precipitative action against the petitioner with regard to the home loan transaction. So now they have filed an IA for seeking for the clarification and modification of the interim order. So that has been on a special order. This was posted before your lordship, and let it be taken up on next week, your lordship.
we have no role not in meeting experts, all not automated. But insofar as we have only sought for a clarification, that if the banks are not in question, not, once they put any information, I don't have control. Not it's rating is not limited only to this loan. If not, the petitioners have taken any loan from any other institution, not it is only one score. Therefore, if there is any change in the rating, not I should not have the country. You know, all that I have sought notice, let it be clarified, but response 5 and 6 for the banks. They should not make any change in the rating. I have no difficulty, not that's a dispute between the banks and not petitioners. I have no role in that. But if I am resisting, not I cannot, in fact, not this is an automated process, and there are other institutions involved. From whom you have taken even a vehicle loan on hire purchase, anything. If anything happens, the rating is automatic. It's an algorithm which is built in.
So I can simply say the directions issued will only pertain to the housing loan availed by the petitioner in from the contesting respondents.
Not only that, what they say, respondent 10 is directly not taking any precipitated action. The action they say not respondent 5 and 6, not because they are the ones who can change the rating by giving any information. I do not have any role at all in the process. That's the only way we are not clarifying the thing. The action not takes the order not of 26/9 and 2023. The last paragraph will not with the clarification that is got. Not I cannot take any precipitated action also, not as a matter of because I'm only a rating agency, so I cannot even change something on my own. That's what I am governed not by the Credit Information Companies Regulation Act 2005. As per that, there are certain statutory duties placed on me, which I have explained a lot in my application. I have to just not, I am considered like a post box with a software built in, not where if the bank puts any information on it, it gives some output. I cannot take any other action. Therefore, all that I am seeking is Proceedings is the last portion of the order. As requested by the learned counsel of the petitioner.
Respondent number 10 is also
directed not to take any action. But there is no way not I can take any.
But here, Your Lordship, my submission.
To say that 5 and 6 will not take any action regarding rating. Not in relation to this promoter, that would satisfy. But I'm sure even petitioner would not have any grievance because it is only 5 and 6 who can change not anything by their actions.
Your Lordship, here, my submission before this honorable court is that in paragraph number 7 of the
I have explained the statutory scheme also in my application and the methodology in which the rating is done. I have no control over the process, and it's not. In fact, even the bank when it updates, it is not that they will update me by some email or some this thing, and then I make some operation. There's an automated process, it's like a funnel, where at their end, if they do it, it automatically. Therefore, not say 5 and 6, not to take any action. So far as rating of this loan, that would satisfy not even the petition is done.
here in paragraph number 7 of the application, Your Lordship.
Sir, your interest will be protected.
No, Lordship, here what has happened, they specifically mentioned as per the CICRA rules, Your Lordship. They specifically mentioned as per section 1.
Further change will be made, except saying that respondents number 5 and 6 are directed not to tamper with any information that would in turn enable respondent number 10 to make any changes in the credit rating. That's all.
But if I may just
Here,
I should have clarified it, I have just for the Lordship's consideration, I have just made a.
IA1
Just this would clarify
IA1.
I should have spent out how I see clarification before that was absent.
Other same.
Yes, same.
Order on IA number 1 of 2023. This application is filed by respondent number 10, seeking certain clarification or modification of the order dated 26/9/2024.
23.
23. 26/9/2023. Full stop. Next para. Learned senior counsel, the Srinivas Raghavan, appearing on behalf of respondent number 10, which is a credit rating agency, submits
Under not the Credit Information Companies Regulation Act.
that
I do not do those.
the, Kudiyadunna, the tenth respondent functions under the Credit Information Companies bracket regulation close Act, 2005. And the information furnished by the banking agencies and non-banking financial agencies are only processed by the tenth respondent, and the credit rating is accordingly made. Full stop. However, in the order passed by this court, directions are issued to respondent number 10 not to take any precipitative action against the petitioner which would tamper with his credit rating. Full stop. On the other hand, direction should have been issued to respondents in 5 and 6 not to forward any such information to respondent number 10, which would
Affect the.
affect the credit rating
In relation to
at the hands of respondent number 10.
In relation to present loan subject.
Next para. Accepting the submission made with learned senior counsel, comma,
In context of the present loan transaction.
it is clarified that the order dated 26/9/2023 shall be read as directions issued to response number 5 and 6 not to provide such credit information that would adversely impact the credit score of the petitioner
In context of the home loan transaction.
in respect to the home loan
Home loan.
procured by the petitioner from respondents number 5 and 6.
And extension of entry model.
That is the order granted earlier stands extended till the next date of hearing.
Both the matters, one and one part, much of it.
Your Lordship would dispose of the IAM.
IA is accordingly disposed of.
Great, much of.
IO extension. Entry motor extension.
ಆಗಿದೆ ಸರ್.
66. ಅಲ್ಲ.
ಸರ್ ಯಾವ್ದು ರೀಚ್ ಆಗಿಲ್ಲ, ನಾಟ್ ನೆಸೆಸರಿ ಟು ಎಕ್ಸ್ಟೆಂಡ್ ದ
ಇನ್ ನಾಳೆ ಆಗುತ್ತಾ ಇದು 61 ಎಲ್ಲಾನು
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸರ್ ಎಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ವೀಕಾ?
ಸರ್ ಅಂದ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗುತ್ತಲ್ಲ?
ಸರ್ ಶ್ರೀನಿವಾಸ್ ರಾಘವನ್ ಸರ್ ಜೂನಿಯರ್ಸ್
ತಗೊಳ್ತಾರ ಅವರು 61 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಈಗ ಇವತ್ತು ರೀಚ್ ಆಗದಿರೋದು
ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಹೌದಾ?
ಸರ್ ಅಲ್ಲ ಆಟೋಮೆಟಿಕ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗುತ್ತಲ್ಲ?
ಸರ್ 63
ಎಲ್ಲ ಆಟೋಮೆಟಿಕ್ ನೋಡ್ಬಿಟ್ಟು ಸೀನಿಯರ್ ಡಿವೈಸ್ ಬರುತ್ತೆ.
ಅಲ್ಲಲ್ಲ
ಆರ್ಡರ್ಸ್ ಐ ಇದ್ರೆ
ಸರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ಗೆ
ಎಂಟ್ರಿ
ಎಂಟ್ರಿ ಮೋಟರ್
ಸರ್ 63 ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗುತ್ತಲ್ಲ?
60 ಡೇಟ್ ಕೊಡಕ್ ಬರಲ್ಲ ಸರ್. ಡೇಟ್
ಅದು ನಮ್ಗೇನಿಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ 20th
ಯಾವ್ದು ಕೊಡಕ್ ಬರಲ್ಲ ಸರ್.
ನಮ್ಗಿನ್ನೂ ಒಳ್ಳೇದು ಸರ್. ನಮ್ಗೇನು
ಅದು ಬರುತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಬರುತ್ತೆ. ಸೀನಿಯರ್ ಡಿವೈಸ್ ಬರುತ್ತೆ ಬಿ ಗ್ರೂಪ್ ಆದ್ರೆ. ಆರ್ಡರ್ಸ್ ಡೆಫಿನೆಟ್ ಆಗಿ ಬರುತ್ತೆ. ಎಲ್ಲಾರು ಹೇಳಿದ್ವಿ ಹಾಕೊಳ್ಳಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ. 15 ಅಲ್ಲ?
ಇವ್ರು ಬಿಟ್ಬಿಟ್ಟಾಗ್ಬಿಟ್ರು.
ಅಂದ್ರ
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಉತ್ರಳ್ಳಿ ಮೀನ್ ಹಿಡಿಯೋದು ಎಲ್ಲಿ ಮೇಡಮ್?
ವಿಶಾಲ್
ಆ ಮಸಾಲೆನೋ ಯಾವ್ದೋ ಬರುತ್ತಲ್ಲ. ಹಾ. ಅದೇ ಆ ಸಿಗ್ನಲ್ ಗಿನ್ನ ಸ್ವಲ್ಪ ಹಿಂದಕ್ಕೆ ಸರ್ಕಲ್ ಉತ್ರಳ್ಳಿ ಸರ್ಕಲ್. ಉತ್ರಳ್ಳಿ ಸರ್ಕಲ್ ಗಿನ್ನ ಸ್ವಲ್ಪ ಹಿಂದೆ.